Will come to order, and the clerk will please call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook,
Here.
Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, Representative Verdell.
Thank you, members. We have a quorum present. We'll go ahead and begin. We're hoping to vote out some of our bills, but we'll wait till we get a few more members present to do that. So we want to welcome everyone. We're glad you're here. We welcome everyone to testify that wishes to testify. If you do wish to testify, though, you're going to need to fill out a electronic witness affirmation statement, which or a form which are available on the kiosk located in the hallways behind the hearing room. And so if you haven't done that already, if you would. Also, if you want to register your support or opposition to a bill that's on the agenda today, if you will, you're certainly free to do that without testifying. There's not a requirement that you testify. I need to reflect that Mr. Money is present. So with that, there's one announcement that I need to make. Well, first of all, to the witnesses, we've imposed a 2-minute time limit on witness testimony. There will probably be some questions, or could be in addition to that. But if you can kind of try to limit your testimony, I will interrupt you at some point, and I'm not trying to be rude, but we've got a number of bills and a number of witnesses, and we need to keep the hearing moving to make sure we get all the witnesses on. Many of the witnesses have travel plans and need to do something else, so we would appreciate your cooperation on that. At this time, the chair needs to make an announcement of referrals to subcommittee, to our subcommittee on new offenses and change penalties. The following bills are being referred: House Bill 2461 by Representative Leach, House Bill 2590 by Representative Alcott, House Bill 2681 by Representative Dutton, House Bill 3165 by Representative Leach, House Bill 3189 by Representative Kerwin, House Bill 3231 by Representative Kerwin, House Bill 3565 by Representative Cook, House Bill 3653 by Representative LaHood, House Bill 3790 by Representative Morgan, House Bill 4816 by Representative Guillen, and House Bill 4911 by Representative Fairley. The chair will note that Vice Chair Wu is now present, as well as Representative Jones. Do we have any? And so we'll go ahead. Members, I announced a moment ago that if when we get some more members here, we have some things we need to vote on. So when we get a full committee, we can do the vote. So we'll go ahead and begin our testimony on bills. And so at this time, the chair would lay out House Bill 2777 and recognize Representative Rose. And I don't believe we have there's a substitute at this point. Is that right?
No, sir. Thank you, Mr. Chairman and members, for the opportunity to lay out House Bill 2777. So, members, today, individuals with severe mental illness can be sentenced to death. Current protections for defendants are not enough. They fail to protect the rights of individuals with severe mental illness at the time of the offense. The U.S. Supreme Court has ruled that our system's current protections for individuals facing capital punishment are fundamentally founded on the idea that individuals who fail to understand their actions or why they are being punished are not fit to be sentenced to death by our government. Yet protections that currently exist for individuals living with severe mental illness do not include an exemption from being sentenced to death. A prime example of the current system failing in the case of Andre Thomas. While in custody, Mr. Thomas gouged both of his eyes out and swallowed one of them. After Mr. Thomas gouged out his first eye, he was deemed incompetent to stand trial. but just 47 short days later, he was found competent. So the U.S. Court of Appeals for the Fifth Circuit held that Mr. Thomas, who continues to hear voices despite the heavy antipsychotics he takes, is competent to be executed, and the United States Supreme Court declined to review his case. So the jury that sentenced Mr. Thomas to death never heard about his mental illness. If HB 2777 is enacted, a defendant can request a jury to determine whether or not they have a severe mental illness at the time of the crime. So basically, members, HB 2777 creates a way for a court to assess on a case-by-case basis whether the defendant has a severe mental illness, and it places the burden on the defendant. So meaning a defendant must show by clear and convincing evidence that they had a severe mental illness at the time of the offense. The exemption created under this bill will only apply to those persons who have two diagnoses, schizophrenia and schizoaffective disorder. And the defendant must show proof that they had an active psychotic symptom at the time of the offense. So members, this bill holds individuals with severe mental illness accountable and does not allow them to walk away free, meaning they will receive life in prison without the possibility of parole. So they will be held accountable for their offense. And so also, members, let me just note that enacting the death penalty is always a long and expensive process. Things get even more expensive when severe mental illness is involved. An American Bar Association study found that a similar bill in Tennessee would have saved taxpayers $1.4 to $1.9 million a year. Given that Texas' death row population is 4 times larger than Tennessee, Texas will presumably see even higher savings if this bill is passed. So members, states such as Ohio and Kentucky have also enacted exemptions for people, exemptions from the death penalty for those persons with severe mental illness. And so I really do feel it's past time that Texas do the same. And I'm going to say this too. This is my 4th legislative session carrying this bill, and we get it out of the House every time. And I have had conversations with the Lieutenant Governor, and so I'm very excited and feel real positive about us finally getting it over the finish line this session. So with that, Mr. Chairman, I will be happy to answer any question. I reserve the right to close.
Okay. Any question, members? One question I've got on the schizoaffective disorder. Is there a definition in the? I don't find a definition in the bill for that. Do you know if there's a definition that's used for what would constitute that disorder?
That would constitute a schizo. Usually, a schizo defect is like schizophrenia and bipolar.
Yeah.
It's a combination of those.
Okay.
But I will let an expert come up and say that, but I do know that that's basically what it is. A person who usually has schizoaffective, who has schizophrenia
And what
bipolar.
I'm wondering is whether there are levels of the disorder. In other words, some are more severe than others. And I really don't know the answer to that, but we'll ask.
We'll have the answer before
Okay.
we leave out of here today.
Okay, all right. Any other questions?
I'm
members?
not the expert. I just don't want to
Ms.
say, but I
Bowers?
do know that
I
most
need to
people-
reflect that Ms. Bowers is present. Okay. And so we have, I'll go ahead and call witnesses, and we'll
Okay.
give you the right to close. So
Thank you.
we have Christine Bussey. Bussey? Thank you. And for you, and is Ms. Bussey or Bussey?
Yes, sir.
Okay, for you and the other witnesses, if you would, we really need you to do this, if you'll remember, to state your name, and then you've registered either as appearing on behalf of an organization or individual or yourself. If you will repeat what you signed on the register and then tell us whether you're for or against the bill. So if you'll remember to do that, thank you very much.
Sure thing. Thank you. Good morning, Chair Smithy and all committee members. My name is Christine Bussey. I serve as the Peer Policy Fellow of NAMI, Texas, the state affiliate of the National Alliance on Mental Illness. Thank you for the opportunity to testify in support of House Bill 2777. In Texas, nearly 4.8 million adults have a mental health condition, with over 1.1 million experiencing conditions classified as serious. This bill addresses a narrow subset of those individuals, specifically people with schizophrenia or schizoaffective disorder, whose active psychotic symptoms substantially impaired their capacity to understand reality at the time of their crime. While NAMI Texas has long supported policies that divert people with severe mental illness from incarceration and into treatment, we also support both accountability and justice for victims and their families. What we cannot support is a capital punishment system that disregards the fundamental nature of these psychotic disorders. Psychosis refers to a loss of contact with reality through hallucinations or delusions. Executing someone for a crime committed during active psychosis contradicts modern neuroscience and basic moral principles. It fails to acknowledge that severe mental illness can profoundly impair a person's ability to understand reality, let alone form criminal intent. Taking capital punishment off the table for these individuals also promotes efficient use of public resources. As mentioned earlier, the legal process in these cases is long, costly, and burdensome, which leaves victims' families in limbo for years awaiting resolution. A prior version of this bill passed the House last session with broad bipartisan support. House Bill 2777 offers Texas a responsible path forward with accountability through life without parole while recognizing the realities of these disorders. It brings finality for victims' families and is supported by a broad coalition of stakeholders in the mental health, disability, and faith communities. I urge your support for House Bill 2777, and I thank you for your time.
Thank you, Ms. Busk. Any questions, members? Okay. Thank you very much for being here.
Thank you.
We have Shannon Jaquette.
My name is Shannon Jaquette, and I am the Policy and Education Analyst at the Texas Catholic Conference of Bishops, testifying in support of HB 2777. The bishops support criminal justice reform that provides for fair and compassionate treatment of the accused and incarcerated, responds to the needs of victims and victims' families, and promotes rehabilitation and the successful reintegration of the formerly incarcerated into society. We oppose the imposition of the death penalty, and the bishops ask for clemency for every person on death row. We advocate for the abolition of the death penalty, but until that day comes in Texas, we support reforms that seek to limit its application, such as Representative Rose's bill, which prohibits the sentence of death for a defendant who, at the time of the commission of the offense, had a severe mental illness. Research in psychology and neuroscience provides evidence that individuals who suffer from mental illness may not be able to exercise rational judgment or understand the nature, consequences, or wrongfulness of their conduct. A defendant's schizophrenia or schizoaffective disorder at the time of their offense should be considered a mitigating factor to such an extent that a death sentence is not warranted. Moreover, people suffering from these conditions are limited in their ability to assist in their own defense, which may result in violations of due process and place them at greater risk of receiving a death sentence. The execution of the severely mentally ill does not serve justice or the common good. Non-lethal means are sufficient to defend and protect society, and Texas ought to limit itself to such means. We appreciate Representative Rose for continuing to file this legislation and ask you to support HB 2777.
Thank you very much, Ms. Jaquette.
Yes, correct.
Okay, any questions, members? Thanks for being here. We have Benjamin Wolf is here with the Office of Capital and Forensic Writs, and you've testified neutrally on the bill.
Yes.
Okay.
Good afternoon, Chair, Committee. Thank you for having me. My name is Benjamin Wolf. I'm testifying on the bill. If I could start first, Chair, by answering your question.
There you go.
So there aren't different levels of schizophrenia and schizoaffective disorder. These are severe mental illnesses that are clearly defined in the DSM, the Diagnostic and Statistical Manual published by the American
That's why I was wondering if there was a DSM definition. I assume there was.
There is, and so while there aren't different levels, there's symptoms sometimes wax and wane. But the point that I'd like to make about this bill as a resource is that this bill is narrowly tailored towards not just any. There's other what might be fairly characterized as severe mental illnesses or mental illnesses that severely impact different people. These are what are recognized as the two most among the two most serious, and it is limited to schizophrenia and schizoaffective disorder, and those that are actively experience psychotic episodes. So it's not that when symptoms are waxing and waning, but it's people who are in the full throes of schizophrenia. Secondly, I'd like to point out that in terms of this bill, again, it is quite narrow, applying to only 2 diagnoses and persons suffering from active psychotic symptoms, and divert those individuals to sentences of life in prison without the possibility of parole. The criminal legal system, the criminal justice system in Texas, hasn't always done that well in the absence of this bill. We intervened in a case recently, the case of Syed Rabbani, who was severely schizophrenic, spent 35 years on death row before his resentence. There's another person who Randall Mace, spent 16 years on death row and 3 prior execution dates before the Attorney General of the state of Texas, and the court system agreed he didn't belong there. He had a diagnosis of schizophrenia in addition to intellectual disability. Another individual, Larry Haddon, was sentenced to death in 1996, and when he was sentenced to death, he was in the throes of an active psychotic episode of involving schizophrenia, and he was sentenced to death strapped to what everyone called in the courtroom as a Hannibal Lecter chair.
Okay, let me see if there's any questions. Members, any questions for Mr. Wolf? Yes, Mr. Little.
Thank you, Chairman. Mr. Wolf, I'm trying to understand how this bill changes the current regime that we have regarding evaluating a defendant's competency. So my understanding is that if someone is incapable of appraising the nature and consequences of their conduct when they commit an offense, then they're already deemed incompetent for purposes of that prosecution. Am I wrong about that?
So it's these are kind of overlapping concepts, but it's a little bit different. So there are interplays between insanity and incompetence and what this bill would do. What competency, the inquiry about competency really focuses on them understanding the proceedings against them and their ability to interact with their lawyers. The insanity the question about insanity deals with whether someone can appreciate right from wrong, right? And what this bill does is identify those individuals who are actively psychotic and who have one of the 2 most serious diagnoses in the DSM, and it might be someone who, because of active hallucinations, active delusions, think that that there's a conspiracy, and I'm making all of this up, and that because of they're in that or they're hearing voices that are telling them to do something, and because of that severe mental illness, because of those active psychotic symptoms, those people would be diverted to a sentence of life in prison without the possibility of parole. But so sometimes there's overlap, but there's not 100% overlap. So sometimes someone can be competent to stand trial, yet they were in the throes of active psychosis and schizophrenic at the time they committed their offense.
Thank you for your answer. I'm having trouble understanding the overlay of these specific disorders with the current state of the law. So let me try to ask a more specific question. If you have schizophrenia or a schizoaffective disorder, and you have some form of active psychotic symptoms, you're essentially exempted from capital punishment under this bill, right?
So long as you convince a jury and you have the burden of proof and you present and you have the burden of proving the defense has the burden of proof by clear and convincing evidence that those factors, then you would be and you're found guilty, you would be sentenced to life in prison without parole.
Okay, I think I understand your answer. So here's my question, and you'll have to excuse my ignorance, and I'm not a mental health professional, and fortunately I don't have anybody in my family who suffers from either of these conditions, but it seems to me that there are times when someone is actively in a psychotic episode
Right.
and then not in a psychotic episode. And so the possession of this disorder
Right.
is the question of whether you're exempt from the death penalty is independent from the question of whether the person who has this disorder is capable of knowing the nature and consequences of their action when they committed the offense, isn't it?
So, so the people who have, let's just say schizophrenia, have, good days and bad days. For them to be exempt from,
Can I press pause there?
Sure.
So, in a good day, you're not in an active psychotic disorder. So let's say that on a good day, you commit a murder. But on a bad day, you don't commit a murder. Regardless of whether you're in an active psychotic episode, if you have the disorder, this statute takes you out of the capital murder regime altogether, right?
No, I don't believe so. The Representative Little, so you'd have to prove that not only that you have this disorder, but you were actively psychotic. And so at the time that you committed the offense, and so it's not that, it wouldn't exempt folks from the death penalty who have a diagnosis of schizophrenia but aren't in a period of active psychosis at the time they commit a homicide.
I'm sorry, Mr. Wolf, I don't read it that way. And here's what I mean. So when I look at 46D001, it's saying a person with severe mental illness is someone who has active psychotic symptoms that substantially impair the person's capacity. But unless I'm missing something, I'm not seeing that that person has to be in a psychotic episode at the time the alleged offense was committed, unless I'm mistaken.
So I interpret active so I have clients who have schizophrenia diagnosis who aren't always actively psychotic.
Oh, Mr.
And
Wolf,
so-
could you speak a little more into the mic?
I apologize. So there are people who can have schizophrenia diagnoses who who aren't always actively psychotic, and so you'd have to prove that not only that the diagnosis, one of the two qualifying diagnoses exists, but that as a result of that diagnosis, that at the time you committed the offense, that you're actively psychotic or having active psychotic symptoms. That's how I read the proposed bill.
Okay, and I'm going to push back on that a little bit. So in 46D004, it says evidence, then this is dealing with the question of evidence that a defendant was a person with severe mental illness at the time of the commission of the alleged offense is not admissible, et cetera, et cetera. I don't, unless I'm making a mistake, I don't see something, okay. Gene, I'm sure you've got something you want to say. So, but I've got a couple more questions here. So,
46.
Oh, good. Is it?
I thought did you?
I see 46D005, determination of the issue by the jury. It says the defendant must prove by clear and convincing evidence that the defendant was a person with a severe mental illness at the time of the commission of the alleged offense. So it has to be a person who falls within that definition. And the definition calls for someone who has active psychotic symptoms.
Right.
But the gap that I'm seeing when I read it is there's nothing in the statute that requires that person to be in an active psychotic episode at the time the offense is committed. And if I'm misreading it, I hope you'll point it out for me.
Okay, Mr. Moody, is that okay?
Please,
Mind if-
yes, please,
If
Chair.
you, it's, the first page, line 8 through 12 talks about what does person with severe mental illness mean, and then it says that psychotic symptoms substantially impair the person's capacity to, one, or two, that the person either cannot appreciate the nature, consequence, or wrongfulness of the person's conduct, or two, exercise rational judgment. I think that they're in a psychotic state and they're not able to do these things, which is pretty much the definition. This is the definition of insanity in the code.
Yeah, I don't see the when involved in this code, but I'm willing to misunderstand.
It's, there was, go ahead.
Ms. Jones?
Maybe this answers your question. Rep. Little, if you go to page 2, line 19 through 21, it says the defendant must prove by clear and convincing evidence that the defendant was a person with severe mental illness at the time of the commission of the alleged offense. Is that?
That's what
maybe-
I read from Mr. Wolf, and
Why, I guess my question is, why does that not tell you that it's at the time of the alleged offense?
so the definition of that person is someone who has, if we go back to the definition on the first page, this is someone who has active psychotic symptoms. But between the definition and the provision that you just read, Representative Jones, it's not clear to me that the person is required to be in an active psychotic episode when the offense is alleged to have been committed. It's generally, does this person have active symptoms?
No, this says the defendant must prove by clear and convincing evidence that the defendant was a person with severe mental illness at the time of the commission of the alleged offense. So I'm confused.
And the question I was posing for Mr. Wolf, and maybe there's another witness who can address this, is I understand that someone can have active psychotic symptoms without always being in that state of psychosis. And so you could have this person who is susceptible to these symptoms but not be in an active psychotic episode when the offense
It seems
is
to me like that could be easily remedied with some language.
I think it could,
address what
but
you're-
I'm trying to figure out whether it needs to be or if I'm the only one who reads it this way. Sorry.
Are you finished? Did you? have
Yes, I'm
anything else?
sorry. Thank you,
Okay,
Mr.
I think
Wolf.
Mr. Moody, Mr. Moody had a.
Thank you, Mr.
I think I do have questions. I think it ties into the conduct, when you mentioned conduct in the definition. I think the way they're trying to get at it, because I understand what you're saying. You have a defined term up here, and then certainly the defined term ties it to the time of the offense, but does the defined term actually combine those with the conduct of the case? I think the use of the word conduct in the definition is what ties it to the actual conduct in the case. That would be my argument, but I do see why you could clarify. I think it could be clarified more. Just to give kind of lay of the land, right? Because we're talking about there's competency to stand trial.
Right.
There's not guilty by reason of insanity.
Right.
It's another lane that exists in the law today. So if I'm playing devil's advocate, and you're going to this isn't in law, other avenues to try and raise this, and this is why I think kind of brings into question why we need this, but the competency piece you already talked about, that's talking about being able to participate in the trial. Not guilty by reason of insanity is a different standard that is not this standard, where someone could have all those voices and do all that stuff that you just described, but because they still know it's wrong to kill someone, that doesn't count.
Right.
Right? So all of those things that you would think of as in a layman's term, you think not guilty by reason of insanity, like that would be the ideal, that would be the perfect situation to illustrate that, but it isn't how it works in case law, right?
Right.
And so then you have special questions. Why is, and this is more devil's advocate question, why is it not sufficient for this population to be able to submit, be able to proffer evidence during the punishment phase on special questions to mitigate, isn't this mitigating evidence that the jury could take into consideration at the punishment phase, and they could answer, they could say there are mitigating circumstances in this case, and it would default over to life in prison without possibility of parole. That's where this lives now, essentially, right? Why you're not here supporting the bill, so I need to make sure that I'm not trying to put you in that position. In your experience, would these situations, would these particular situations have a remedy in the current mitigating evidence special question?
Well, I think that the experiences that I've had and the cases that I've seen reflect the gaps that this bill perhaps is intended to cover. There's situations where had a client who was sentenced to death strapped to the Hannibal Lecter chair in 1996, and then there was we got appointed 7 years ago, and then in 2020 everyone agreed that he was incompetent to be executed, but in the meantime spent 24 years on death row and had prior execution dates, right? And so the criminal justice system isn't sometimes isn't as sensitive to picking up on these issues under the current.
Yeah, and I didn't even get to that part of it. You got to then be competent to be executed.
Right.
Right. So that's a whole nother. Then
Right.
you're going to deal with it then. So I think I just in terms of procedure, this goes the way this bill is built. This is a pretrial determination, correct?
It's a
Or not pretrial.
It's
sorry.
a trial
it's a
level.
special.
It's an issue that is determined at the time of guilt, and so what that does, even so, if taking your hypothetical, what you're saving is the cost and expense of all of which might be hundreds of thousands of dollars in a capital case of the punishment phase of a death penalty trial.
Yeah, I'm sorry, I misspoke. But it takes place at a point where you can essentially cleave off the back half of that.
Right.
Still accountability. It's very different from someone raising NGRI. It's very different from competency at execution or competency prior to. So it is that's kind of the gap that's being filled here.
Yes.
Okay. All right. Thank you so much.
I need to recognize that Ms. Rodriguez-Ramos has joined us. We welcome you. And so any other questions, members? If not, we appreciate you being
Thank
here,
you.
Mr. Wolf. Our next witness is Dr. Kimberly Harrison.
Good afternoon. My name is Dr. Kimberly Harrison. I'm here on my own behalf, testifying in support of the bill. Thank you, Chairman Smithy and members of the Criminal Jurisprudence Committee. I'm a clinical psychologist and board certified in forensic psychology by the American Board of Professional Psychology. I operate a private practice based in Austin that involves conducting psychological evaluations of individuals involved in criminal court proceedings, including their mental state at the time of the offense. As has been discussed, schizophrenia and schizoaffective disorder are severe mental illnesses that, if untreated, impair individuals across all domains of life. People with these severe brain diseases are impacted in their abilities to think clearly and logically, to accurately perceive reality, to behave in an organized manner, to communicate effectively, to engage in reciprocal social relationships, and to understand the effects of their illnesses on all these different areas of functioning. I believe that there are many reasons individuals with schizophrenia or schizoaffective disorder at the time of the offense should be exempt from the death penalty. Number one, the fact that their impairments in reality perception, thinking, reasoning, and judgment affect their behavior and culpability. The need for parity with other classes of death penalty exempt individuals, such as juveniles and people with intellectual disabilities. The financial costs of mental health evaluations and court hearings to determine if a mentally ill inmate is competent to be executed. and the seemingly endless wrangling that leaves everyone involved, including victims' families, waiting for decades for the execution to be carried out. Qualified forensic psychologists are able to conduct valid and reliable evaluations of defendants' mental state at the time of the offense. We have well-validated tests and procedures to determine the validity of reported symptoms and to detect faking or exaggerating of mental health symptoms.
Well, let me ask you, thank you. Let me ask you this question. How specifically is schizophrenia diagnosed?
How is it diagnosed?
Generally, yes.
So generally, a clinical interview with the individual, behavioral observations, looking at their history. A lot of times, the person may have been hospitalized on an emergency basis because of their symptoms. Psychological testing is sometimes necessary, reports from family, friends, people who have observed their behavior. So all of that is taken into account when diagnosing.
So is it still possible, though, to basically fake a diagnosis if someone is intent on doing that?
Well, we have specialized, valid techniques for assessing if someone is faking. I mean, is it possible someone can fake? Yes. But again, if you're looking at all of this information together and with specialized methods, you can usually ferret that out.
Now, to address Mr. Little's question that he had a moment ago, and he may want to follow up on this, but assuming you've got a general diagnosis of schizophrenia or that disorder, how do you go about proving or determining that disorder was a specific a factor in the commission of the crime that the defendant's on trial for?
Again, it would be looking at numerous data points, so police reports, victim reports, crime scene evidence. The evaluations would be done in much the same way that we already conduct evaluations if someone is pleading not guilty by reason of insanity, because again, the issue is the same. Was this person experiencing symptoms of mental illness at the time that the crime was committed? It's just with an insanity evaluation, we're looking to determine if those symptoms prevented the person from understanding right and wrong at the time.
Okay. Any other questions, members? Yes, Mr. Wu.
Quick, just, because I've done this before. When you do evaluations of defendants for mental illness, usually for schizophrenia and other illnesses, there is a set, like, nationally recognized regime of this is how you conduct this investigation, right? There's like a checklist of like you're supposed to go through, and these are the way you're supposed to evaluate, correct?
Well, there are diagnostic criteria
Right.
that a person has to meet in order to have the diagnosis.
Right, and these are not like, you're not just like when somebody does a diagnosis of schizophrenia, it's not like, well, I think there is, but they actually go through, when they do the reports, it's like a very long report, and they have checklists, like this type of test, they can't have this score, this different type of test, they had this score, right? And you take a look at each one of those individually, correct?
Correct.
Right, and in fact, I don't know if this is usual practice, but when I do these cases, they actually have a part of the test that is to see if somebody's faking it. That is, they give an assessment of whether or not this person is trying to feed them answers or actually answering honestly.
Right. If there are any suspicions that the term we use is malingering, then yes, we have specific tests that we can use for that.
So, like, when somebody's trying to fool the doctor, a lot of times the doctors will note that in their file. Yeah, they're trying to pull one over.
Right. And especially in a forensic evaluation, because that is always a concern, right? If someone thinks that they're going to avoid punishment, so we're always on the lookout for that.
And these are like long and lengthy tests, are like interviews and tests and other things. It's not just like 2 hours and we're done.
Yeah, I mean, it depends on what the referral question is. So if you were assessing this issue, if this bill were to become law, then yes, it would be a long evaluation and looking at large amounts of information.
Okay, thank you.
Is there a particular part of the brain that where schizophrenia is usually kind of rooted?
Well, for decades, it's been thought to primarily be due to neurotransmitters. So the chemical messengers in the brain misfiring. So for a long time, it's been dopamine is what is targeted by antipsychotic medications. The belief that people with schizophrenia have too much dopamine in their brains, and so these medications reduce that level, and a lot of people reduce the symptoms.
Any other questions, members? Mr. Cook has a question.
I think just a few minutes ago you said that you would be looking at a lot of different information if you were trying to make the determination as to whether or not there was active psychosis. I don't think that, I guess this is more of a question. Is that what you meant? Like in order to, like in the first page of the bill, it says, in this chapter, person with severe mental illness means a person who has schizophrenia or a schizoaffective disorder, and as a result of that disorder has active psychosis symptoms that substantially impair the person's capacity to appreciate the nature. So understand, like if you're testing for, you know, I guess it's more objective if you're taking like is it a fill in the blank, or not fill in the blank, but fill in the bubble type test that you're using to make the diagnosis?
No, I'm just using the criteria that are listed in the Diagnostic and Statistical Manual.
Okay. So, but is it, if you have the disorder, is it, when I hear active, because each person that spoke before you, I think, probably emphasized active psychosis at the time of the commission of the offense.
Right.
And so I guess that's my question, is how, so you go in and out of that, correct? I mean, I guess that's kind of what we hear loosely, not in the professional environment, but you can have active psychosis or you can not.
Right. Generally, with these disorders, it would be rare for someone who is not taking medication to have days when they're just completely "quote unquote" normal. Right. Their symptoms are never really going to go away completely unless they're taking medication. So, yes, the symptoms do sort of ebb and flow, more severe days, but it would be unlikely if someone really had schizophrenia or schizoaffective disorder that they would have days or weeks at a time when they're completely clear.
Would you agree that if you were, having a face-to-face interaction with the person, it's going to be easier for you to make the diagnosis? I mean, if you're able to observe the person.
Right, yes.
Okay. And so that would be in real time. So if let's say you got brought in a year, murder happens, a year and a half later, you're brought in as an expert to make this determination. So you would be able to interview the defendant at that time and make judgment of what his current capacity is, correct? You would be able to
Right.
make that determination.
Yes.
And would you agree with me that determination or those decisions that you're able to make then are going to be more reliable than you speculating what took place a year and a half ago?
Again, that's why records and documents are so important in these types of cases, because again, if someone does have one of these severe mental diseases, chances are very high that they've come in contact with the police before, they've come in contact with the mental health system, they've been hospitalized, and so we're going to have those records back in time.
But those are evidence of the disorder, correct? Not whether or not the person was active on the day of the commission of the offense. That's where I have a tough time making the determination. Is I think it's much easier for you to have an interaction. A year and a half later, if you were deciding whether or not the defendant was competent, to stand trial, that's probably a much easier, more reliable test or observation, examination, than you speculating what state of mind a person was in 18 months earlier. Is that fair?
Well, when you have this diagnosis and you're able to see the person's pattern and okay, if they're not taking their medications, they're going to start having these delusional beliefs, and it's the same delusional beliefs every time they get off their medications, or it's the same disorganized
but if
behavior.
A person is, if they're being tried for murder, are they going to probably tell you they were not on their medication in June of 2022 when the murder? Because all those factors are things that you're going to be relying on someone, like you said, a police report, doctor's reports, things like that. That's all you're having to make the determination, correct, on information that was made at the time. Is that
Right. Right.
Thank you.
Any other questions? Ms. Jones had asked.
Thank you, Doctor. In my day job, I'm a criminal defense lawyer, and my clients with schizophrenia and schizoaffective disorder are different. would you agree with me that, well, at least in my practice, most of my clients who have mental illness, especially schizophrenia or schizoaffective disorder, they actually don't like taking meds because they don't feel normal. So like their normal is chaos, and they actually could live law-abiding, productive lives if they took their meds. But so most of them don't. Is that accurate?
That's one of the major issues with these mental illnesses. And to be fair, a lot of the medications do have pretty negative side effects. And a big characteristic of these disorders is people lack insight into their mental health. And so they don't realize how disorganized their behavior is when they're not taking their medication. And so they think they feel better.
May I go into this? So they're sort of used to the chaos. And if they're taking their meds, right? Let's say they've got family support and their family's getting them to take their meds, and then they're doing well. Have you seen where once they're doing well, they think, I don't need these meds. I'm doing well.
Yes.
And so then they stop taking their meds.
Yes.
A lot of times I have clients who don't have health insurance, so they actually don't have access to meds. Do you see that a lot?
Yes.
Also, when you're trying to figure out whether they were insane at the time of the commission of the crime, if they are, let's presume they're having a good day, right, on the day that you interview them, and they tell you whatever happened on the day of the commission of the crime, don't you go back, at least based on my experience, to, I don't know, family members that maybe were around them during that time and ask them, hey, how are they acting? If the police were called, you go back and you look at police reports and you say, I mean, were they doing anything schizophrenic
Right.
at the time they were arrested? So there are ways to figure it out.
Yes.
So the fact that they may be having a good day today when they're speaking with you does not necessarily make it easy for them to trick you into what happened on the other day, because you have verifiable ways to either confirm what they say happened or not to confirm it.
Correct.
Is that accurate?
Yes.
And even I can tell malingering. I mean, there are people think they can fake crazy, but it's hard to maintain faking crazy.
It is hard to maintain.
It's really hard to maintain faking crazy.
Yes.
And again, including with somebody who's not an expert, like with training like you. So and you're board certified.
Yes.
So I would imagine you had to pass some tests.
There were a lot of tests.
To be board certified.
Yes, ma'am.
Right. And just based on your experience, there are credible, scientific, peer-reviewed ways to accurately determine whether someone was competent or insane at the time of the commission of the crime.
Correct.
Thank you. I feel like saying I passed the witness.
Mr. Money? Yeah.
Hello. The witness thing here says that you're a forensic psychologist. Is that correct?
Yes.
And is that an MD or a PhD?
PhD.
Okay. Are you the kind of person who would be able to qualify as an expert witness in these types of cases?
Yes.
Have you testified in cases like this before?
Yes.
Are you personally in favor of the death penalty in any cases?
Am I in favor of the death penalty in any cases? I am not.
Okay. So you're opposed to the death penalty, but you are a person who would testify whether or not someone would be eligible for the death penalty.
Well, since this isn't a law yet, I haven't come across this in my practice. I do not do competency to be executed evaluations. That's just not something I do in my practice.
But if this law were to pass, then you could be called by a defense attorney or prosecutor, supposed to examine the defendant and make a determination in that regard. Correct?
I could be asked to take the case. That doesn't mean I would take the case.
Sure. Is it true that a lot of murderers and especially serial killers have what would be qualified here as a severe mental illness?
No.
Just looking at some of the reports here, Jeffrey Dahmer has been diagnosed by a doctor at the American Academy of Psychiatry and the Law as having Asperger's and a schizoid personality disorder. Would that surprise you?
I don't know anything about the case.
David Berkowitz, who was better known as the son of Sam, the serial killer in the 1970s, was diagnosed with paranoid schizophrenia. So if that happened in Texas after this law was passed, we would not be able to execute him, correct?
Well, he was later found to be malingering.
Okay. And so, but that's an extra determination that would have to be made. Jared Lee Loeffner, who killed 6 people and wounded 13 others, including Gabby Giffords, the U.S. congressman, was diagnosed with paranoid schizophrenia. So if that were to have happened in Texas after this bill is passed, then we would not be able to execute him, correct?
If that was, I wasn't involved in that case. I can't say what his diagnosis was.
Okay. And James Holmes, who was part of the Batman murders in Aurora, Colorado, has been diagnosed with schizophrenia by 20 different doctors. So if that were to have happened in Texas after this law was passed, that guy who got geared up and went into a movie theater and just indiscriminately killed a bunch of people could be diagnosed by doctors like yourself or the 20 people who diagnosed him with schizophrenia, and then would be ineligible for the death penalty. Is that correct?
If he was having active symptoms at the time, which again, I wasn't a part of that case. I didn't evaluate him. I don't know if, he could have been on medications and did the killing for reasons that had nothing to do with his mental illness. I don't know that case. But in that scenario, if he wasn't having active symptoms at the time, then my understanding is under this bill, he could still be eligible for the death penalty.
Yeah. I think in each and every one of those cases, the vast majority of the people of Texas would not want the prosecution to have to go through enormous other legal hoops in those cases. At least I believe that's the way that the people of House District 2 would look at this. And so I thank you for your testimony.
Okay, Ms. Jones has a question, another question.
You said that you evaluate whether people are insane at the time of a commission of an offense.
Yes.
Is that accurate? For everyone who you've evaluated to be, whether they were insane at the time of the commission of the offense, have you found that every one of them has been insane at the time of the commission of the offense?
I have found that very, very few of them were insane at the time.
Thank you.
Any other questions? We sure appreciate you being here. Mr. Riddell has a question.
Is it safe to say that sane people don't commit murders?
Are you speaking about the legal definition of sanity?
No, just to say it, the same person wouldn't commit a murder.
I don't know what definition of sane you're using.
Okay, all right, that's all I have. Thank you,
All right.
appreciate it.
Okay, thank you very much for being here. We appreciate it. Is there anyone else here to testify for, against, or on House Bill 2777?
I registered. I might have forgotten to put I was testifying. Cindy Castilla, Texas Eagle Forum.
Okay.
Do you have me?
Come on up, and I'll tell you what, I'm going to get you to identify yourself, and then go ahead, and then I'll ask you a question, okay?
Okay. Cindy Castilla. I'm president of Texas Eagle Forum, speaking in opposition to 2777.
Okay, now, do we have permission, does the clerk have permission to change your affirmation?
Yes, sir.
To indicate that you wish to testify and are testifying?
Thank you, Chair.
Okay, thank you. Go ahead.
Okay. Carving out exemptions for guilty persons to escape a conviction with the death penalty is innately unfair. A jury or judge must have the right to determine the penalty when options are available based on the facts of the crime. Trial by jury was considered critical to our founders, and we need to honor that. I have, and allowing their choices. I have a relative who, after too strong of a batch of marijuana, became psychotic and eventually was additionally diagnosed as bipolar and schizophrenic. He has a harder life than before his incident. He hates his medicines, but he takes them because they protect his family from an episode he may have without taking them. He no longer touches any psychoactive drug, as they are the thing that most easily sets off his psychosis. He also stays away from other possible triggers. Exempting a person with mental illness from due punishment as determined by a jury is instinctively unfair. We all make choices. The mentally ill still make choices. If they make choices that create life and death danger to society, the duty of prosecution is to protect society. We have seen parole given to very dangerous individuals after they have served time based on a mental health diagnosis. If it takes a death penalty option to help the severely mentally ill make better choices, then we need to keep that option in our law to protect innocent victims of their further choices and behaviors. We hope you will support leaving the death penalty option available to juries. They don't have to use it, but it should be available for appropriate crimes, no matter who commits them. Thank you.
Thank you very much, Ms. Casilla. We appreciate you being here. Any questions? Thank you.
Okay, thank you.
Okay, now anyone else here wishing to testify for, against, or on House Bill 2777? If not, Representative Rose, do you wish to close?
Thank you, Mr. Chairman. I really appreciate all of the questions and all of the dialogue on this bill. I would like to also thank Mr. Little for his questions. Everyone who gave input, but I think some of my colleagues have the wrong idea of what this bill does. And even the last witness, I think she just stated that a jury should be able to decide. Well, that's what we're asking a jury to do. This is just on the front end of determining if a person has a severe mental illness or not. This bill is not to try to get everyone who has mental illness off. And one of the things, since I've been here, we have made some great strides as it relates to mental health in this state. Texas, even though we still rank one of the lowest as it relates to mental health, we have really vested a lot into assisting those persons with mental illness. This bill does not allow a person to go free for their crime. Only thing this bill does, it just does not allow a person to be sentenced to death if a person is mentally ill. We have for so long in this state executed persons who have had a severe mental illness at the time of their crime. It is not fair to sentence or to put a person to death when they are not culpable with their situation. And so, again, this is on a case-by-case basis. This is not every person that comes into jail with a mental illness that everybody's going to go through this process, because the proof is up on the defendant. The defendant they have to prove that at the time of the crime that they were psychotic or they had a history of schizophrenia or schizoaffective disorder. And I apologize for trying to get that definition earlier. So I'm so glad that our witness came forth with that, even though I was on point, but not as on point as she was as it relates to the definition. But I am not trying to just let everybody go free. My family has been a victim of crimes before. But when you're talking about a person with mental illness or a person with schizoaffective or schizophrenia, if you're not able to understand, or why in the middle of a time, if you're so psychotic and you don't understand why or understand that what even happened when you committed a crime. And I'm going to go back as far as to say this. This bill came out of my life's work. Most of you know that I spent majority of my career in correctional mental health. And I was a liaison between the courts and the psychiatry department. I worked in the psychiatry department at the Dallas County Jail, and I've seen inmates come in psychotic. And after committing their crime, not even knowing what they have done. And when they find out, once we were able to get them in, get them treated, and to find out what they've done, and I've seen the devastation that it has caused upon their lives. So I'm not sitting here telling you about no stats. I'm telling you about what I have witnessed in my career. And there are people in this state that have been on death row and are currently on death row who really should not be on death row. Now, I'm not saying that they're not dangerous because they have committed a crime. But why put a person to death? If you're going to be pro-life from the womb to the tomb. And with that, Mr. Chairman, I close.
Okay, Ms. Rose, let me see if there's any questions. Any questions?
I'm
Ms.
gladly
Jones has
answer
a
any.
question. Okay,
Be pro-life from the womb to the tomb.
okay. Ms. Jones has a question.
I don't really have a question, Rep. Rose. What I will say is this: I appreciate you bringing the bill because I see it in my practice, and so I was confused when I heard that the jury couldn't determine whether to put you to death when they actually could. It was it's just a question that goes to them back in the jury room, and they decide. And I also don't think, at least for me, like it's a function of like whether you believe in the death penalty or not. The question is, you know, I was having a conversation with my colleague here, and made me sort of think. So, like for me, mental illness is real. I think I've shared with people. My dad committed suicide. Clearly, there was some mental illness there. So I know sometimes people know not what they do when they're doing it. And I believe had my dad not been under mental illness, and if he would have just thought about me, he wouldn't have done what he did. And so I think that when people make decisions, regardless of what even if they're really bad, that you don't put them to death, you can put them in jail forever, right? Because I too have been a victim of crime, and very many of my family have been victims of crime. I'm not gonna tell you how many of my cousins were murdered, and my brother was murdered, and my aunt was murdered. And in fact, the guy that they say killed my brother got 10 years probation. And that's another story for another day. But I just think that some people, if they don't have the mind that like a sane person has, then maybe we just take death off the table and you can still put them in prison for life, because I'm not trying to endanger society. I just think that that's a humane society. And so thank you for bringing the bill, and I'm proudly going to vote for it.
And Mr. Wu.
I won't ask you through. I'm just lay it out. And I've dealt with clients with severe schizophrenia charged with very serious crimes. Like one client, they literally would not let me see him at the hospital for 2 weeks because he said he was too psychotic. He has no idea where he is. That client asked me for months, why am I in jail? And despite them repeatedly telling them it was for murder, he had no idea what he had done or why he was there, or often where he was. I think the last witness basically said, like, look, people made their decisions. I think the point of this legislation, the point of especially directing this to people with severe schizophrenic psychosis, is that they're not making decisions. Because when you're fully psychotic, when you have like severe schizophrenia, you don't know what reality is. Like your reality in your mind changes from second to second, minute by minute. I've dealt with clients with schizophrenia that it is impossible to talk to them while they're off their meds, because like they can be lucid for like 5 seconds. The next 5 seconds they're on Mars, and there's just no point. I think the point of this legislation is these people, if they can prove up their side of it, what they're essentially saying is, I could not make a decision. I could not rationally make a decision because I do not live within this reality, and that any decision I made was not a sane one, was not a one that a normal person could or would have made, because it's not based on reality, right? And that's kind of the point, and why this is directed at schizophrenia and not like bipolar or something else, because this is the one, especially the one type of mental health issue where you don't know what reality is. Right. So while you thought you were fishing, you actually had a gun in your hand. And so we're saying is that, like, for those people who did not know what reality was or is, that they should at least be excused from the death penalty while having to serve out a life on parole or something like that.
Anything else, members? Thank you
Thank
very
you,
much.
Mr. Chairman. I just want to say for the record, Jeffrey Dahmer was not executed.
So if there's nothing else, if there's no objection, House Bill 2777 will be left pending for now. Mr. Lozano, are you ready? Let's call, the chair will lay out House Bill 1221 and recognize Representative Lozano.
Thank you, Mr. Chairman and members. This bill is not about the death penalty. I'm sorry, this is actually kind of boring, but it's a very important issue that came from my district attorney in my district. This bill, members, addresses a fee that was set in 2007 at a cap of $500. It hasn't been updated. And what this fee is used for, since most counties in Texas offer pretrial diversion programs, the money is used to allow first-time or low-level offenders to avoid a conviction by completing a rehabilitative program. What has happened since then is costs have continued to increase, and this is what occurs. This bill would raise the cap from $500 to $1,200, not as a mandate, just as an option, as a ceiling. Prosecutors still would use discretion to set the fees based on actual cost and the defendant's ability to pay. So if you're indigent, obviously there would be a much lower fee. Many programs waive or reduce fees for those indigent participants. One, the higher cap makes waivers for the indigent more sustainable. Some of the arguments that we've heard is that the indigent will not be able to pay the fees, and I understand that concern, and I'm very sensitive to that. But I believe this bill will help those, like for that first reason, that the higher cap makes the waivers for the indigent more sustainable. While the waived fees aren't recovered, the DA can offset those costs by collecting sufficient revenue from participants who are able to pay. That is not possible if the cap is low, forcing the DA to charge the indigent more, or forcing the DA's office to eliminate the program altogether and only offer traditional community supervision with more burdensome costs. Secondly, there's also concern that a few counties charge the maximum, and that would hurt indigents. First, it's critical to recognize in these counties that waivers are available for those who cannot pay. Secondly, the reason these counties and others do not have room for discretion, that's another factor. Those programs listed earlier, drug testing, betterment classes, probation, supervision, they all have a cost. And the cost has been rising for 20 years, and it's time to help out our counties and our DAs with this program. And thirdly, members, perhaps most importantly, this increase is for the optional programs to continue. And it would be great if the program only costs $50 or was free for everyone. But with the program relying on these fees, the fees are the resource in which these programs are able to operate off of. If the DAs continue to struggle to take in enough for these programs with the current cap, we will see DAs limit or even halt this option altogether because it just isn't sustainable with current costs. If these critical programs continue, as the alternative is much more burdensome for those in need, many would face the alternative of felony probation with fines as high as up to $10,000. This change is simply a necessity, members, given the higher cost. And in conclusion, members, raising the cap ensures that pretrial diversion programs remain sustainable and a sustainable path for our justice system for those who need a second chance the most. And I'd like to reserve my right to close unless there are any questions.
You'll have the right to close. Any questions for Mr. Lozano? Okay, we'll go ahead and call witnesses.
Thank you, Chairman.
We have John Hubert.
Yes, sir. My name is John Hubert. I'm the district attorney for Clayburgh and Kennedy counties. Thank you for letting me speak here today. The pretrial intervention or pretrial diversion programs are incredibly important. They fill a gap in the system that allow us to take first-time offenders of low-level felonies and make sure that there are consequences to the action, because there has to be consequences, but also that we can offer programs, and in the end, if they complete it, they can get their record expunged. And this is just a very valuable, it's the only one that I know of other than finding not guilty at trial or finding not probable cause where they can get the record expunged. So this is a really valuable thing for first-time offenders, young kids, stuff like this. To do this, though, we have to have a healthy program. These fees are used for administration costs. We use them to hire people to go out and watch them when they're cleaning up stuff along the side of the road. We use them for to teach them life skills, how to start a lawnmower, how to paint, stuff like that. Just basic stuff as they're doing community service. We use those. We consider that administrative because it helps the program. If the PTI program can't pay for itself, then we have to get rid of it. And I don't want to do that because that means we have to put them, we can only offer formal community supervision or dismiss the case. And if we dismiss the case, there are no consequences. If we put them on formal community supervision, maybe they can get it sealed, but they can't get it expunged. So this offers us, the pretrial diversion programs offer us a program, way to kind of fill that need. Again, it's only $1,200 for felonies. Of course, the fines are up to $10,000.
Any questions for Ms. Jones?
Thank you for.
Before you, I'm sorry to interrupt. Let me, one thing. I need to clarify, you signed your affirmation that you're testifying in your position as district attorney and also on behalf of yourself. Is that true?
Yes, sir.
Okay, thanks. Go ahead, Ms. Jones.
So I'm confused.
No, one other thing, I'm sorry. And your position on the bill.
I'm for it.
Okay, all right, now.
So here's what I don't understand. I don't understand how raising the fees for all felonies is related to PTIs. That's the first thing I don't understand. Why wouldn't, in a PTI, for the most part, is you did something,
Yes,
right?
ma'am.
And we're literally going to give you the opportunity to pay your debt to society through however long the term is, with
Up to 2
whatever
years.
hoops you jump through. And if you successfully do it, then you'll get a PTI, and you really have created a legal fiction where you can deny that you were ever arrested for it, and your record is literally wiped clean, because you're generally a first-time, low-level offender. You would agree with me, right?
Yes,
My
ma'am.
other job is I'm a defense lawyer sometimes.
Yes, ma'am.
So why would the cost of maintaining that privilege, right, be borne by other people when you actually did do something, right? And if you are offered the very rare PTI, because I don't see where DAs are handing them out like candy, why wouldn't you have to pay that? Because at the end of the day, you're going to have a clean record, again, assuming you do what they ask you to do. So and why should I, if I committed a felony, pled guilty to it or got convicted of it, when there's the opportunity to already fine me, to fine me $10,000, why should I have to pay to get this guy or this girl a clean record? Right? So I just am not understanding, and why are it just doesn't have a causal link to me. So help me understand that.
If I understand the question correctly, and I may not understand correctly, if I understand the question correctly is, are the people on the PTI paying their own costs?
That's not the question.
Okay.
The question is, why should other people who have felony convictions, why should they have to pay for the privilege of somebody who actually did something to get a PTI? Why is that fair?
I agree with you. This would actually take the cost from other people that are on a different type of probation and place it on the people that are in the PTI program.
So the only people that are doing this are the people that are in the PTI program are having to pay the $1,200, right?
Up to. Yes,
$12.
right. Not that, no, it won't apply to any person on.
So actually, hold up. So if I'm wrong, then I'll take back my question. Are you telling me that the only people that will have the $500 to $1,200, is it a fee or a fine?
It's a program fee, and it's for the
Program fee
administration of the program.
is the PTI people.
Yes, ma'am. It's only
So
for
this
the
is
people-
not for the other people?
No,
who
ma'am, it's
commit-
not for deferred or straight probation. Only for the people on pretrial intervention
Oh,
programs.
so they're
and
paying
support
for, so they're
administration.
paying for, now, I don't know that I have a problem with it. I thought you were saying if you get probation and you were charged with a felony, then we can increase you from 500 to 1,200, and then we're gonna use that increased fine, or whatever it is you call it, to help the people with the PTI.
No, ma'am.
Okay,
Exactly.
then that concern goes out of the window. So thank you for clarifying it for me.
Any other questions for Mr. Hubert? Is Mr. Lozano your representative?
Yes, sir.
Well, he's doing you a good job. so-
Lozano and I've got two.
Okay.
But-
Okay, well, we appreciate you being here today. Thank you.
Yes, sir. Thank you.
We also have Rylan Maxsood. Sorry.
Good afternoon, representatives. I'm here to testify against HB 1221 on behalf of both myself and the Texas Fair
And
Defense
state
Project.
your name, if you would.
My name is Rylan Maxsood. Thank you. This bill would more than double one of the pretrial intervention program fees that goes to the prosecutor from $500 to $1,200. These programs were intended to actually prevent recidivism by intervening in someone's life when they're accused of a crime as an alternative to costly and unproductive incarceration incompatible with holding a job. For example, someone with an alcohol use disorder who receives a first-time DWI without any aggravating factors like high BAC is often offered dismissal after a year of counseling and random breathalyzer checks multiple times a day, every day. I would personally feel a lot safer on the road with someone who has proven their new sobriety multiple times a day, every day for a year, than with someone who simply spent a few weeks in jail after a DWI conviction. Each prosecutor's office decides which crimes and programs like addiction treatment are best to serve their constituents and prevent recidivism. I believe in both market incentives and practical reality. Estimates for the total cost of a DWI in Texas already exceed $10,000, with an array of costs and recipients too numerous to list, many of them never eligible for indigency waivers, and indigency waivers, frankly, are not used frequently enough. In justice and municipal courts, my personal area of specialty, judges waive fees less than 2% of the time when the need is far greater, we know. More than doubling this pretrial intervention program fee would further place rehabilitation out of reach of the average Texan, disincentivize use of programs to actually prevent recidivism, and endanger those of us who'd rather try to address the causes of crime than simply lock up first-time offenders, which is even costlier to the county than those who can't pay the fees. Thank you.
Any questions for Mr. Maxsood? Ms. Jones?
Now you got me thinking about something else. I was up here thinking about like my PTI clients. They tend to be young. Most of them did some bonehead that ended up being a crime. Most of them were indigent. And while some judges will waive fees, it's been my experience that most judges don't. And so I guess my concern after hearing you, and I just didn't think about it because I was on a whole nother path when I heard the other witness. Seems like it might make PTI, which is probably an appropriate alternative in the few instances that it's offered, unattainable. So basically it would be a debtor's plea or a debtor's prison because you literally wouldn't be able to participate in the PTI. And then when I think back, and you can tell me, where do you practice?
In the justice and municipal courts mainly, but I'm familiar with the general criminal justice system here.
Because in my PTI cases, because they are so rare, there really is not a whole bunch of supervision. So I'm trying to figure out where all the money would go, because it's just not, and PTIs tend to be very short compared to other probations, which could be years, like 6 months, sometimes 3 months. So
And generally, the supervision that I've seen, I've represented someone with DWI in the criminal defense clinic, and generally, the supervision is by private monitoring companies.
And you have to pay for that
Exactly.
yourself.
Exactly, and
Right.
and the judge can't waive a private company's fees. So.
Now I'm wondering where it's going, because when they make you put a machine on, it seems like I remember my client having to pay like $700 or $800 to get the machine on, and then you got to pay a monthly fee. I mean, that monthly fee's like $200. So if you're on a PTI for 6 months, and you let's say they give you the $500 that they currently have, you're paying. Most poor people can't afford $200 extra for something else. Thank you for making me think about something.
Ms.
Absolutely.
Rodriguez
Thank you.
Ramos has a question.
Thank you, Mr. Maksud. I'm not a criminal defense attorney, so how does this typically work? When they assign these fees, there's a time certain that they have to pay. Is it during that intervention part of it, or how long do they typically have to pay this?
Yes, I mean, typically during the intervention part of the program.
So in a payment plan?
Yes, there would be a payment plan, and I mean, certainly that's possible. But for example, if they fall behind on the $60 a month fee to the private monitoring company, then they're just out of compliance at that point, and they're no longer able to participate.
So do they have additional sanctions when they're not paying that stuff? Like, do they then revoke?
For those unsuccessful in completing it, I mean, generally the pretrial intervention programs involve you filling out a plea and admitting to the crime and everything. So for those who fail the requirements, generally that plea is entered, and then sentencing occurs. And as the district attorney said, probation is generally even more expensive, even more difficult to catch up with. And ultimately, if you fail the requirements of probation, you're incarcerated, and that's even costlier to the county if we're concerned about the county treasury.
So we're raising this from 500 to 1,200. That's like, if you make minimum wage, that's 4 weeks. That's a full month's salary. And sometimes they have to pay this within a matter of months, right?
Yes.
Wow, interesting. Okay, thank you, sir.
Thank you.
Any other questions? Okay, thank you. I'm sorry, Ms. Jones.
I know in straight probation, they sometimes can extend you if you fall behind. But a lot, at least with my clients, if they're indigent, I beg and plead with the DA and the judge who has to sign off on it to please don't make them have to pay a whole bunch of money. But if they do jump through all the hoops that you were talking about, that you asked them to jump through, that it would be in the best interest of justice. But I don't even know. I'd actually like to ask the DA, because I'm not certain how they do it in his county, if someone in a PTI doesn't have the money, because technically your contract is between the accused and the DA. If they don't pay the money, do you terminate PTIs? Do you take it back and they got to start over? I'd actually like to ask the DA that.
Well, we can bring him up, or you can talk to him, offline, either way.
Okay.
Either way. I think Mr. Cook has a question.
Do you think the pretrial diversion programs are important?
I think they are, yes.
Do you think it's a good option, other than probation, like y'all been talking about?
Yes, primarily for society, not even considering the defendant.
And you know where the money goes that's paid?
For this fee specifically, it goes to a special fund to be used by the prosecutors to administer these programs, yes.
Right, so to administer the program, correct?
Well, yes, but I think included in that is, prosecutors' time, and I feel like they're going to be employed either way, regardless, without these funds.
Well, but is it, like, if you look at the statute, it says that reimbursement fees collected under this article shall be deposited into the county treasury in a special fund to be used solely to administer the pretrial intervention program. So that would tell me when the legislature set this program up, they wanted it to be self-sufficient. And so, y'all keep saying that the fee is being raised from $500 to $1,200. That's not correct. It's up to $1,200. Right now, it's up to $500. So maybe they're charging $100, maybe they're charging $300, maybe they're charging $500. But clearly, from a legislative standpoint, it looks like that this fee was set up to administer the cost of pretrial intervention programs. And so
And I certainly believe, even if there are costs that are no longer recouped under this, I'm willing to concede that. I'm not familiar with the logistics. I concede that, the exact dollars. But I think it's better for the county to invest $700 upfront to prevent recidivism and incarceration, which is so expensive day by day. And that's the true alternative to this program. So again, I am sensitive to the county treasury, but I feel like investing $700 at the beginning would save a lot of money down the line for the county.
thank you.
And there could be, Ms. Jones, to deal with the problem of the ability to pay. I mean, there could be some, it's up to $1,200. So, Mr. Lozano, you and Ms. Jones might visit about this, about some provision that takes into account the ability of the defendant to pay the amount.
That's all I'm concerned about. There are some judges who understand that people shouldn't be necessarily denied the ability to participate in something.
It's a waste of time to say,
Right.
you go into this program if you can pay $1,200, if he or she
Right.
can't pay $1,200. So that's probably something that you all can work out in the bill, I would think.
I'll speak with them.
Okay. Okay, anything else, members? Okay, thank you very much for
Thank you,
being
Chairman.
here. Anyone else here to testify for or against or on House Bill 1221? If not, Mr. Lozano, recognize Mr. Lozano to close.
Thank you, Chairman Smithy and members. I look forward to working with you on this bill. It's strictly economics. The waivers that are available for those who cannot pay still remains. This is strictly a numbers issue, and we want to make sure that this program remains viable. And unless there are any questions, I close.
Any other questions for Mr. Lozano? I guess that's
Chairman.
it. So thank you very much. And if there's no objection, the chair will leave 1221 pending for now. Thank you. Mr. Shashline, you've got a crew here, so let me get Mr. Jones up here. Doesn't have but two witnesses or so. If chair would lay out House Bill 1738 and recognize Mr. Jones, Mr. Benton Jones, to distinguish it from our honorable Representative Jones.
Two Joneses, no relation. Thank you, Chair Smithy, Vice Chair Wu, and members of this esteemed committee. Before I begin to lay out this bill, I want to express my sincere gratitude to the members of this committee who took the time to meet with me to discuss House Bill 1738. Your engagement and honest feedback was invaluable to my preparation for this hearing. House Bill 1738 is a straightforward cleanup bill that I had the privilege of introducing last session. This very bill passed out of this committee unanimously last session with a Republican majority. This demonstrates the broad bipartisan support for this measure. The fundamental purpose of this legislation is to align Texas state law with the bedrock principles enshrined in the 14th Amendment of the U.S. Constitution. Specifically, it seeks to strike the unconstitutional language from Section 21.06 of the Penal Code, a statute enacted in 1973 that has been rendered invalid by the Supreme Court. The 2003 landmark Supreme Court decision, Lawrence v. Texas, unequivocally established that criminalizing consensual adult non-procreative sexual activity, often referred to as sodomy laws, is unconstitutional. This ruling affirmed the fundamental right to privacy and personal autonomy for all Americans. Despite the clear precedent that was set by Lawrence v. Texas over 2 decades ago, the outdated and unenforceable language of Section 21.06 remains in our penal code today. This has tangible negative consequences and have had tangible negative consequences. Law enforcement professionals acting in good faith, but sometimes unaware of the legal complexities, have violated the due process and civil liberties of Texans by attempting to enforce this defunct law. This has in turn cost taxpayers thousands of dollars in unnecessary legal fees. Removing this language eliminates this potential for error and protects both our citizens and our state's resources. It's worth noting the broad agreement on the need to repeal this law. Even in his dissent in Lawrence v. Texas, Supreme Court Justice Clarence Thomas famously conceded that our state was uncommonly silly and stated that if he was a member of this very body, he would repeal this law. Furthermore, our current United States Senator, Ted Cruz, has publicly stated his support for repealing this very law. He said, and I quote, "Consenting adults should be able to do what they wish to do, consenting adults should be able to do what they wish in their private sexual activity, and government has no business in their bedrooms." This sentiment reflects a widely held belief in personal liberty and limited government intervention. Now, I want to directly address an argument raised by opposition to this bill, stating that this bill would make homosexuality more acceptable in materials read by children and more acceptable as overall conduct in the United States. That this legislation is the opposite of protecting children and families in Texas. Let me be clear, absolutely clear, that this bill makes no change whatsoever to the children's education or learning. Anyone who suggests otherwise is not being honest with their intentions, and these players continue to spread misinformation by weaponizing Texas children and their families for political gain within this body. The sole focus is to rectify the unconstitutional language and the specific statute concerning adult consensual behavior. That's it, that's all. To leave no room for doubt, I will quote the exact language of my bill. Section 21.06 of the Penal Code is repealed. And in the Health and Safety Code, repeal the mentions of the criminal offense under 21.06. This is the entirety of the proposed change. It is targeted, specific, and only corrects the unconstitutional provision. Members, this is a matter of common sense governance. I am not asking you to vote on whether or not you agree with the Lawrence v. Texas decision. Instead, I am asking you to vote for a law that strengthens the fundamental civil liberties and individual freedoms that all Texans deserve. I'm asking you to vote for a law that upholds the principles that Texans should have the freedom and ability to make their own private decisions without unwarranted government interference. I'm proud to acknowledge the bipartisan support this bill has garnered both this session and last session. I want to thank Speaker Pro Tem Joe Moody, former Speaker Dave Phelan, Representative Brian Harris, and Representative Ann Johnson for their commitment to these principles and for serving as joint authors on this critical piece of legislation. Therefore, I respectfully come before you today to urge your affirmative vote to move House Bill 1738 to the House floor. And at this time, I'll be happy to answer any questions you may have. And with that, I reserve the right to close.
Well, let me ask you this. I went back and read the Lawrence case. I hadn't read it in years. But when you read Lawrence, it doesn't strike down 21. It doesn't sound to me like the court is striking down the majority opinion, which it was a split court. And so you got the majority opinion by Justice Kennedy. And there's nothing in there that says they're striking down the statute. In fact, in the majority opinion, he seems to say there are certain circumstances where the statute would have validity. For instance, he points out that you could have, and once we look at the statute itself, which 2106, it doesn't have anything about consent or anything. It just says a person commits an offense if he engages in deviant sexual intercourse with another individual of the same sex. And so what the majority opinion says to me is there are certain instances where the state would have a compelling interest in stopping that behavior. For example, conduct between an adult and a minor. Another one would be where you have no consent, where you don't have effective consent. You have a person who is unable to properly consent to the relationship. Another one that Justice Kennedy pointed out would be conduct that occurs in public. And another one that would be, for instance, prostitution, connected with prostitution. So I'm sure that most of those acts that Justice Kennedy pointed out would be covered by some other statute in the penal code. I mean, I don't know that, but I suspect they would be. But wouldn't you agree, though, that there are some aspects of what 2106 covers that the state has a compelling interest in making illegal?
I think that's a very good argument. However, this law has been used very broadly, and the interpretation of this law has been very broadly to specifically point out same-sex couples. There was an example that happened in El Paso to where two men were together having lunch. And someone called the police on them, and they were arrested because of this legislation. There was no deviant.
When was that?
Huh?
When was that? Do you
That
know?
was in 2009.
Okay.
And so this law has been used time and time over and over again. I mean, even some of the people that you'll have, coming up to witness to give testimony has been before this body 17 times to fight this bill, and not based on any conduct that's happening with any of the areas that you mentioned, which is also outlined in other parts of the penal code, but specifically to same-sex couples who are just living their life just like anyone else.
But I mean, you would agree that the state has some compelling interest to prevent certain conduct that could fall under this statute, under the very broad definition of the statute.
I think that when you look at any couple, especially when you look at the nature of some of the sodomy laws, it falls for anyone, not just, I guess the question I would propose, like, why is there a singling out of same-sex couples versus the understanding and the need to address this at large, especially when you talk about situations that are not just pointed towards someone of same sex, but there's a number of situations that could warrant this with also heterosexual couples as well.
I think that's well taken, sir.
Thank you, sir.
Okay, any other questions? Mr. Moody? Well, let me get Mr. Moody in.
No, and it just to the chair's point on some conduct, prostitution is illegal, covered in the penal code. Rape is illegal, sexual assault is illegal, indecency with a child is illegal. So those instances of a compelling state interest have been addressed in other portions. And so what this leaves is a provision that covers consensual conduct between adults. And so because we've spoken through our code to penalize those other portions, those other types of conduct, this stands alone only to govern that conduct, and that's why it was struck down for that reason as a violation of due process. I'm happy to speak about the El Paso case more, but it was post Lawrence and cost our city a good sum of money to retrain officers after a couple of men were kissing at a local restaurant.
One other question that I had is, we have this language about from the Health and Safety Code about instructional materials, and yet that's not reflected specifically in the caption of the case. And I assume this was a council draft. I just had a question whether that should be, since it does amend more than just the penal code, that possibly the caption should be a little wider, but I'll let you deal with that.
Definitely can look into it, and simply regarding, and I know that there's been a lot of conversation regarding the Health and Safety Code, but the only reference to the Health and Safety Code was removal of the language that specifically addresses 2106 and nothing else.
Good. Ms. Jones, did you have a question?
I just want to clarify that Lawrence v. Texas was in 2003. The Supreme Court struck down the law in a 6-3 ruling, and it talked about saying homosexual activity. I mean, it referred to it as deviant, they explicitly overruled their 1986 decision, Bowers v. Hardwick, which was a similar Georgia law. And I'll say this, that I think that the reason that it was 6-3 and the reason that they struck it down is because what two grown people do in the privacy of their bedroom is nobody's business but their own. I'm not entirely clear why they bring up kids, but I will share this. I struggle with
people targeting people who are in same-sex relationships, and why people want to focus on what people in same-sex relationships do in the privacy of their homes when they're not doing the same thing with heterosexual relationships. It's a problem for me. And so it's been 23, if I do my math, 22 years since Lawrence v. Texas came down. And I just think, as I said before, that what two grown people do is their business. And I just don't think that we, for everyone who believes in limited government, there are so many more things that we could be worried about than what two, for the third time, grown people are consensually doing in their bedrooms. So I think that your bill clarifies what the law of the land is and has been for 22 years, and it removes the opportunity for people who are fixated on what, for the fourth time, two grown folks do in the privacy of their home if they happen to be the same sex, because they are not micromanaging heterosexual relationships. That's my 2 cents.
Thank you, Representative Jones.
Any other questions, members? Okay. Thank you, Ms. Jones, and we'll certainly provide you the right to close.
Thank you.
And, members, we have 3 witnesses signed up on this bill. One of them signed up as Gao, G-A-O. Is that person? Here's what I'm going to need you to do, okay? I need you didn't put your last name, or I don't know if that's your last name or first name.
Last name.
Okay. If you could go back out in the kiosk and do your full name, and I'm going to call the other witnesses first, and by the time you get back in here, we'll get you on, okay?
Yes, sir.
Okay. And so the chair would call Clayton Caldwell.
Howdy, folks. I'm speaking extemporaneously, so please forgive me if I stammer a bit. My name is Clayton Caldwell. I've lived here in Texas since 1978. I am a 60-year-old cis gay man, and I was around way back in Ann Richards' time when they were originally trying to get rid of 2106. Just a few things I would like to bring up about it is that, as has been noted,
Before you go any further, if you would state your position on the bill.
Oh, I am for the bill. I think that 2106 does need to be stricken from the Texas Penal Code. Okay. One of the big focuses is that, as has been noted, it is specific toward same-sex people. And if someone wants to bring up a health issue or a deviancy issue, one would think that it would be applied to all people, not specifically same-sex couples. But as a matter of fact, when Ann Richards was working on revamping the Texas Penal Code, there was an amendment presented to do exactly that and make it applicable to all couples. But that was struck down for reasons that are unfathomable to me. But that said, one of the big things that why I think people want it to exist is not because it's constitutional or valid, but they want to use it as a sword of Damocles over the heads of gay people. There was a woman, a lesbian in Dallas named Micah England, who had applied for the Dallas Police Force. And her application was denied based on 2106, despite her not having exhibited any sort of behavior that would be applicable under 2106. Simply the fact that she was a lesbian was enough for them to consider her a de facto criminal. And that's what 2106 really does, is treat gay people as de facto criminals. And I've seen anti-gay literature that actually claims that, oh, you can't trust gay people because they're criminals. So removing 2106 would get rid of a false argument that is used to unfairly impugn on gay people.
Okay, let me see if there's any questions. Any questions for Mr. Caldwell? Okay, and I've got to get you to say, I hate to keep badgering you, but you are here testifying on behalf of yourself, is that correct?
Yes, that is correct.
Okay, thank you very much for being here. The chair calls Jonathan Covey.
Mr. Chairman and members, my name is Jonathan Covey. I'm testifying against HB 1738. And I believe I understand what the author's intent here is. We've taken some time to go into some more depth on this issue, and we decided we have to oppose it. And I have 3 points I want to make. Number one, even though it's unenforceable, Section 21.06 is the exclamation point reinforcing that homosexual conduct is not an acceptable lifestyle. Some laws don't need to be enforceable to serve a purpose. They are declarative and persuasive. And that's what this bill does for those who read about it or know about it. It warns that this conduct is not acceptable. Secondly, as an organization, we disagree with the rationale and the ultimate outcome of Lawrence v. Texas, how it was decided, and we feel that Section 21.06 registers our state's disagreement with the U.S. Supreme Court decision. The Lawrence decision failed to address key points in previous case precedent, and it drastically misapplied the rational basis test without giving deference usually afforded to state interests. And then thirdly, to the extent that folks are experiencing criminal enforcement on an unenforceable statute, this is a matter of, a very serious matter of misinterpretation by those who are charged with enforcement, not a fault in the statute itself. And unfortunately, laws are misinterpreted and are abused by bad actors. But to blame the statute, not the enforcement, I don't believe is the right approach.
Any questions for Mr. Covey? Okay, we appreciate you being here. Oh, Mr. Wu, I'm sorry.
Hi. Thank you. This statute that we're talking about is unenforceable by law, correct?
Correct.
It's a dead statute. Yes?
Correct.
Okay.
Yes, sir.
And you're saying that because the statute is still in the books, it's the police officer's fault for enforcing it and not the fault of the legislature for keeping it on the books?
What I'm saying is that I'm not okay with it sending the wrong message to thousands of people in the state of Texas that this lifestyle or this conduct is becoming more acceptable.
I just want to back up. I'm saying, like, your statement earlier that if people are getting prosecuted by this, for the statute, that this is really the fault of police officers who are following a statute that's on the books, right? Instead of the fault of the legislature for keeping a dead bill or dead law on the books.
Right. We don't control law enforcement and the judgments they make, and I don't have the big criminal code book that Representative Little has on me. But from what I've heard, this section has a notation in it saying that it's unenforceable.
So it's the fault of police officers for not having gotten Westlaw, pulled up the statute, read the case notes on it, and not enforce a law that is still on the books.
Well, I think if something is being enforced that's unenforceable, that's the district attorney and law enforcement's end of things.
I mean, that sounds like it's just a really roundabout way of saying maybe we should get rid of a law that is unenforceable off the books so that it's easier for police officers, so they know what the law is, right? Why have a law on the books that is unenforceable? Like when we repeal other statutes in a law, should we just leave them in the books after we repeal them?
Well, we have. The 1925 pre-Roe statute was left on the books.
Have we repealed that?
No.
Okay. So, and again, this Roe has been overturned, whatever it is, but right now, I mean, like, this is not something that's in law. And again, it's the criminal statute of this, the criminal portion of this, that's causing people to get arrested for a law that is unenforceable because we left it on the books. And it's creating confusion for not only average citizens, but for law enforcement. Would the sensible solution not be to get rid of a dead statute that is causing confusion and problems?
I think this statute is doing some benefit by giving a warning that this lifestyle is unacceptable.
And you're saying that that should be the role of government, to tell adults what they should or should not do in the privacy of their own homes?
Well, that's already done in cases. I mean, we regulate bestiality, we regulate incest, we regulate bigamy.
I'm sorry, bestiality, where are the two adults in that?
Sorry. Adult incest, bigamy, and prostitution, so forth.
Okay. So, again, we're not talking about those things. Those have separate statutes that regulate them, right? Earlier, Chair Smithy talked about all the other types of conducts that might be touched by this. Every single one of those other conducts has a separate criminal statute that touches it, and it does not impugn on whether the conduct is between a man and a man and a woman, or whatever it is. Right?
Well, I think the point is that if all private consensual conduct is not able to be regulated in some way, then it's a slippery slope.
So, again, those other conducts, one, already have statutes on them. We regulate, conduct between adults and children because children cannot consent. We regulate between adults and animals because animals cannot consent, right? And all of this other and down. But here we're talking about consenting adults in their own home. And you're saying that we should keep this law that is no longer enforceable, that makes it life more difficult for consenting adults in what they do in the privacy of their home. All right, that's okay. Thank you.
Even consenting adult actions have societal implications at times.
Okay, any other questions, members? Okay, thank you for being here.
Thank you.
I'm sorry, okay, one more thing. You are testifying on behalf of Texas Values, correct?
Yes, sir.
Okay, that's it. Thank you very much. And, Mr. Moody. Oh, come back up here if you would. We got one more question. Mr. Moody has.
Sorry, actually, what you said, I guess you said Texas Values is who you're representing here today?
Yes,
Is that
sir.
right? So, and we've been in hearings on this bill, I don't know how many times now. The testimony from your organization has changed from you want this portion out. Now it's just says, even when we took that portion out, related to the health and safety code provisions, right? That was in a version actually previously for Representative Jones's bill. That was the main concern that was raised by your organization, taken out, right? Because it leaves the language in. We'll just highlight it because it actually parrots what you just said. The original, when we started talking about this, struck two different things. If you look at page 1 of the bill, the previous iteration struck the entirety of lines 13 and 14, state that homosexual conduct is not acceptable lifestyle and is a criminal offense under section 21.06 Penal Code. The testimony previously, over the years has been, well, don't strike that first part. Just if you're really trying to repeal the law, just strike the part that says it's an offense. And so that's been complied with, and that's been the testimony of your organization in the past. So now I do want to thank you for the clarity, because I think we've distilled down that the position of your organization is that homosexuals should be viewed as criminals. That's the position of your organization?
Well, every session, and I think you make a good point, every session, the goal about this has been more than just removing the criminal penalty.
No, that's exactly what it is.
So
But we've done that for, I think we did that the first time in 2019, struck that out. So it hasn't been part of this conversation in a real way. When Mr. Jones picked up the bill, it was filed back how it used to be filed, and he understood the concerns, and he removed it.
I think Representative Beckley had it in before that.
Yeah, I don't recall. I guess so. Is it the position of your organization that homosexuals should be viewed as criminals? Because it's the only reason to keep this statute on the books.
The position of our organization is that we don't want to pull something out that's going to make it seem like that homosexuality is more acceptable.
And what the law did was criminalize that conduct. And so the position then has to be that that's the viewpoint you want to continue in perpetuity, even in the light of a Supreme Court case invalidating this particular provision.
we want to give the message that
That's
this
cri-
is not acceptable conduct.
But unacceptable conduct versus what is criminal conduct is different.
I
I
understand.
could say that, I've got kids and, they like to eat fast food. That's unhealthy. It's not good for them. It's not a good lifestyle decision for them. And I make those decisions in our house. And we have regulation through all sorts of code on food and warnings and all that other stuff and whatever. But there's a difference between saying something is unacceptable and unhealthy and criminal. You would agree with that?
I think what I would agree with
Because if you
is-
would take that position, that's fine. That's your position. You don't think, and your organization's position, they said, we don't think it's acceptable lifestyle. We don't think it's a healthy lifestyle. And that's why all this stuff is left in here. So all that's left here now is your organization taking the position that these people should be viewed as criminals. And I just wanted that to be clear on the record. Is that the position? Because that's all that's left here now.
that we don't control if law enforcement.
I'm not talking
do
about
this.
that.
I
The position of
understand.
leaving it here in the penal code, because your argument is that if we remove it, we're sending some sort of message. The only message being sent by a criminal statute being removed is that conduct is not criminal.
The
And
message.
so to leave it there is saying, we would like for you to know.
Well, the message that's
that we
also
think
being
they are
sent
criminals.
by removing it is that it's more acceptable.
In that it's not a crime.
Right.
Okay, all right, thank you.
Okay, anything else? Thank you for being here, Mr. Covey.
Thank you, Mr.
And so we have Mr. Charles Gayo. Gao? Okay, I'm sorry. But thank you for going out and re-registering. Appreciate it.
Thank you, committee members. My name is Charles. I am a gay Texan, and frankly, I am glad that these kinds of outdated, unenforceable, and private provisions are being taken out of our laws.
Okay, let me stop you there. You're here representing yourself, correct?
Yes, sir.
And you are for the bill, right?
Yes, sir.
Okay, and the other thing is, will you give our clerk permission to delete your prior, your prior form where you just put your last name?
Yes, sir.
Okay, I just need to get that.
Yes, I do consent to that.
Okay. Go ahead, I'm sorry to interrupt you.
No problem. Where was I?
I'm sorry.
Yeah, I'm glad that these outdated, unenforceable, and private concerns are being taken out of the law, and I would just encourage that our legislators consider other impacted minorities, such as trans people who don't necessarily have the same protections, to consider legislation to protect these groups
Yep.
as well.
I've got to ask you to stay on the topic of the bill, and that's
understand.
not just to protect the bill, so.
Yes, I understand. Actually, I don't have any further comments beyond that, just that this makes sense. I'm glad it's happening.
No, appreciate you being here. Mr. Wood, did you have?
Absolutely, thank you. Mr. Gao, you said you're a gay Texan.
Yes,
correct?
sir.
Are you a criminal?
I don't consider myself to be.
No. Are you in a relationship?
Yes, sir.
Okay. And you love each other, you care for each other?
Yes,
Right.
very much so.
And should any of that be criminal?
I don't believe so.
Is never mind. Thank you.
Thank you, sir.
Okay, any other questions, members? Okay, thank you very much for being here.
Thank you.
Anyone else here to testify for, against, or on House Bill 1738? If not, Chair recognizes Mr. Jones to close.
Well, thankfully, our opposition helped write my ending for me. So when we look at this law, again, the same organization has come forward, even with good faith negotiation, has changed the goalposts in this conversation. It was mentioned several times about, and to my opposition, this being in the Health and Safety Code, that we still have in that language. And on this bill on page 2, line 17, it emphasizes, when we talk about information that's provided, information is provided in a factual manner and from public health perspective that homosexuality is not a lifestyle acceptable to the general public. That is still in the law. And so, That language is still in there. In a good faith negotiation, I came before you last session and made the changes to just address the criminality of this conversation. And that's what I hope that we will continue to focus on. And when we look at other statutes and law that were specifically mentioned, there are several other places where several items which it's almost insulting to have a conversation like this and have to talk about things like bestiality and incest and all those areas, but it is addressed. Bigamy, Section 25.01 of the Penal Code. Bestiality, Section 21.09 of the Penal Code. Pedophilia, Section 21.11 of the Penal Code. And incest, Section 25.02 of the Penal Code. So all of those issues that were raised as concerns regarding this legislation is still in our Penal Code and will remain. My efforts is to make sure that we are taking out the unconstitutional language that exists, particularly identifying same-sex couples as criminals. And so, in closing, I will say this. Chairman Smithing, your marriage to your wife is not a crime. Representative Little, your marriage to your wife is not a crime. Representative Money, your marriage to your wife is not a crime. So when we have a conversation regarding my fiance Gregory and I, why should I, a colleague of yours, be treated as a criminal under this statute? Why are we still having this conversation about the criminality of an individual when everyone should be treated with dignity and respect and have due process under the law? And last, I would say, as a man of deep faith, I know that God makes no mistakes. I, nor the people who are in same-sex relationships, are not a mistake, and we are also not criminals. And with that, I close.
Let me ask you, Mr. Jones, one question.
Let's go.
So the only conduct that you're specifically wanting to legalize here is consensual conduct between adults, is that?
That is correct.
Okay, and okay, I got you. Okay.
Children cannot offer consent.
All right. Okay, any other questions? Okay, thank you very much.
Thank you very much.
Members, if there's no objection, the chair will leave House Bill 1738 pending. Members, I've got to get Mr. Curry on. He's got some witnesses that need to be somewhere, if that's okay. I apologize to those of you who have been waiting. Mr. Chair would lay out House Bill 2984 and recognize Representative Curry.
Thank you, Mr. Chairman, members of the committee. Thank you for the opportunity to present House Bill 2984. I am honored to carry it. You'll understand why in a minute. The Gutierrez family is present, and I appreciate y'all's patience in letting me present this bill now. So this bill clarifies that a person is presumed to be intoxicated if a test shows the blood alcohol content, BAC, of 0.08 or higher at the time the test is conducted. I want to stress that this bill does not challenge the legal definition of intoxication, the procedures for collecting blood specimens, or methods used to analyze blood alcohol content levels. The idea for this legislation originated from a working group of county and district attorneys, as well as law enforcement, and is intended to honor the memory of Sergeant Ramon Gutierrez of the Harris County Sheriff's Department office, who was tragically killed by a drunk driver in August of 2021. The need for this bill stems from challenges that often arise in DWI cases, where questions are raised about whether the driver was intoxicated at the time of the incident, due to delays between the incident and the time a blood specimen is collected. By creating a rebuttable presumption in these cases, HB 2984 aims to reduce the time and resources toxicologists currently spend performing what is known as retrograde extrapolation, the process of calculating blood alcohol content at the time of the offense based on later test results. As an example, performing a retrograde extrapolation is highly variable with regards to time consumption, but usually takes 3 to 5 hours, and then discussing with and educating attorneys can take another 3 or 4 hours and more, in addition to the time involving the court case itself. This is a common sense measure. In fact, according to responsibility.org, similar statutes exist in more than 30 other states, including Alabama, Oklahoma, and Virginia, among others. The bill enjoys broad support from law enforcement, prosecutors, forensic labs, and advocacy organizations dedicated to combating impaired driving. We have expert witnesses today who can talk about this issue from the perspective of law enforcement and trying these cases. The expert in testing had to back out for personal reasons, but I urge you to read his submitted written testimony as well. Thank you for your consideration. I'll be happy to answer any questions at this moment. I reserve the right to close, please, sir.
And we'll certainly do that. Any questions for Mr. Curry? Ms. Jones?
I'm not, thanks for coming. So if it's 0.08, right, that's technically legal intoxication. I'm not sure what you're trying to do. Can you help me? I mean, if we go to trial and they prove that it's 0.08, then you're legally intoxicated and they're going to find you guilty. How does this practically change anything?
So if you wouldn't mind, do me a favor. I do have experts on this. If you don't mind,
I'll defer to them.
They'll answer it a little better than I will. I will answer it certainly, and I'll finish with an answer if I need to.
So you sort of answered it. I'll just let them come up and then I'll ask them.
Anything else for Mr. Curry? Mr. Little?
Thank you, Mr. Chairman. Thank you, Representative Curry, for your bill. I have some pretty significant concerns about this because of the shifting of the burden of proof to the defendant. Once the presumption becomes rebuttable, then it shifts over. The burden of proof then shifts over to the defendant to rebut the presumption. Although I'm not a criminal defense lawyer, I'm fortunate enough to have interacted with a lot of them. At times, the blood alcohol tests are the equipment that's used is either faulty, it's not calibrated well, it's not used properly, there's human error involved, and I have some pretty significant concerns about shifting the burden of proof away from the state. Do you have any feelings about that, Mr. Representative Curry, or I'm sure you've given that some thought?
Well, first and foremost, I'm not a lawyer, so I don't necessarily want to argue this point with you when it comes to a legal point.
Sure.
But I would say that if whether you can test the blood alcohol content level, that's the way it's being calculated, the way it's being measured or not, if subsequent to the arrest, no matter how long it is, there is a blood alcohol content taken that is 0.08 or above, then certainly that's rebuttable. Whether from a legal standpoint, I would assume that you would try to rebut the blood alcohol content level based on what you're saying. But if it's at the time and it's past the time of when the arrest occurred, then it should be automatically presumed that it was 0.08 or higher at the time of the arrest. Mm-hmm. You see what I'm saying?
I do see what you're saying.
So I'm just saying, if you take the test later and it's a 0.08 then you don't have to go through all this other extrapolation stuff.
All right. Thank you, Representative Curry.
Thank you.
Thank you, Chair.
Representative Jones?
So, Rep. Curry, if what Rep. Little said is, if it's meant to shift the burden from the state to the defense, so here's my problem. I believe in the Constitution and all the amendments. And the reason I say the amendments are important is because I wouldn't be a person without them. But the reason this country was founded was because in England, the government could just oppress you, right? And so that's why we founded this country, to make sure that the state, the government, Big Brother, always has to prove beyond a reasonable doubt each and every element of what you're charged with. And so and I'll wait until the experts come testify.
Thank you.
But it's not, I'd actually like to see, right, because I think that justice should not just be determined by the prosecutors. I mean, again, the reason this country was founded was because of what I said before. So if this working group didn't have criminal defense lawyers to balance the equities, because there's nothing like if the government targets you and they're wrong about targeting you, right? But they believe from the depths of their soul that they're right, that you're a criminal. God forbid you be that person, which is why the standard is so high for them to have to prove beyond a reasonable doubt. So when you say prosecutors and district attorneys, anyway, so I'll just wait. But if it's meant to shift something that is deeply entrenched in this country, then I will tell you.
I appreciate that. I do want to say in response to that my heart, like all of our heart, is number one, is to make sure that we do have common sense laws and that they do protect the innocent until proven guilty. I don't have an issue with that whatsoever. My point is if you're drunk when you're arrested and you're still proven to be drunk later, you don't have to go back and extrapolate that you were drunk when you were arrested, unless you've been drinking in jail, which I don't think they allow that. But my point is that if you can simplify a law and not have to create, now granted, from a defense standpoint, I understand that every person has a right to defense. They should be able to defend, and it has to be beyond the reasonable doubt. Have no issues with that.
That the state has that burden.
Correct.
Okay.
Totally agree with that. My heart is I want to stop as many drunk drivers as I can, and I want to stop as many deaths because of drunk driving as possible. So please understand that once my experts come up and once we're able to talk about this further, then I'll be happy to address more in my close if need be.
I'm actually looking forward to what they have to say.
Okay.
So thank you.
Thank you.
Mr. Wu has.
So I think I understand what your bill is doing. So you're saying, like, some kind of incident occurs, someone's pulled over, a police officer suspects that someone might be intoxicated, whether it's following an accident or not, right? And that police officer another police officer at some later point requests a blood draw, correct?
I think that is correct.
Like whether that's 2 hours down the line, 3 hours down the line, 4 hours down the line, 6 hours down the line, whatever it is, they request a blood draw, or the hospital does a blood draw. And at the time that they draw the blood, it's above 0.08. And so because it's above 0.08 at the time of the draw, whether that's 2 or 4 hours later, the presumption, now you have a legal presumption in front of the jury that says, well, if it's over 0.08, 2 hours, 3 hours, 4 hours ago, then we're going to presume that it was above 0.08 at the time of the driving.
So, Vice Chairman, if you'll allow me to pause there for a moment, I have a district attorney here that's going to talk about this, and I assure you, I've never had this happen with me, so I don't know all the ins and outs of it, but I'm proud to be carrying this bill for the Gutierrez family and for those that asked for it. So,
thank you.
I appreciate your patience.
Thank you.
Okay. Anything else, Mr. Curry? Okay, we'll certainly save you the right to close. The chair calls Lupita Gutierrez. Thank you, Ms. Gutierrez. We appreciate you being here today.
Pull the mic down.
Yes. I do realize I'm short. Good morning, Chairman and members of the committee. My name is Lupita Gutierrez. I'm here today as a wife, as a mother, and as a woman whose life has forever been changed. I didn't wear the uniform, and I did not wear the badge. Ramon was my husband of 25 years. We have 3 children, Natalie, Alfredo, and Omar. Natalie has become a mother, and my husband's not here to hold our first grandbaby. Omar graduated, and he didn't have his father witness his graduation. My husband was the strength of our home. He was the kind of man who showed up every day for his family, for his community. He was also a very gifted cook. He was a great barbecue. He did some great barbecue. Everyone that knew him, they knew him for that. He often cooked for his colleagues. Whenever we had a tragedy and some of us had to flee, he was behind cooking for some of his coworkers. He served the Harris County Sheriff's Department for 20 years with courage, dedication, and like many officers, he had to go out and find the extra jobs to provide for his family. One of those nights that he was working one of those extra jobs, he was hit by a drunk driver. Someone that did not find it in herself to stop, render aid. The only thing she was worried about was to get home herself. I believe that this bill, it's about making it clear that taking a life carries a real responsibility. It gives a voice to those that are not here. And it sends a message that lives lost through reckless driving cannot be dismissed. Please, in honor of my husband and the officers that are here and everyone that has to be out on the street, for every family that has lost a bread provider, a family member to drinking and driving, I ask you to please pass this bill. And
Okay, I've got to clarify, you're here representing yourself?
yes, sir, I'm here
Okay,
representing myself.
And you're for the bill, obviously?
Yes, and I'm for the bill.
Okay. Any questions, members? Well, we appreciate you being here. I think we have your son. Your son
Yes.
is here as well.
Yes, sir.
Okay, great.
Thank
Thank you
you.
for coming. The chair calls Alfredo Gutierrez. Your mother set a very high bar for you to follow, so.
Yes, she's quite amazing.
Yeah, okay.
My name's Alfredo Gutierrez. I'm here representing myself and the Gutierrez family, and I am in favor of the bill. Good morning, Chairman and members of the committee. My name is Alfredo Gutierrez, and I'm here to speak about the impact drunk driving has had on my family and why HB 2984 matters. On January 24th, 2022, my father, Sergeant Ramon Gutierrez, was struck and killed by a drunk driver while escorting an oversized load. He was a 20-year veteran of the Harris County Sheriff's Office. He was a husband, a father, and a protector, and he didn't come home that night. Since that day, my family has had to rebuild our lives without him, and we're not alone. In 2022, over 1,100 Texans were killed in alcohol-related crashes. That's 3 families every day, just like mine. There hasn't been a single day without a traffic fatality on Texas roads since the year of 2000. That means more than 2 decades. Not one day has passed without a family receiving life-changing news. This bill is about accountability. It's about closing the loophole that allows drunk drivers to avoid consequences even when their BAC is clearly over the legal limit. HB 2984 gives our system the clarity it needs. It helps ensure that what happened to my dad and so many others doesn't keep happening. Please support this bill for my father, for my family, and for every Texan still waiting for justice. And all that I ask is that as you consider this bill, I ask that you take a moment to reflect, what would you want from the law if it were your family? What would justice look like if it were your father or your spouse or your child? Thank you very much.
One other thing, you had said that you're here representing yourself and your family. Can the clerk have permission to put on there that you're representing your family as well?
Yes.
Okay.
Yes, sir.
We'll do that. And so any questions, members? No, it's hard for you and your mom both to come up here and talk about this, but we do appreciate you being here and doing that. So
Thank you, and we appreciate y'all listening.
thank you very much.
Appreciate it.
And, oh, I'm sorry, we do have a question. Ms. Jones.
Well, I actually think that you competed very well with your mother.
Thank you.
I'm sorry for your loss.
Thank you.
And I guess I'm glad to see that you are not allowing your father's death to be in vain and that you're trying to make some change.
Yes, ma'am, and we're doing everything we can, and again, there are experts here that can speak on it a lot better than us, but we do believe that this is a very common sense adjustment to the wording. Again, they're going to speak to it more, but again, thank you guys so much for listening.
One other question, what year was it that you?
It was 2022, so the same year, in that same year, there were 1,100 accidents that were related to alcohol.
All right. Thank you for being here.
No problem, thank you.
Members, we, Sasha Latham. Go ahead.
Good afternoon, Chairman Smithy, Vice Chair Wu, and esteemed committee members. My name is Sasha Latham, and I am a sergeant representing the Harris County Sheriff's Office, testifying in support of House Bill 2984.
And you're also testifying on behalf of yourself as well.
Correct,
Thank
yes,
you.
sir.
Okay,
Yes, sir.
thank you. And you're for the bill?
Yes, sir.
Okay, thank you.
I currently serve as a supervisor assigned to the Vehicular Crimes Division. I supervise our day shift fatality crash team and our crash reconstruction teams. I've investigated or been the supervisor on scene of over hundreds of fatality crashes. I'm a drug recognition expert and a master peace officer. I'm also the person that knocks on your door in the middle of the night to tell you the worst news of your life, that you've lost a loved one to an impaired driver. Impaired driving is the most technical offense in the penal code for a peace officer to investigate. One of the requirements of the law as it's written currently is to prove that someone's alcohol concentration is at what it is at the precise time that someone's driving. Yet there's no technology that I can use to determine what somebody's alcohol concentration is at that exact moment. In every impaired driving investigation, there is a delay between the time of driving and the time that I then collect a breath or a blood sample. We then rely on a toxicologist to perform what's called retrograde extrapolation to then determine what someone's alcohol concentration is at the time of driving. Retrograde extrapolation is dependent on information that's gathered from an impaired person during the investigation, which is not always accurate or complete. Because of these limitations, it's more common for toxicologists to testify that it's possible that the defendant was below a .08, despite that not being reasonable. HB 2984 will bridge the gap between the time of driving and when the time the breath or blood sample is collected. Additionally, this change has no fiscal impact. Majority of other states have this. This will make impaired driving investigations and adjudication of these cases more streamlined, and this doesn't necessarily give us more arrests. It just makes the arrest that we have worth the effort. I'm happy to answer any questions.
Members, are there any questions? Rep. Jones?
When there's a fatality and the driver's there, could you guys not get a search warrant to draw blood at that moment so that you know what was in his blood at the time of the accident relatively quickly? Is that accurate?
And we are lucky enough, because you're out of Harris County, correct?
Yeah, I know Ed.
Okay. So we are blessed enough in our county to have it set up where we have magistrates on and prosecutors on 24/7, 365. It still takes us a significant amount of time to draft a search warrant and speak with the prosecutor to draft a search warrant, then get it before a magistrate who, if they find probable cause, then sign it and then get in front of a qualified technician, nurse, or phlebotomist to then draw that blood draw. So we're still talking about at least hour and a half, 2 hours, depending on the severity of the crash and the complications of it. Now we're talking about 3 or 4 hours, sometimes 5 or 6. So not necessarily from the scene can I immediately get it. No.
But you can.
No.
I mean, if you think, and let me just say this, and if the drunk driver is alive and they've got to rush him to the hospital's gonna take his blood and do all that stuff, right?
Some do, yes, some do not.
I just, again, the Constitution protects freedom from unreasonable search and seizures, and I am just struggling with, because the government doesn't have something in place to be able to do stuff. I mean, and that we should de facto make it easier for the government to prove their case. So I'm just sort of struggling with that. But I do know that you can get search warrants. So, and I know, and I've practiced law in small towns, because have law license will travel across Texas. That sometimes they don't have 24-hour magistrates or whatever, but I also don't think that just because you are in a place that doesn't have stuff that you should lower the standard for government to be able to prove stuff beyond a reasonable doubt, because I just think when you give the government a break, I mean, in fact, I just read somewhere, I thought it was an outlier where somebody was charged with intox manslaughter for a big wreck that happened on 35, and then they came back and found out that the person wasn't intoxicated. But the whole world thought the guy was intoxicated. The media said that he was intoxicated, and so. Huh? Say it again.
I said it's probably good that they were able to test them.
I don't know what they tested. I just know I read that he wasn't intoxicated, and I was like, well, that ain't what I saw on the news. So in any case, I just really struggle with something bad really happens, and then us just trying to lower the standard for government, because God forbid the government sets its sights on you, and then what is a little person without all the resources of the government? Like, what do you do when the government has all the resources against you, and we've made their burden less? But I absolutely don't want drunk drivers killing people. I do not. But I just think the government is in the best position to do what they need to do in order to be able to prove it beyond a reasonable doubt. So, and I don't know that I do a whole bunch of DWIs, but most times when it comes back within a number of hours and it's more, they normally presume, at least I've heard that alcohol's gotten out of your system, and so you were drunker or you were more intoxicated. It's been my experience. I haven't seen a case where they're like, if you're 0.08 and after the fact, like, relatively close to it, where they're like, oh no, you weren't drunk. I just hadn't seen that in my 30 years of practice.
Yeah, I guess the challenge that we have is with the original language, the core issue is operation, right? At time of operation. There's nothing that I can use, there's no technology right now that enables me to know what somebody's alcohol concentration is at the precise time of driving. It'd be different if a vehicle was equipped with something that would provide me with that information. I'm just being lazy law enforcement and not getting it. It doesn't exist. So it's kind of like the burden that you're holding to law enforcement currently with that language is that technology doesn't exist. I can't get you that information.
All I'm saying is that I haven't seen where they actually had a blood draw that said it was 0.08. I've never seen where they didn't find the person like being intoxicated.
So,
that's all I'm saying.
Yeah, we've had recently, a month prior to Sergeant Gutierrez's case, another intoxication manslaughter. Stephen Long was killed by an impaired driver. That person was a 0.18 right at 2 hours after the crash. And the toxicologist testified it was possible, because we didn't have the information needed for them to perform the retrograde extrapolation. So they're forced to testify that it's possible that somebody's under an 0.8 at the time of driving within that 2 hour window. Not necessarily that it's reasonable that somebody would drink that way. And that resulted in an acquittal of that case. And he was twice the legal limit within 2 hours. So it's happening, unfortunately, in our county.
Thank you.
Okay.
So let me. So, I mean, when I was in Harris County DA's office, it was back when we had no refusal nights, right? And I always did those because we got time and a half, and those are always fun nights to work. And so I know exactly what you're talking about because I ran warrants. I did the warrants for those cases, and I mean, I think as long as the fax machine was working, I think your turnaround time on those is like maybe an hour, and they're already at the location.
What year was that, if you don't mind me asking?
Like 08 to 11. And then the one time the fax machine stopped working, I physically ran the warrants, like in my Subaru, at breakneck speeds through downtown to the courthouse. And even with the fax machines not working, I mean, that was like maybe a 2-hour turnaround. I know you guys haven't talked to us about this before, and I'm having trouble following the logic of why we're doing this, okay? And I know you say like, well, we have no device that ever tells you what their BAC was at the time of the driving. We have never had that device. It has never existed. I mean, unless they had an interlock in their car and blew at that exact moment,
Right.
We've never had that ability, but we've always prosecuted cases. And even before we had no refusal nights and we got blood draws, we did no test, no accident cases, jury trials all the time, right? And we would prove up these cases without a blood draw, without a breath sample, without a lot of stuff. And we still did it because that was our job. And I don't, maybe I'm listening to it the wrong way, but what it sounds like you're telling me is our experts are giving more nuanced answers than we would like. And I would say, like, on that last example that you talked about, was like, my question is like, well, what kind of questioning did we get to get to the point? Like, did we go and follow up with the experts? Like, hey, you said you can't be sure, but like, let's be, we can't ever be sure about anything, right? But how sure are you about their intoxication at the time of driving? And he said, we can't know exactly, but like, look, the police officers searched the whole scene. There was not extra bottles of alcohol laying around. There were not broken glass. There's not spilled alcohol inside the cab. There's not all these other things that suggest that the defendant might have consumed the alcohol afterwards, after the accident, right? And you ask bring a police officer back, hey, you search your vehicle before you put the defendant back there? And they say, yes. Did you find any alcohol back there? Like, no. After you took the defendant out of the vehicle, did you search the vehicle again? Yes, that's standard procedure. Did you find any empty alcohol bottles? No. Did the defendant have spilled alcohol on his body when you brought him into intake? No. And so, like, an expert would say, my guess, based on all the DWA trials I've done, I would get my expert to say, like, look, we can't be exactly sure, but what they're saying and suggesting is not reasonable. And given everything that we know about the scene, about the incident, and whatever witnesses have said, they would say, like, if they try to argue, if they're saying that they consumed the alcohol after the accident, it is theoretically possible, but highly, highly unlikely and not supported by the evidence that we have. Right? Wouldn't that be? And whether or not the jury buys that, but whether or not a jury buys that and believes that witness or believes the defense instead, that's the job of the prosecutor. That's the job of the defense attorneys.
Ideally, I would love my experts to testify that way. What the change has happened in the last year is new guidelines set by the Society of Forensic Toxicologists, right, or SOFT. So they were given very specific guidelines when it comes to performing retrograde extrapolations that now everybody nationwide has to abide by. So I think that plays a factor in, and they give them guidance on how to testify regarding this specific thing. So a lot of the times that's what they're saying is it's possible that this is happening, but there is no evidence of open containers in the vehicle or anything like that. So the purpose of this bill would to close that argument, unless there's evidence to the contrary of that. If there are open containers, they do take a snapshot of them downing an entire bottle of whiskey right before they take off and drive, well then, of course, all of that needs to come in.
But I'm saying, instead of making the law say that for the prosecution, shouldn't the prosecution, in their case in chief, saying, we think the defense is going to argue this, this, and this, because everyone argues those things. Here's why those things don't fly, right? And close it off out. Why, if you have met minimum proof that it was .08 some point after the blood draw, right? Why then create a presumption then that the defense has to come and rebut? And then the thing is, defense would have to put on evidence and would have to put on the defendant. What if the defendant just says, I refuse to testify, I don't want to testify, I'm invoking my right to remain silent. And so they're not able to defend themselves because they're maintaining their right to remain silent, but we've created this presumption against them, but not proven the core element in question. Why not just prove the core element?
Yeah, we still have to prove each element of it. So it's not like
No,
just
not
because they
anymore.
are.
No,
it's-
but
we
if you
still
have
have to
this-
prove operating. We still have to prove that testing
Right.
is correct and accurate and all of that stuff. So we still would have to go back and prove all of that.
But
It's just we're eliminating the argument that of a fictitious.
Right. No, one of the elements is that they were intoxicated at the time of driving.
Yes.
Right? What you have proved is they were legally intoxicated at the time of the blood draw. Correct? The evidence you have is that they were legally intoxicated by law at the time of the blood draw.
Correct.
And you're saying because they were legally intoxicated at the time of the blood draw, we should presume that they were legally intoxicated at the time of driving.
Unless there's evidence to the contrary, like open container in the vehicle, spill.
I just want to make sure I didn't misunderstand that.
No, you're.
No, it's all you.
Ms. Jones?
As it relates to what you and Rep. Wu said, like if you switch the burden, you literally are lowering the bar for the state. And it now means that the state does not have to prove each and every element of the defense beyond a reasonable doubt, which I think flies in the face of the Constitution. But I thought about whether I should say this when you gave the example before of the acquittal.
Sure.
The first thing I thought when you said it was the prosecutor didn't do a good job. And I don't know the facts of the case, but like I said, that's like about a slam dunk as a prosecutor can have when you have a test that says .8. I mean, for most of my clients, it's like, okay, I'm gonna need for you need to let me work out a deal for you to some time. Because we got something scientific, right, that said it. So, like I said, I wasn't gonna say anything, but I just have problems changing the law and changing a constitutional burden that is deeply entrenched in the Constitution of these United States of America. And it's one of the reasons why this country was founded, because of like one bad result or because somebody didn't do what they were supposed to do. And believe me, there are times when I go to trial and I've gone up against prosecutors who knew exactly what they needed to do. And then I've gone up against prosecutors who I thought, I want to try some more cases against them, right?
Right.
But I don't think that's cause to shift something so important, especially like I say, in cases. And this doesn't have anything to do with. I don't think that it disrespects anyone who died from a drunk driver. That because I think that the Constitution is bigger. The United States Constitution is bigger than anybody in this country. The Constitution should protect the least of us from a powerful government that has should have every opportunity to crush the little guy. And so that's just telling you that. But I respect what you do. I know you see a lot of really bad stuff in your division particularly. And so thank you for what you do. And I don't know if I could do it because I know that you probably need some mental health stuff because you see really bad stuff.
So anything else, members? Mr. Cook?
I missed part of your testimony, so forgive me if y'all have already covered this, but I'm assuming you've seen this bill, right?
Yes.
Does this bill give you any more opportunity to take a blood draw than what current law exists?
No, it doesn't change anything in the way that we currently
So
investigate DWIs.
these constitutional rights and all the stuff
Correct.
that we're
No,
talking about.
we still do everything the exact
has
same
nothing to
way.
do with this bill, right?
Correct.
This bill says that if you were drunk at 3:00 p.m. when the test was taken, and as opposed to 2 a.m. when the offense took place, you were probably more drunk at 2 a.m. than you were at 3 p.m., correct?
Correct.
So you're actually getting a little bit of a bogey because it's 6 hours later, 8 hours later, or
Correct.
something like that.
Yes.
I think it's a
Yes,
great
sir.
bill, and I appreciate you being here.
Thank you.
Yeah. We appreciate, anything else, members? We appreciate what you do every day, and thank you for taking time away from that to be here today.
Thank you, Chair.
Thank you very much. Thanks. Okay, we have Michael Hanover here. Now, Mr. Hanover, I've got to clarify one thing with you. I hate to be a stickler for this.
No,
but
you do.
Once again, we're just trying to protect the bill. So we've got two affirmations that you've signed, one as Assistant District Attorney in Harris County, and the other one was in that position and on behalf of yourself. So
I intend to testify both as a representative of the DA's office and on behalf of myself.
Okay, and so does the clerk have your permission to delete the affirmation statement that you made with just your position?
Absolutely, and I
Okay.
apologize for the
Oh,
error.
that's fine. I just had to get that cleared up for the record. Thank you, sir.
No problem. Good afternoon, Chairman Smithy, Vice Chair Wu, and committee members. My name is Michael Hanover, and I am here representing the Harris County District Attorney's Office and myself, testifying in support of House Bill 2984. And thank you to Representative Curry for sponsorship of this bill. I've been with Harris County for approaching 8 years now and recently served as the chief of the Vehicular Crimes Division, where I supervised 6 prosecutors handling our county's intoxication manslaughters. I was a trainer on our office's vehicular call-out team, where I responded to fatality crash scenes weekly. The most difficult part of my role was meeting with the families of deceased victims and telling them that based on our evidence, our chance at justice through a jury trial was low because we could not extrapolate the defendant's blood alcohol content from the time of the test back to the time of driving. In Harris County, the time lapse between driving and a test is usually 3 to 5 hours, which is spent performing a preliminary investigation, writing and transmitting a blood search warrant, finding a judge, and then transporting or traveling to a medical facility. We are left then with 2 points on a long timeline: a crash or a traffic stop and a test, and a lack of information between them regarding our particular suspect's biological processes of absorption and elimination of alcohol. Without an investigative lead on where that driver was coming from, we often cannot responsibly extrapolate blood alcohol back to the time of driving. A defendant who truly was not intoxicated at the time of driving will have the ability, under the proposed new law, to overcome the rebuttable presumption as written, as they have access to the relevant evidence on that point. This will not make cases too easy to prosecute. In everyday DWI cases, the state will still need to lawfully obtain a specimen and prove intoxication prior to when a suspect sobers up to below 0.08. And in fatality cases, will continue to carry an additional burden of proving the suspect's intoxication was also the cause of the crash. I'm committed to working with you all on this issue, and I respectfully urge favorable consideration of House Bill 2984. Happy to answer any questions.
Thank you, Mr. Hanover. Any questions? Mr. Little has a question.
Thank you, Chairman. Mr. Hanover, I just wanted to ask you, how many intox manslaughter cases do you think that you ended up with acquittals rather than convictions as a result of not having this rebuttable presumption?
Would be hard to quantify. It's many. It's many. It was several in the course of 2024. And now, you know, when you say acquittals, I guess I'm including in that cases where we had a specimen over a 0.08, but perhaps our suspect was so injured that in the crash that we had no standardized field sobriety tests, in other words, data about their behavior and the impact of alcohol on their body at the time of the crash. And the law, as it's currently written, is telling juries to look for biological evidence about a suspect's absorption and elimination of what they drink that we simply can't provide in many cases. And so it's many, sir.
I'm struggling to understand that because when you have a suspect who's injured, you're getting blood from them and it's being tested later, correct?
That's correct.
And so you extrapolate back in time, and obviously they're not getting more drunk with the expiration of time, right? So why is this evidence not of a sufficient probative quality to get you a conviction? If somebody gets in a horrible wreck, harms other people, you get a blood draw, 2 hours later it's tested, it's a 1.0 or 0.08, or I'm sorry, 0.10 or whatever it is, that's above the legal limit, what's the problem?
So in order for us to, a big part of the problem is that forensic testimony has to be responsible and based in the science, and it has to give benefit of the doubt to the defendant. We don't want to push outside the boundaries of where the science will let us go and convict somebody based on that kind of testimony. And so in order to perform an extrapolation and go from time of test, BAC, back to time of driving, we need information including whether or not the suspect had a full stomach. When did they consume their last alcoholic beverage? What kind of beverage was it? How much of it did they drink? And it also boils down to their physiological makeup. What is their body mass index? And all of these variables are things that innately the state doesn't have access to the information on them unless either the defendant was coming from a bar and we can get video of every drink that they took and so we know it, or the defendant tells us. And then the credibility of that becomes the question. And so the argument that we hear and we struggle with from the defense side in these cases is the state gave you no evidence to show that my client didn't drink 3-4 drinks or whatever in the hour before they got behind the wheel and therefore was still absorbing that alcohol at the time that they were driving.
Yeah.
That's the problem.
I understand that. I've got a couple problems with the bill. So you look in the proposed section 49015, it says that the rebuttable presumption is created if it is shown out on the trial of the offense that an analysis of a specimen of the person's blood, breath, or urine showed an alcohol concentration level of 0.08 or more. The term analysis is not defined in Chapter 49. I mean, as close as I can tell, I could have a suspect blow on my phone. There it says 0.08. How do we know what analysis is required by the statute to yield a 0.08 blood alcohol content? So that's one question that I have.
Sure.
The second one, and I think we're clarifying here, if there's a rebuttable presumption, the hair on the back of my neck stands up every time I hear rebuttable presumption. It's once you show it, the burden of proof shifts to the defendant to rebut it and offer proof rebutting the presumption. Isn't that right?
Yes, sir.
Okay. So maybe you can address those two items for me.
Sure. Let me tackle the first one. As I understand the way that House Bill 2984 is written, there is still the ability of a jury to disregard the credibility of the analysis that's put forth as evidence by the state. And that's the way that the law is right now. So if we were to say offer into evidence, blew on a cell phone and the 0.08 like you just showed us, we wouldn't be meeting our element of showing a 0.08, and I don't think anything about that component is changed by the
I think
addition.
it creates a presumption. I just need an analysis. Blow on the phone, blow on a piece of paper. It's not clear to me from the statute or the chapter what the criteria is for an analysis that meets the evidentiary burden to create the presumption. You know what I'm saying?
I do know what you're saying. My point is the way that I read this as a prosecutor and the way that I would employ it would be that it doesn't change anything. The jury still has the ability to disregard the presumption if my evidence is not credible that tells them to apply the presumption. And
I'm tracking you.
I'm very convinced that that's the case.
I'm tracking with what you're saying.
And then,
Thank you.
can you remind me, you had a second point there that I got focused on the first.
Well, it's the rebuttable nature of the presumption that it
Yes.
does, it does shift the burden of proof. So, I mean, you agree with that, right?
I do, but it's more nuanced than that, if I can elaborate.
Please.
I don't see this as burden shifting because the state still has to prove the element of intoxication. What this bill does is it tells the state, and it tells all the citizens of this state, that a sample of blood or breath at some period of time after the crash that came back over a .08 is such powerful and convincing evidence that we're going to say, without something to take away from that evidence, that's enough to meet the burden. The state still has to prove intoxication beyond a reasonable doubt.
I'm tracking, I understand the point that you're making. Do we have other rebuttable presumptions like this in criminal law that I'm not aware of?
Yes, sir, we do.
Like, can you give me some examples?
I sure can. There's one in section 32.55 of the Penal Code. That one is regarding financial abuse of an elderly individual. And forgive me, Representative Little, I may not have a subsection.
Don't worry about
to
that.
give you.
I'm putting you on the spot. And
But that's a situation where we gave a rebuttable presumption that the use of an elderly person's money is wrongful if it's shown on trial that the actor who used that money knew that said elderly person had dementia or Alzheimer's. And again, I'm not quoting, I'm paraphrasing, but that's one. I've got a couple others.
that's kind of a novelty. That's come into the criminal law, or into the statute in the last few years, right?
I don't know.
I wasn't here, but I'm looking at the added by acts. It looks like 2021, 2023.
Yes, sir. There are others in the fraudulent use or possession of credit or debit card information statute. There's one in interference of public duties. And then there's an additional one in the theft statute, which I would argue is one of the most widely used criminal statutes that we have.
Okay.
That one is, it says that an actor engaged in buying or selling secondhand property is presumed to know that that property is stolen if they fail to record basic information regarding how they acquired it. And so again, for the state to be able to take advantage of that presumption,
Yes.
we have to give pretty significant proof to even get into the land of it applying.
Yes, sir. And I know you have a very challenging job and you're doing very important work, so I appreciate your bearing with my questions.
It's no problem at all, sir. Thank you.
Thank you.
Any other questions? Ms. Jones? Oh, I'm sorry. Ms. Jones?
Hey, Michael.
Hello.
Y'all, I remember when he was a baby prosecutor in Harris County. Now look at him over whole divisions and stuff.
It's good to see you, Representative.
Absolutely. Couple of things. The first thing you said something is a powerful, don't remember your words. You said such a powerful piece of evidence that it's not a big deal, I think I'm paraphrasing, to shift the burden.
So,
is that what I heard you say?
Certainly not a big deal. Anytime a burden goes one way or the other, it's a huge deal. What I said was a specimen above a .08 at some time period after the time of driving this bill is saying that is such a powerful and convincing piece of evidence, and it's scientifically backed as well, and therefore we're going to say that the state has met its element on intoxication if they can show that, and in the absence of something to change it.
So, to that point, a lot of times when you have lay people in the jury, which again, the jury system I think is the best system in the world.
I agree.
Right? When people come in and they're experts, I mean, you got to certify somebody as an expert, that they have like extra training and whatever. When people come in uniform to testify, people sometimes give more credibility to the uniform. In fact, I know for a fact in Harris County, if law enforcement is testifying for the state, they can wear their uniform, but if they're testing for the defense, they literally cannot wear their uniform, which I got a whole opinion about that.
I actually didn't know that.
Okay,
Rep.
well,
Jones.
newsflash, that's what happens. But, so there are so many built-in things to the system that, like, for example,
the jury sits by the state, not the defense, right? They're just all these sort of things. And so I think that when an expert, because that's who's going to be testifying for the most part to whether somebody's legally intoxicated, whether it's the Harris County Forensic, is it the Forensic Center or whatever they're
Houston Forensic Science Center.
Houston Forensic Science Center or whomever, I think that they should, and I think that it's no little thing. I think it's always a big deal when you mess with the burden of proof to the Constitution. The second thing I was going to say, and I was praying about whether I was going to say this or not, but I'm just about to put this out there in the universe. The defense bar in Harris County had a whole bunch of success under the previous DA. DAs weren't always trained. You had chiefs sometimes who had 2 or 3 years of experience in whole courts when prior to that, before you were a chief, you were there 7, 8, 9, 10 years, and you just had to wait your turn. And you had literally had the opportunity to be in every division of the DA's office, so you could actually learn something, right? So, but now there's a new sheriff in town, DA in town, pun intended, where I'm hopeful that the DAs are getting better training. And so I think that the success or not level of the Harris County District Attorney's Office in the relatively recent past, not after January 1st of 2025, should not be indicative if somebody got acquitted under that regime. Because we defense lawyers were looking super smart and super good. Because I'm just going to put that out there in the universe. And so, again, so anyway, that's all I have to say. But unless you want to say something in response.
I hear you. You know, as a prosecutor representing crime victims all day, every day, we can always be better. This bill is not about Harris County specifically. It's not about any specific case or any specific acquittal or dismissal or what a prosecutor did or didn't do. It's about bringing the law up to being consistent with the science on this issue, and it's about the entire state of Texas, and it's about whether or not we're okay with telling juries to look for evidence that shows that a person who's a .14 3 hours after a crash didn't drink 6 beers in the 30 minutes before it happened? Or do we say, we're not okay with that guy being out on the road with our family members? And that's what this is about, not any specific case.
Thank you for being here. We appreciate it. Do you have a question?
Just real quick.
Mr. Wu has a question.
I'm sorry, just real quick. One of your answers earlier struck me is you said that the jury still gets to make the decision. That's kind of what I had problems with is the way I read this bill. It says there's a rebuttable presumption that the person was intoxicated, which is the core of the offense, right? At the time of the offense, if it is shown at the trial that an analysis of a specimen in a person's blood, breath, or urine showed an alcohol concentration of 0.08. It doesn't say that the jury finds that this is true. It doesn't say a judge finds that it's true. It just says that it is shown. So if at trial, the way I read this, if at trial a person just simply brings in a 0.08 blood test, and that question of intoxication is now complete. That's it. I mean, the jury doesn't have to find that they believe the 0.08 because that's not what's in here. The jury, it just says, if you show that there was a blood alcohol concentration of 0.08 or greater, then there is a rebuttable presumption that those elements of the offense outside of time and jurisdiction have been met.
I think that the key phrase in the language in the bill is shown on trial. There are other things that I have to show on trial as a prosecutor. There are things that I have to prove. I don't just get to throw any old exhibit in and establish a fact. To show something on trial, to me as a prosecutor, means you better prove it. And in addition to that, the rebuttable presumption doesn't take away the ability in any way to attack the credibility of the quality of the specimen, the lawfulness of the taking of said specimen.
I get that, but the way this is written to me does not include that. This just says if they're at trial, they put on evidence that this shows that it's .08, it is done.
That's not how I'm interpreting it. I believe I've got to show it on trial, meaning I've got to prove it. And now I think also the similar language, like that's something that.
But again, like a show at trial, like what is the level of proof at trial? Because like again, the statute says if it is shown on the trial that this is true, or that there was an alcohol concentration of .08 or more. There's not like a evidentiary hearing. There's not a like the judge has to find this, the jury has to find it by preponderance, clear and convincing, or beyond a reasonable doubt.
Let me say this. I believe that even within, in another place within 49 of the Penal Code, there's similar language, and that is if it is shown on trial that the person's blood alcohol content was a 0.15 or above, there's a punishment enhancement.
But that's a punishment enhancement. The guilt has already been established.
My point is, Representative Wu, is that same language requires proof beyond a reasonable doubt in another setting. I don't know why it wouldn't with this particular setting. That if it is shown on trial language is what I'm focusing on.
Because we're still in the middle of the trial. Like if you're saying in punishment phase, we have to prove up those. I mean, the prosecution has to prove up those prior convictions, right? Or the enhancements.
Yes, of course.
Right? And most of those enhancements, especially like deadly weapon and all that stuff, would be done in the trial itself.
Yes, commonly, yes.
So, again, I mean, like if it's an aggravated assault with a deadly weapon, proving up the deadly weapon is a part of the elements of that case.
In that particular case, yes.
Right.
There are others that wouldn't be like that, of course, but.
Okay. And again, that proof of beyond a reasonable doubt, that's to the judge.
Well, it would depend.
Or jury.
Yes.
Right? And you would still
It's
have
to a
to
fact
prove
finder.
that up individually, piece by piece. Like you would have to bring the convictions in, right? And you would have to show that you bring in your business record affidavit and do all that stuff and prove them up beyond a reasonable doubt that they're true.
Yes, sir.
Okay. I get that, but what I'm saying is here, this part is in the middle of the trial, right? No guilt has been established, but my concern is that you're saying that if they just, the way I read this is by merely showing that this is .08, that there is a blood or breath that's over .08, then the way I read it is that the question of intoxication is now closed, unless the defense puts on evidence.
I respectfully disagree with that reading.
I think we could clarify that.
Yeah, I agree. But I believe that with this new bill, for the state to avail itself of the proposed rebuttable presumption, we have got to prove beyond a reasonable doubt, we've got to show on trial that there was a specimen taken above a .08, whenever it was.
I don't want to belabor this point, but this is the way I understand this. The criteria and recommendations from the forensic and from the scientific community has changed. What they, and correct me if I'm wrong, they have basically said the way we've done these extrapolations in the past were probably a little too loosey-goosey, right? And we're going to have set higher standards for what we actually can extrapolate and the way extrapolation is done. Is that fair?
I think as the science is changing, our toxicologists are adapting. Yes.
Our science is getting better. Our scientists are taking that new science and saying the way we did stuff in the past probably wasn't right. It probably could have been better.
There has been a shift based on the science and what the toxicologists are willing to testify to, yes.
And because of the new science, toxicologists are now more hesitant to give the exact answer that you want.
We're not as able to get extrapolation testimony as we were, yes.
Right. And what you're asking, so because there's this change in the science, because the science that you have in front of you is not as good and not as convincing as it used to be, we're going to take it and just change the standard.
I'm not ever looking for any specific testimony. I want the truth, and the truth is that somebody who is a 0.12 or a 0.09 or whatever, however many hours after, that is such convincing proof of intoxication at the time of the crash that I don't believe additional evidence should be required about their biology.
Exactly. So why can't we just have an expert get on the stand and say, hey, I've done this for a long time. This is like 1.2, like 3 hours after is really convincing. There's possible ways that they might have consumed this alcohol or alcohol got into their systems after the crash. Or maybe they had they sucked down like 10 beers, like 5 seconds before the crash or something like that. But the experts say that's completely unreasonable, and it is irrational. That it's unsupported by the evidence. Why can't they just do that?
Well, first of all, that's not the testimony that they're willing to offer, and second of all, I think that the law can and should move with the trends in science, and the current law is telling juries to look for evidence about a specific person's biology that we don't have access to the information to provide. It's literally within them, and so what we're asking is that the law be adapted to reflect that reality and keep our roads and streets safer.
Thank you. Anything else, Mr. Cook?
Would Penal Code 205 dealing with presumptions, wouldn't that apply here? Wouldn't you still have to submit this presumed fact to the jury for determination? Isn't that correct?
That's how I'm interpreting it. However, before I commit to that, I'm not familiar with the exact language of 2.05.
Let me read it to you. It says, except as provided by subsection B, which has nothing to do with this. It's when a presumption is in favor of the defendant. When this code or another penal law establishes a presumption with respect to any fact, it has the following consequences. Number one, if there is sufficient evidence of the facts that give rise to the presumption, the issue of the existence of the presumed fact must be submitted to the jury. That's pretty spot on, right?
That's exactly correct.
Okay. All right, thank you.
That's sort of become second nature to me in practice. I don't take it for granted that I can just put any...
Because the judge can still, it says, unless the court is satisfied that the evidence as a whole clearly precludes a finding beyond a reasonable doubt of the presumed fact. So the judge can make that determination, but...
And prevent me from using the presumption, yes, also. Is that...
No, I don't read it that way. It says, unless the court is satisfied that the evidence as a whole clearly precludes a finding beyond a reasonable doubt. So I think it would only be...
That would be a judge telling me, you didn't even get close, you don't get the presumption.
Yep. All right, thank you.
Yes, sir.
Anything else? Thank you for being here, Mr. Hanover.
Thank you, everybody.
We have Jennifer Tharp.
Good afternoon. My name is Jennifer Tharp. I'm the elected criminal district for Comal County. I'm testifying in support of HB 2984.
And you're also here on behalf of yourself?
Yes, sir.
Okay, thank you very much.
Thank you. Representative Cook, you stole my thunder a little bit with 2.05, but I'm glad you highlighted that because the penal code actually lays out what is that process of when and how a presumption can come into play. So presumptions come into play in the form of a jury charge, but before it could even come into that form of a jury charge, there's first a gatekeeping function that the court is going to do. Number one, is that presumption appropriate? There were some questions asked earlier about the type of analysis. What's confusing perhaps on the fact that there is no definition of analysis in the penal code, it's because it's actually in the transportation code. So in Chapter 724 of the Transportation Code, that's where it lays out the type of breath specimens that can be collected, as well as the type of blood specimens that can be collected. It also lays out the rules with regards to consent. When is it truly consent? But again, it's a little confusing because it's in the Transportation Code and not in the Penal Code. And so if you're not doing DWIs on a regular basis, it's not necessarily an area of the law that you would look to. But circling back to this presumption and why it's important, I was sitting here listening to all the testimony and the great questions of, is this truly going to shift the burden from the state to the defendant? And one thing that I think that has perhaps gotten lost in the testimony is, at the end of the day, the state of Texas has to stand up and prove each and every element beyond a reasonable doubt. And so let's take DWI and, I apologize.
Oh,
Okay.
You're on yellow still.
Sure. So if you take DWI into account, I have to show on or about a certain date in Comal County, this defendant was operating a motor vehicle on a public roadway intoxicated. Because the statute to make it criminal says at the time they were operating, that's where this huge disconnect is. Because as the officer tried to testify, it is impossible to get that specimen collected immediately at the time of operation. I will tell you the average time for us is about 2 to 3 hours to do a blood draw. We are a no refusal county. What that means is we have judges who are willing to be on call 24 hours a day, 7 days a week, 365. In fact, I have one of my local judges here, and it is not uncommon for him on a busy weekend to get a phone call at 8 p.m., go back to bed, midnight, go back to bed, 4 a.m. And so understand that blood is taken pursuant to Transportation Code 724. It's done in my community by one of my main my law enforcement jurisdictions at our hospital. And so that builds in some of the time and the delay. So what this is doing is giving, if appropriate, and if first the judge agrees with that gatekeeping function, an instruction to the jury. But please understand, it does not change the burden of proof. The state still has to prove intoxication. Okay. And if there were issues with how it was collected, we're not even going to that presumption.
Okay. Any questions, members? Thank you very much. Oh, I'm sorry, Mr. Moody.
Just to walk through it. Doesn't change the burden of proof. Does require defense to proffer evidence if they want to rebut that presumption.
Correct.
So burden of production. So in DWI prosecution, which I had the privilege of doing quite a bit of back in the day, you've got the alcohol concentration set out as intoxicated, and there's the impairment definition of intoxication. So you've lost the normal use of your faculties, all that other stuff. And if you got a test, and back, like Representative Wu talked about back in the day, sometimes we had a bunch of cases that didn't have tests, so you'd be trying it on the impairment definition. So you're looking at field sobriety tests, or if they're in an accident, you're not going to really get that, but then you're looking at the accident or alcohol on the breath of the person. If they go to the hospital, maybe you get a blood draw that way. You've got where are they coming from, where are they going to, what time of night is it? All these other factors that come into play that start to build the evidence that this person was driving while intoxicated. And I think the concern is going to be, what sits over the top of this conversation for me is, I understand where we're trying to get to preclude the situation that family talked about earlier. If we have more certain prosecution of driving while intoxicated, maybe there's an opportunity to keep people from doing that in the future, and so you don't have tragedies. I do think the net effect of this bill would make it much easier to prosecute these cases because you're building the presumption in. Now, I think that's the net effect. You're going to get more convictions, you're going to get more pleas, because if you have the test, unless the test was done some out of whack or whatever with whatever type of standards we have, you're gonna get the rebuttable presumption. And the way it reads in 205, right? It said that they still have to find it beyond a reasonable doubt. The jury charge is very specific. The judge has to say it this way: the facts that giving rise to the presumption must be proven beyond a reasonable doubt. So the facts giving rise to the presumption in this case is there's a test that is 0.08. Those are the facts. That's it. And so if the test is valid and there was no violation of rights there, violation of rights probably come before trial anyway. But at any rate, and if those facts are proved beyond a reasonable doubt, the jury may find, and it says you don't have to, but you still may find that element exists. So the jury does have a role here, But I think the concern that I'm hearing is it's leaning in towards, while I think functionally the burdens are all the same, it's leaning towards pushing up against the defendants, kind of pushing up against the defendant. You're going to make these convictions pleas easier to attain, which if that is the goal, then I think that's what we should just state here. The thing that sits over the top of it for me is the presumption of innocence, right? That's where we have to start with. And is this knowing that we want to preclude people from killing folks on our roadway, is this a fair administration of this particular law when that piece of evidence is more likely than not going to be in the jury charge as a presumed piece of evidence? And so that's just the question policy-wise. Do we want to do it? We do it in very select places, in other crimes. And so it just comes down to, is this something you want to do? Because I think the net effect is more convictions, more pleas on these particular offenses.
And I think you raised some very valid points. And I think what is good about the way Representative Curry crafted this bill is it only comes into play if the BAC is 0.08 or greater. And so it's not coming into situations where your BAC concentration is lower than that. Second, what I would say is the same committee contemplated a presumption in another area of law. It was endangerment of a child. As a body, we've recognized that if a child is in close proximity of an adult in possession of methamphetamine and that child tests positive for meth, there is that presumption that it was done with that intent to harm that child. We've recently looked at expanding that to fentanyl. I think as a society, we've recognized the need to protect children in that regard. I think the argument could be said the same. There is a need to protect Texans on Texas roads from drunk drivers. It's very dangerous, not just for everyday moms, dads, children, but also law enforcement. They're putting their line on the lives every single day for each and every one of us.
Yeah, like I said, these are constructs that we have in other places, and so that's mainly what I wanted to raise. Is this is a policy consideration, whether we want to, and I think it tips the scales. I think legally it's passes constitutional. We have this right, so but it will. The net effect of this is going to tilt the scales against the defendant, against defense counsel in court. That's the net effect, in my opinion, what's going to happen actually in the courtrooms. And so that's just, whether that's where we want to go policy-wise on these offenses, I guess, is what this committee has to consider.
May I add one point to that aspect? In the same vein, there's that balance because in prosecuting that case, if I've got to then go find an expert and then go spend tax dollars on tracking down an expert to then do that extrapolation, there's a balance of that too. And understand, it's in terms of presumption of innocent, we're talking about first that the judge has found that that test was legally obtained and it was a proper procedure on how the analysis was done. And if that is a situation and the blood alcohol concentration is greater than 0.08, it can be argued to the jury that if it was greater than 0.08 3 hours after the traffic stop, it was 0.08 or greater 3 hours earlier when that officer conducted the traffic stop.
Oh, yeah,
so I think it's a careful balance, but
I agree.
That's just my perspective.
I think that's kind of the balancing act when you look at something like this. One other question: there's no time limit, and I don't know that we want to dabble in that, but this presumption applies if the test was acquired 1 hour, 2 hour, 3 hour, 4 hour, 5 hour, 6 hour. There's no. Now at a certain point, obviously, it all dissipates. But so you're talking about probably that range of time. I've heard the arguments rising, falling, whatever. But then, do you think there's any wisdom in trying to bring that presumption within a certain amount of time?
So you raise another good point, and because Texas is so different, there are areas of Texas where, and I think you even have a bill later on today that talks about who can draw blood, because there are areas of Texas that do not have access to phlebotomists in a jail to do a blood draw. They are limited on hospital facilities or medical facilities to draw that blood, and so where do you come up with that time period? And so if that is a situation, again, I think you lean back into 2.05 of the penal code because that judge, their job as the gatekeeper is to look at each and every case. You would have a situation that is done within a short time period, but the judge, listening to all the evidence, is like, no, this presumption is not appropriate.
No, and I get that. I think on paper that's true. I also do think, I mean, we continue to elect our judges in partisan elections, and they are responsible for the community as well. I have
Absolutely.
a hard time believing that many judges are going to keep this out of the jury charge when it could be put on their desk that it's a public safety concern. I don't know that it'll be, and my father's a judge, so I would tell him this as well, but I think they would feel a pressure outside of what's really presented to make sure that doesn't come back to home to roost on them. So I'm just saying, these are the practical implications of doing something like this. It works. This will pass constitutional muster. It's just depending on, are these the types of policy considerations that we want to put in play? So this has been a great conversation. I always appreciate your testimony, so thank you.
Anything else for Ms. Tharp? Okay, thank you for being here.
You're welcome.
The chair calls Allen Place. And members, this would be a good time to make an announcement. We've got some things we need to vote on. We're still missing Ms. Jones. Why don't we say, if y'all can plan to be here at around 5, as close to 5 as possible, we can vote then. Is that okay with everyone, or is it okay? And so hopefully we'll get Ms. Jones back at that point. I'm sorry, go ahead, Ms. Place.
Thanks, Mr. Chairman. My name is Alan Place. On behalf of Texas Criminal Defense Lawyers Association, I'm speaking against the bill. I would state, first of all, this bill, Representative Cook, does really two things. In regards to the comments you made earlier, I want to just focus on number one, look at Penal Code 2.01. Basically, what that says is all persons are presumed innocent. I'm just reading the actual bill as it's laid out. And basically, the headline is rebuttable presumption of intoxication. It says there is a presumption a person was intoxicated. That is the fact that you have to appear, the state has to prove. And by putting a presumption in here as opposed to the other nuanced ones that were mentioned earlier, I don't know if anything is fundamentally changing the burden of proof is this. And that's the first part of this, okay? The second part of the bill, and before I get into the extrapolation issue, this is just the fundamental part of our Constitution, is that the state has to prove the matter, and this is basically giving it to the state, basically, in some sort of charge that, yes, this is it. We think that fundamentally runs afoul of our basic fundamental system in Penal Code 2.01, that is the presumption of innocence. The other thing is every DWI case that's ever had, there's going to be time between the accident and the time that there is a blood draw or a breath test, okay? So that this is not new. There's always going to be that period of time. And so we have science, and we've always had science, and it may be getting better. But ultimately, the circumstance is the crime has to be proven at the time of the operation of the driving, not 1 or 2 or 3 or 10 hours later. So it's completely contrary to what has to be proven. The other thing that I want to point out to the committee, because this is not something that you do every single day, in the Penal Code 49, we have the definition of intoxication, and one of it is if it's 0.08. So in other words, in voir dire, during the trial of the case, during closing, the state will be able to show that if they have proven the fact that there is a blood draw or a breath test of 0.08, that is the legal definition of intoxication.
Okay. All right.
Okay.
Any questions, members? Okay, we appreciate you being here.
Thank you.
Mr. Place. Anyone else here to testify for, against, or on House Bill 2984? If not, Mr. Curry, you want to close?
Yes, sir. Thank you, Mr. Chairman. Thank you, committee members. I appreciate y'all's digging into these facts and all of the information that we've given. I would like to start by saying God bless the Gutierrez family and all the families and friends of those that are killed by drunk drivers, and understand that all we're all trying to do is just make this better. We're trying to make a better world for our families, for our children, for our grandchildren. I think I can honestly say that all of us are here to make sure that our children are safe and our grandchildren are safe and that their futures are safe. So I appreciate y'all taking the time to look into this as hard as you have. I am going to kind of note a few things very quickly, and then I'll move on. Number one, you do have a statement in front of you that was given, that it's either in your Dropbox or what have you, from the gentleman, Peter Stout, that was not able to be here to testify. He is a toxicologist, and then we'll explain, that should help explain different things. I have to tell you, I kind of, from a reasonable standpoint, I mean, I think that this is very reasonable. I don't need to sit here and read this to you again, but from my standpoint, it's pretty clear whether it's an hour or 6 hours or 12 hours later, if you, and I'm going to use this as an example, but if you've been in jail and you've been arrested and you've been incarcerated for whatever, or even locked in a car, a police car in the back or what have you, and you're still over the legal limit an hour, 6 hours, or 10 hours later, that should be enough proof that you were drunk when you got in the car. Not when you got in the car to go have the crash. I mean, if you were that drunk later, that's why the extrapolation process is not necessary in the opinion, and this what this paragraph should do, is prohibit the fact that you really don't need the extrapolation process, which could be a judgment issue, could be challenged, which is fine. I don't have a problem with it being challenged, and if necessary, then so be it. But if you're drunk later, then you're drunk when it happened. And that's, now, could someone go make an argument saying, well, I drank so much right before I went and got in my car and killed somebody? Yeah, they could. That's why you have defense lawyers, and that's why you have the ability to defend your position. But from my standpoint, I believe that simplifying this and saying, you know what, if you're drunk later, you're drunk when it happened, and good luck, especially if you killed somebody or otherwise. I mean, it's just bad. I'm going to disagree with the criminal defense lawyers that testified, just from the standpoint of the length of time should not matter. And I think that trying to pick this thing apart from an extrapolation standpoint, when this piece of the law should be very clear, is not the right thing to do. So I would respectfully ask y'all to pass this out of committee and as quickly as possible, and let's see if we can't get this moving to help out these DAs and other attorneys.
And Ms. Curry, I'm sure you'll be willing to work with some of the members if there's some things we could do where we could get this bill out.
Absolutely, I'm always willing to do that, and honestly, I've had no contact on it so far, but I'm happy to discuss that.
Okay. Anything else, members, from Mr. Curry? We appreciate you being here. Thanks.
Thank you. Thank you for your time.
So, thank you. So if there's no objection, the chair will leave House Bill 2984 pending for now. Yeah. So we need to vote on a couple of bills here. Actually, I think about 6 or 7 bills, and then we'll be done. So we've got everybody. Thank you.
Got it. Give me I got to vote in jury.
So, okay, I know, it's the next one. Okay, first, members, the chair lays out as pending business House Bill 74 by Representative Howard. This is a bill we heard last week that enhances safety measures for sexual assault survivors in their homes when using public transportation in the court system and with regard to their personal health. House Bill 47? Yes. Okay. So, Ms. Bowers, you okay with moving this? Okay, Ms. Bowers moves that House Bill 47, without amendments, be reported favorably to the full House with a recommendation that it do pass, be printed and placed on the committee, the calendar. Will the clerk call the roll?
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Aye. Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Aye. Representative Louderback? Aye. Representative Money? Aye. Representative Moody? Aye. Representative Rodriguez Ramos. Representative Verdell. Unanimous.
Thank you. So by 11-0 vote, the bill will pass and be referred to the Calendars Committee. Next, the chair lays out as pending business House Bill 463 by Representative Jones. This bill we heard a couple of weeks ago regarding expunction for certain drug offenses where a lab analysis shows no controlled substance present. There's been a substitute that I think has been distributed. Anyone have problems with voting on the substitute? So if none, Mr. Money will offer the committee substitute to 463. Is there any objection to the adoption of the substitute? There being none, substitute's adopted. And so Mr. Money moves that House Bill 463, the substitute, be reported favorably to the full House with a recommendation that it do pass, be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy.
Aye.
Vice Chair Wu. Representative Bowers. Representative Cook.
I'm a no right now. I've not had a chance to review.
Okay. Representative Jones.
Aye.
Representative Representative Little. Representative Louderback. Representative Money. Representative Moody. Representative Rodriguez Ramos. Representative Verdell.
So by 9-2 vote, the bill will be reported favorably and referred to the Committee on Calendars. This time, the chair lays out as pending business House Bill 1465 by Representative Hickland. This is the bill we heard last week that requires individuals convicted of invasive visual recording to register as a sex offender and defines what is considered a place in which a person has reasonable expectation of privacy for finding that such an event occurred. Mr. Cook offers a committee substitute, which I believe has been provided to you. Is there any objection to the adoption of the substitute? The chair hearing none, the substitute's adopted. And now Representative Cook moves that the committee substitute to House Bill 1465 be reported favorably, referred to the full House with a recommendation that do pass and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy.
Aye.
Vice Chair Wu. Representative Bowers. Representative Cook. Representative Jones.
Aye.
Representative Little. Representative Louderback. Representative Money. Representative Moody. Representative Rodriguez Ramos. Representative Verdell. 11-0.
By 11-0 vote, it will be reported favorably. Next, the chair lays out as pending business House Bill 1552 by Representative Paul. This is the one that changed the definition or references to child pornography in statute to child sexual abuse material. We had some fairly robust discussion on this. Does anyone still have problems they think they need to? I don't necessarily have to vote for it, but does anybody need more time? Representative Paul, Dennis Paul. So if not, Mr. Moody, are you okay with moving this? Okay. There's no substitute. Mr. Moody moves that House Bill 1552 without amendments be reported favorably to the full House with a recommendation that do pass be printed and sent to the Calendars Committee. Clerk, please call the roll.
Chair Smithy.
Aye.
Vice Chair Wu. Representative Bowers. Representative Cook. Representative Jones.
Aye.
Representative Little. Representative Louderback. Is that aye? Aye. No, he's not. Okay. Representative Money. Representative Moody. Representative Rodriguez Ramos. Representative Verdell. 10-1.
By a 10-1 vote, the bill will be reported favorably, referred to the Calendars Committee. Next, the chair lays out as pending business House Bill 1686, the bill we heard last week relating to the protection of privacy of sexual assault survivors. The bill prohibits live streaming of trials for certain sex crimes and protective orders unless requisite consent is obtained. First, allows survivors to use pseudonyms, prohibits the release of survivor phone numbers from the Open Meetings Act, and establishes certain discovery measures for confidential evidence. There is a committee substitute, and so Representative Money offers the committee substitute to House Bill 1686. Is there objection to the adoption of the substitute? Chair hearing none, the substitute's adopted. Mr. Money moves that House Bill 1686 as substituted be reported favorably, referred to the full House, with a recommendation that it do pass, be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
So by 11-0 vote, the bill will be reported favorably and sent to the Calendars Committee, the Committee Substitute House Bill 1686. Next, members, the chair lays out as pending business House Bill 1953 by Representative Sinfronia Thompson. Members, this is the bill we heard last week relating to the enforcement of certain rights for sexual assault crime victims, some of which include giving survivors notice within 5 business days or as soon as reasonably possible when a plea bargain has been set, the right to an attorney during an investigation interview with the victim, informing victims that the prosecutor does not represent the victim, and notifying the victim of the court schedule changes. The bill also creates a civil penalty for individuals, entities, including healthcare facilities and hospitals that prevent or fail to offer a victim to have an advocate from a sexual assault program present during a forensic medical examination, and if considered a safe, ready facility or program, have that designation removed. So,
Chairman Smithy?
yes,
Point of information, am I allowed to offer an amendment at this time to this bill?
well, if you've got an amendment, what I suggest is that we put this bill off till and give the members a chance to look at the amendment. And I don't have a problem with that. We've still got a little bit of time.
There's one sentence, and it has to deal with the attorney may not unreasonably delay or otherwise impede the interview process. It's one sentence I don't want to hold up or bill. I tell you what, I withdraw my point of information. I'm ready to vote, and I'll address it with Dean Thompson.
Okay, if that's agreeable with you, Mr. Little.
All right, thank you.
Okay, thank you. So, and there is no substitute on this? No. Oh, there is a substitute. Okay.
Is it, if I have it, there should be a sub.
Yeah, oh, there is a substitute. Ms. Jones, you okay with doing the substitute? Ms. Jones offers a committee substitute. Is there any objection to the adoption of the substitute? There being none, it's adopted. And so Representative Jones moves that House Bill 1953 is substituted, be reported favorably to the full House with the recommendation that it do pass, be printed and sent to the Calendar Committee. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
Okay, by 11-0 vote, the bill will be reported favorably, referred to the Calendars Committee. Next bill, the chair lays out as pending business, House Bill 2355 by Representative Fairley. This is another bill we heard a couple of weeks ago that exempts from general disclosure under Public Information Act the law enforcement reports released to the Attorney General for purposes of determining a victim or victims or claimants' eligibility under the Crime Victims Compensation Program. We do have a substitute, and Mr. Louderback, were you okay with offering the substitute? Mr. Louderback offers committee substitute. Is there objection to the adoption of the substitute? There being none, the substitute's adopted. Mr. Louderback moves that House Bill 2355 as substituted be reported favorably to the full House with a recommendation that it do pass, be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
Okay, by an 11-0 vote, House Bill 2355 will be reported favorably, sent to the Calendars Committee. Next, the chair lays out as pending business House Bill 2582 by Representative Hall. This is another bill we heard last week that would expand crime victims' rights to include being informed of the county and conditions of an offender's parole and any subsequent offenses, warrants, or revocations of the parolee. The information would be provided through victim services. And so there's no substitute or amendment that I'm aware of. Mr. Cook moves that House Bill 2582 without amendments be reported favorably to the full House with a recommendation that it pass and be printed, and the clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Lauterbach? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
Okay. By an 11-0 vote, the bill will be reported favorably, sent to the Calendars Committee. We're down to our last bill, and we got a few subcommittee recommendations. Committee substitute House Bill 3073 by Howard. There is a substitute that's been distributed. This is a bill we heard last week, and another bill codifying recommendations from the Sexual Assault Survivors Task Force. The bill clarifies the definition of consent with respect to sexual assault, including protections when the individual is unaware that sexual assault is occurring or when the consent has been withdrawn for different circumstances. Ms. Rodriguez Ramos, you okay with laying out the substitute? So Ms. Rodriguez Ramos offers a substitute. Any objection to the adoption of the substitute? There being none, the substitute's adopted. Ms. Rodriguez Ramos moves that House Bill 3073 as substituted be reported favorably to the full House with a recommendation that it pass and be printed, sent to the Calendars Committee. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Lauterbach? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 10-1.
So by a 10-1 vote, the bill will be reported favorably and referred to the Calendars Committee. Next, that completes the bills we have in committee, but we also have several bills from the subcommittee. Mr. Cook's subcommittee, we have the chair recalls House Bill 3513 by Representative Fairley from the subcommittee on juvenile justice and recognizes Chairman Cook to kind of explain the bill and what the subcommittee came up with.
Thank you, Chairman. On April 3rd, we heard House Bill 3513. The Subcommittee on Juvenile Justice voted 4-0 with one absent to recommend that HB 3513 be heard by the full committee. I would ask that HB 3513 be sent to calendars rather than local and consent.
Be sent to the general calendar?
Yes, correct. That's what Fairley said.
So that was before we knew that the local was going to set a calendar. Now it would be faster to become local. So it's, I know we had talked.
I think it's too risky right now.
Okay. So the motion by Representative Cook is that the bill, House Bill 3513, without amendment, be reported favorably, sent to the Committee on Calendars. Clerk will call the roll.
Excuse me. Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Representative Lauterbach? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
Okay, 11-0 vote. The bill will be reported favorably, sent to calendars. Next, the chair recalls House Bill 1988 by Representative Lujan from the Subcommittee on Juvenile Justice and recognizes Representative Cook once again to explain the measure.
Thank you, Chairman. We previously heard House Bill 1988 by Representative Lujan on March 26, which allows the disclosure of criminal background information of formerly incarcerated TJJD youth if they have been discharged and are at least 18 and have consented. This bill would allow the information to be shared with the, quote, credible messengers, quote, close quote, program, which is a TJJD program that brings formerly incarcerated youth back into the facilities to share their stories and provide advice to currently incarcerated youth. Subcommittee on Juvenile Justice voted 3-0 with 2 absent to recommend HB 1988 be heard by the full committee. And I move.
Okay, so Mr. Cook moves that House Bill 1988 without amendment be reported favorably to the full House with the recommendation that do pass be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers?
Aye.
Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell? 11-0.
By 11-0 vote, the bill will be reported favorably and sent to calendars. Next, the chair recalls House Bill 3276 by Representative Noble from the Subcommittee on Juvenile Justice and once again recognize Representative Cook to explain the measure.
Thank you, Chairman. We also heard House Bill 3276 by Representative Noble. Last session, we authorized TJJD to designate certified individuals as permanently ineligible for employment if they violate TJJD rules or engage in conduct threatening to juvenile safety. House Bill 3276 expands this, quote, do not hire list to non-certified individuals who are employed by TJJD, a juvenile probation department, or registered juvenile facility, or a TJJD contractor, or a volunteer with TJJD. Chairman, I move that we have the full committee here.
Mr. Cook moves that, well, first of all, we have a substitute, I believe, on.
Yes.
Okay, so Mr. Cook offers a substitute to House Bill 3276. And is there any objection to the adoption of the substitute? There being none, the substitute's adopted. Now Mr. Cook moves that the substitute to House Bill 3276 be reported favorably, be printed with a recommendation that it do pass, and be referred to the Calendars Committee. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers?
Aye.
Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money? Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
And by 11-0 vote, it will be reported favorably. We've got 2 more members. This is from the Subcommittee on New Offenses and Changed Penalties. And so the chair recalls House Bill 1443 by Representative Schatzline from the Subcommittee on New Offenses and Changed Penalties and recognizes Chairman Louderback to explain the measure. You good? You okay?
I didn't print it off.
It's pretty close to that.
Oh, no, it's not. Hang on. Did Dana not get it? Did stop? Hold on, we gotta print it off.
Okay.
Can we do it at ease real quick and I'll get it?
Do which one?
We need to print this for the explanation.
Okay.
I don't, let me call your staff. So
Okay.
you can sit at ease for like 5 minutes.
Okay. So, is there one?
Yeah, we could do,
Can we just mark this up? What number?
it's substantive stuff.
Who just has one?
I think, who's here?
Well, we've got Schatzline, he's got several, and Spiller.
Which one?
The what?
No.
3553
Oh, well, Mr. Oliverson's been here. Oh,
Yes.
I'm sorry. Mr. Oliverson, are you ready? We're gonna, while y'all are working on that.
Sounds good.
Hey,
I just have to print it off.
Okay.
When you switch.
So,
Do McLaughlin-Sville, can you just at least ask people if they've had an opportunity to look at the sub? Because I think all they did is it lowered the fine the way they wanted it
And they add a community service.
as an option. Okay. So, I mean, can you at least ask?
yeah.
Okay.
Do you have the number on it?
It is 2947. 2947. It was distributed through Dropbox, but I don't know, and I told the staff to shop it on the floor.
Did we vote that out of the sub?
The
No.
2947?
We have not.
No, there were a couple,
He was just going to recall it if there's no objection.
they were on a time frame.
You don't know? Okay. So we've got an objection, so
Okay, no problem. We'll get it on the list next week.
Okay, let me have Lindsay come.
Okay. At this time, the chair would recognize Representative Oliverson. The chair lays out House Bill 3357 and recognizes Representative Oliverson to explain the bill.
Thank you, Mr. Chairman Smithy and Vice Chair Wu and members of the committee. I believe I have a committee substitute for the House Bill 3357.
Okay, I think it's been distributed. Mr. Cook will lay out the substitute.
Okay. Thank you, sir. So the substitute before you preserves the bill's original intent while cleaning up some language to ensure clarity and enforcement consistency. Members, House Bill 3357 addresses a critical public health oversight gap in our death investigation system, a loophole that exists which permits some certain cremations to proceed without the required medical examiner review. Currently, in counties with a medical examiner, deaths that should be reported under Article 49.25 of the Code of Criminal Procedure are occasionally cremated without ever being reviewed. This happens when a funeral director obtains a burial transit permit from the county clerk and presents it to a crematory, which then treats that as a permission to cremate, even if no medical examiner was ever consulted in the case. The result is that, unfortunately, there are deaths, including potential overdoses, elder neglect, abuse, trauma, or even homicide, that are permanently cremated without any forensic review. Medical examiners are supposed to serve as the final checkpoint before cremation. This is a vital layer of public health surveillance and accountability. So this bill ensures that every cremation involving a death in a county with a medical examiner requires the express authorization from the medical examiner, even if no inquest was initiated. It also clarifies that burial transit permits cannot be used to bypass the medical examiner process, thus closing the loophole that is sometimes exploited in our state. These changes bring statewide consistency to a process that currently varies significantly from one county to county. There are large counties like Dallas County that already implement this type of review and have done so successfully for years. However, committee substitute HB 3357 clarifies this and makes this consistent across all counties in Texas where a medical examiner is part of that process. I do have some expert witnesses here to testify on this bill, Mr. Chairman.
Okay.
And I'd like to reserve my right to close, but I'm open to any questions the committee may have.
Any questions for Dr. Oliverson? Yes.
Yes, ma'am.
Thanks, Dr. Oliverson. You talk faster than I take notes, so I just want to.
I know you've been here a long time today, Representative Jones, and I'm just trying to be respectful of your time.
No worries. No complaints. But, so I know you said that every cremation requires express permission from the medical examiner. Did you have counties with over a certain size? Was it something like that? What was it?
So this pertains only to counties where there is a medical examiner present. So if we're talking about a county that uses a JP type system, this doesn't apply. So this only is applicable in counties that currently have a medical examiner.
Okay, and you said something about transferring, I guess the morgue gives permission for it to go to a crematory, and you said you don't want that to be implied that you can cremate them, and that's what this is that's what this bill is trying to stop.
So in a circumstance where a funeral director is able to obtain a burial transit permit from a county clerk without the medical examiner ever having been involved in the case, that permit can be presented to a crematory that then proceeds to cremate those remains without the medical examiner having ever signed off.
What's the name of that permit again?
Death. It's called it is called a burial transit permit.
Okay, you answered my questions. Thank you.
Thank you.
Any other questions for Dr. Oliverson? Okay. And
Thank you,
certainly
sir.
we'll call you up to close. The chair calls Stephen Postelnik. I'm sorry about the pronunciation.
Afternoon.
Yes, sir.
I'm Dr. Stephen Postelnik. I'm the Chief Medical Examiner in Fort Bend County. I'm here representing myself, and I am testifying for the bill. I have been in practice full-time as a forensic pathologist for about 29 years now. What I found here, and since 2001 in Texas, what we have is, right now, under 48 hours only, our medical examiners required to be given notice of intent to cremate so we can review the case, get more history, bring the body in if we need to, or allow it to go out. What we're finding is that the burial transit permit that is issued by the county clerks is being done on cases that should have been reported to us as under 49.25 that should have been ours. We're finding cases of skull fractures, broken hips, interrupted suicides, elder abuse and neglect that are being cremated without any of us ever noticing it around in the Southeast Texas area. Some counties already receive 100% of the cremation requests, the death certificates, to review to see if it should have been reported to them. We are not. Last year we got about 1,000. We should have gotten about 5,000. Just to give you an idea, back in 2020, a study was done. Dallas County got 9,000 burial cremation requests. Bexar County got 7,500 cremation requests. Travis County got 5,000 cremation requests. Harris County, those same years, got 2,600 cremation requests to review. So they got about 1/10 of what they should have been getting based on their population as compared to the other counties that have 100% cremation requests being reviewed by the ME office. So it is a moral imperative that we survey the deaths in this state, that we find people that die under suspicious, unnatural, and unlawful circumstances. And we are, since we became into existence in 2019, we've been fighting to make sure that we are able to survey the citizens of Fort Bend County to make sure nobody is missed, no crime is not prosecuted, no abuse, neglect, or suicide, or on-the-job accident goes uninvestigated and uncertified. And we're asking to be able to work harder, work longer, and do more for the citizens and for the legal system in our county.
Okay, well, thank you. Any questions, members? Yes, Ms. Rodriguez-Ramos.
Mr. Stephen, what county do you work with?
I'm the chief medical examiner in Fort Bend County.
Fort Bend County. And is there a shortage of medical examiners?
Nationwide, absolutely. We are fully staffed because I run a really good office.
Yeah.
I have people waiting to come work for me when we have openings.
So what happens to those counties that don't have enough medical examiners to?
The cremation, sorry, the methodology is that a funeral home who wants to cremate a decedent sends a signed death certificate to the medical examiner with a form. We have a form that says we want to cremate, can you please review? It takes us exactly 30 seconds, a minute, to look at it, to say, oh, I need more history, and then we can look that up online, or this looks good, good to go, sign, off they go. It's not an onerous thing at all to do that. Harris County is fully staffed. They've got 14 medical examiners, and they filled up all their positions. Bexar County does 100% cremation reviews. They're short-staffed, but they still do them. Dallas County, I think, has one position open, but they are reviewed at 100% of it. It's a minor thing, a paperwork thing that we do, but we bring in about 20 a year that we get missed, that go for burial transit permits, and then we miss them, so we bring them in for us. But we do a lot. We did 1,000 last year. We should have done 5,000.
So there's not, like, in your experience or in conversations you have, were there to be a shortage in a big county or whatever, that they would outsource some of this to a private entity to do this? It's not anything that you're in conversations.
This is something that a well-trained, board-certified forensic pathologist can look at a death certificate in 2 seconds, know everything looks, square deal on this, versus we need more information, versus that body needs to come in now. I've had death certificates signed by doctors who, the body was going for cremation authorization, and they put down cocaine abuse, natural death. I've had motor vehicle accidents, skull fracture, pelvic fracture, natural death. And we only caught those on a cremation death certificate review to come into us. So we know we're missing bodies. Dr. Paneri, who's the chief in Montgomery County became medical examiner on January 2nd of this year. In her first week of operation, she had 3 bodies she had to bring in on cremation authorization review because they were never reported to her to begin with. I've had homicides that we've surreptitiously found as well. So we do the work because we need to catch these bodies.
Yeah, so they're essentially questionable deaths that need to be investigated that.
Correct. They're not questionable until we know about them.
Right, right.
So we review 1,000 to bring in 20.
Yeah, okay, understood. Thank you, sir.
Ms. Jones?
You said surreptitiously. Why do you use that word?
The people can, families can give history to law enforcement, to patrol officers or whatever, that minimize their involvement with their family member's death or somebody's death. The easiest person to murder is someone you expect to die anyway. Elderly, people with natural disease, all that sorts of stuff. Grandma, she's demented, okay? She hasn't been eating, she's emaciated, she looks like a camp survivor. So please, don't send her to the medical examiner office. We don't want her cut apart, we don't want this, we don't want that. Let her go in peace. And the doctor who's been treating her for whatever reason, for her chronic medical problems, he gets called and he says, she had hypertension, she had diabetes, she blah, blah, blah. I'll be happy to sign a death certificate. Off it goes. Okay, we get bypassed because we have a spurious report. That's the surreptitious part of it. And then it comes to cremation, and then we get a death certificate to review, and it's like, wait a minute. The failure to thrive, neurologic degeneration of the brain, what is that? Seizure disorder. Seizure disorders can be delayed blunt force trauma to the head or juvenile epilepsy. We need to investigate those. Those are surreptitious cases.
Okay, thank you.
That we can
any
find.
You answered it. Surreptitious just was a word that just made my antenna go up, but you explained it.
Thank you.
Thank you.
Any other questions, members? Thank you for being here. We appreciate it. Harvey Hildebrand? So, Harvey, one thing, on your affirmation, you put Texas Funeral Association. Can the clerk?
I'm sorry?
That's all
Funeral
right.
Directors Association, Texas Funeral Directors Association.
And so can the clerk make that
Please.
correction with your permission? Okay, go ahead.
Good afternoon, Mr. Chairman, members of the committee. I'm Harvey Hildebrand. I'm the Executive Director of Texas Funeral Directors Association. And we're opposed to the bill as currently written. I do want to express appreciation to Representative Oliverson and his staff. And in fact, we've had one meeting with the ME from Fort Bend County to begin some negotiation or sharing of perspectives. But this under current law, and we have another witness that will speak more to this because he's actually in the business and operates crematories in a region of Texas. But this only applies to 16 counties, which is going to represent most of the population, because it's largely the rural areas aren't covered by the bill. We are opposed to the bill because it mandates something that's not in current law, where with a doctor's certificate, a doctor's signing the death certificate, a number of items happen in the process that another witness will go through with you. But there's a number of things that were required by this proposed bill that aren't in current law, including after 48 hours having to have the ME's authorization letter for cremation. That causes delay. It also creates cost. Currently, there are counties that have MEs that, I'm not sure how they're able to do this, but have adopted rules that aren't based on the current law that this bill seeks to amend. And they have rules that require the authorization letter from the ME, and even though the law doesn't say that. So we're concerned about that, and right now, the fees fluctuate, or, what we've been able to gather from limited survey so far is that the fee seems to be somewhere between $20 and $50 across the state. However, in New Mexico, where they require this, it's over $200. Those costs are either going to be absorbed by the funeral home or passed on to the families. And so those are some of our concerns about the bill. Currently, you not only does even in current law, you have to do it under an inquest, and the ME and other officials can begin that process. But under current law, and you have the death certificate signed by the doctor, you could have a doctor that's attending the death. You have a patient or person under hospice care, a number, chronic illnesses, as the ME pointed out, that can be something else, but generally speaking are not. And we'd like to work further on this bill to see if we can improve it.
If you'll work with Dr. Halverson, and Ms. Rodriguez-Ramos has a question.
Mr. Hildebrand, could you share your opinion on what this would have looked like during COVID if we were to have to do, if the funeral homes had to incorporate this process during COVID? What would that have looked like? Because I know we were stacking up bodies.
It would have exacerbated the process, and as I understand it from talking to the ME from Fort Bend County, that before COVID, I don't think most of the MEs view this as big a problem as he does today. Now, by the way, if every ME ran in their office like Fort Bend County does, where they have a quick turnaround, don't delay cremations, don't delay funeral arrangements, don't delay funeral service, don't charge a fee. Fort Bend County doesn't charge a fee, and they're quick turnaround, and they apparently do a great office. But we have a lot of funeral directors, and this issue first emerged for me as executive director during COVID because of delays that were happening on those counties that have a rule requiring it, even though it's not based in the law.
Okay, and yeah, my concern is fees going to families. It's already expensive. Thank you, sir.
Okay. Anything else, members? Ms. Jones?
Just wanted to make sure, you said the fees that go to families, you said it's $200? You
No,
say
so in the state of Texas, from limited surveying of what we've been able to find out in the last couple of weeks, is that it appears that the fees in Texas at the various counties that have MEs are between $20 and $50. The Fort Bend County doesn't charge. We also have delays in some of the other counties. There are some that, apparently have a lot of good communication with the funeral homes and funeral directors, and it works, I don't think as well as Fort Bend County, but works better than others. And then there's others that there are a lot of complaints about. But in other states that have adopted this, like New Mexico, where it's required, it's over $200. And the only reason I don't spell the number out for you, I think it's about $240, but just because it might be $210, I'm just saying over $200.
And that's a fee from the funeral home? That's a fee from who?
The ME charges that for the authorization letter. So the medical examiner this bill is going to require the medical examiner and require funeral homes to make sure that all death cases are brought to the ME, except for those in rural areas, because, so in that case, well, it doesn't apply. So it's not like it's going to be uniform across the state. You'll have whatever problems that do exist today will still happen in rural areas, but there'll be more of a review in metropolitan counties and contiguous, the suburban counties. Did I answer your question?
Yeah, so the fee is generally $20 to $50, and you're saying that's.
I'm saying right now it doesn't exist except for those counties that have adopted a rule and funeral homes have cooperated and not, sued to challenge that. And that happens in Bear and Travis, and my understanding mostly from the supporters of the bill that it happens in Dallas. I know we have complaints in other counties where, and especially during COVID, it kind of decreased in the last couple of years, the complaints about slowing the process down, delaying the arrangements and the cremation so families can have their service. There's a delay issue, and then there's also a cost issue that this bill will mandate that doesn't exist today.
Okay, so your concern is that when you guys are preparing the services for the deceased person, that it's causing angst to the families because it's potentially delaying the services.
Yeah, and so the family member has signed a document calling for a cremation. The doctor has signed a death certificate in the case, and then in many cases they don't go to the ME, but in some cases they do go to the ME, and like inquest they all do, but in this case all cases would be reviewed by the ME, and it sounds like it would work pretty well for those in Fort Bend County, like they're, but in other counties that's not been the experience, and it costs money and it causes delays.
Just a quick, well, you know what, I'll speak with the bill's author.
Yeah,
Thank you.
Okay. Okay, thank you, Mr. Hildebrand. Oh, Mr. Latterback.
Mr. Hildebrand, appreciate your testimony. What you're saying, when we have unattended deaths here in Texas, what was the number that are showing up at funeral homes that are just with no record of any, no investigation, no?
Well, so today, under current law, although there are counties that essentially practice what this bill calls for, in those counties you have a higher number of reviews. The ME from Fort Bend County has a list he's shown us earlier. I don't have a copy of it, where he shows what they were doing, how many cases were being reviewed in a number of counties. Harris, for example, that's something else. MEs aren't. We don't know that all MEs are for this bill. We understand, but I haven't gotten this information directly, that Harris County is not for it. But we know a number of MEs that counties around Harris County are for it. And we have had people on our side that will comply with one county's requirement, and then, there's some complaints about, well, we don't have to do that in Harris County, and so forth. So there's some issues, and we recognize some on the other side. We'd like to keep working on it, but there are, I think the ME told me earlier, and he can, someone, the author can address this, is that some counties are doing a lot less and not that many more since COVID. And they believe, based on looking at the math, that should be a 20% increase from what's happening now. So I think it's probably fair to say there's probably 20% that aren't being reviewed that, but again, it wouldn't happen in the rest of the state. It would just be happening in those counties.
Okay. Thank you.
Thank you, thank you. The chair calls Ryan Stevens.
Good afternoon. My name is Ryan Stevens. I'm a licensed funeral director here in the state of Texas, and I represent the Texas Funeral Service, the Texas Funeral Directors Association, as well as Legacy Funeral Group. I appreciate you guys allowing me to speak today. I am in opposition of Bill 3357. To echo some of what Mr. Hildebrand said, for me, this is about the families that we serve. So as he explained, the current process where we do obtain an authorization that is signed by the family as requesting cremation. In conjunction with that, along with a signed death certificate by a doctor, we're able to obtain the burial transit permit, which here in the state of Texas acts as the cremation permit. So we're following those rules in that way. For me, again, this is about the families that we serve, and there's two sides. One is the additional cost that will be incurred to the family that will be passed on to them in these situations of unnecessary inquest, as well as the delay. And for me, that's the big one, is the delay. Sometimes, like he said, in Fort Bend County, this happens in an hour, but in some of the other counties in which we serve, we're talking about 24 to 48 hours, and in the case where it rolls over into a weekend, it could be 72 to 96 hours. So this is time that's passing for a family where they're unable to perform services and begin their grieving process, as well as receiving their loved ones' cremated remains back in a timely manner. So for me, it's about the families and the cost as well as the time.
Thank you, Mr. Stevens. Any questions for Mr. Stevens?
Yes, ma'am.
Okay.
So,
Ms. Ramos.
thank you, sir. So when someone passes away and the family is going to, they say they want them cremated, the family is saying this is what we want. There's a doctor already, the individual's doctor for the most part, is already signing off on some paperwork saying, yes, they signed the death certificate, this is the cause of death? Not
That's correct.
necessarily the medical examiner, but the doctor of the patient or what have you, that's been taking care of the patient.
That's correct. So any attended death, whether they're in the hospital for longer than 24 hours or on hospice care or under the care of a physician, those are already signed off by a physician without going to the medical examiner.
Okay, and then at that point, when that's done, that paperwork is done, the funeral home can proceed and start the services for the family and cremate and do what needs to be done.
That's correct. So it's all done electronically here in the state of Texas. So once that physician has certified through the electronic system, we're able to obtain the permit electronically as well, along with the authorization that's signed by the family, and those documents act as giving us permission to move forward with the cremation.
Okay, and so what this is asking is, in addition to that, in counties with exceeding 2.5 million population, we want them to go in front of a medical examiner and do another step to ensure that there's no foul play, because this is not just specifically addressing those with foul play, it's everybody, right?
That's correct.
So then that will delay the process even more. If I'm a grieving family, you have everything you need for me, now you're waiting for the medical examiner, we're mourning, we're crying, and there's a backload, and this is a Harris County or Dallas County, and they're not as quick as Fort Bend, and what's going on, and now the funeral homes now have to delay other funerals. I mean, I can just imagine it's a mess.
But that's correct, and that's the big challenge for me.
Yep, okay, thank you, sir. And then I imagine, there's nothing that says specifically the counties can't charge for this because it's an additional service, so then that means the funeral homes then have to charge me, the grieving family, for that additional paperwork process, even if it's just whatever, but that's 20 minutes an hour paperwork that you need to get on top of that. So, yeah, it sounds a bit cumbersome. Thank you.
Yes, ma'am.
Okay. Any other questions? Thank you for being here, Mr. Stevens. Anyone else here to testify for, against, or on House Bill 3357? If not, Representative Alderson, you ready to close?
Yes, sir.
Okay.
All right, thank you, Mr. Chairman, committee members. Just to answer a couple of quick things, we have not had any comments from a medical examiner opposing this legislation, period. And in fact, the Dallas County Medical Examiner is in full support of this legislation because, again, Dallas County is already doing this and has been for years. I think the bottom line here is I understand the arguments against, but I think it's important to recognize that the purpose of this statute and the purpose of the medical examiner is to detect cases of wrongful death. And as much as it pains me to say it, there are cases in this state where families who are grieving and are in some due haste to have a loved one cremated are covering up a wrongful death, elder abuse, or some other neglect that is a criminal act. And there are people who, once they're cremated, the evidence is destroyed, and you can't go back and essentially prove wrongdoing. And so this is really about preventing people from getting away with murder or other criminal acts. And so I think it's a reasonable step. I'm not aware of any opposition from the medical examiner community. And, I understand that there may be some challenges that have to be overcome. I'm obviously willing to work with stakeholders, but I cannot in good conscience sit by and do nothing when a bill is presented to me that could prevent a miscarriage of justice and somebody getting away with murder. And that is essentially what we're talking about here. So with that, Mr. Chairman, I respectfully ask for the committee's favorable consideration of this bill, and I close.
I've got a question from Ms. Rodriguez-Ramos.
Thank you, Representative Oliverson. Well, this is only targeting counties that exceed 2.5 million, but you would agree with me there's wrongful death in counties with smaller than 2.5 million. So why does this bill, the concern being there's murders happen in rural areas too?
Sure,
Why aren't
but we don't
doing it
have
all
medical
over?
examiners in rural areas, unfortunately. So
But-
that's sort of the distinction we're making here is that we have areas where there are medical examiners that are that are paid, that are on staff, that are ready, that are available to review these cases and make sure that there's no wrongful death. I agree with you. I think it would be great in a perfect world if there was, no matter where you live, that there was an opportunity for even a quick review to make sure that, you know, I've got a case here, and I wasn't going to read all this, but I'll just tell you that there's a case that was presented to me of a 71-year-old profoundly emaciated woman who died in a bed in her daughter's home. And the ME was able to divine from the circumstances, although the family was pushing for cremation. And interestingly enough, the daughter was actually law enforcement. Later admitted, after it was discovered that the mother was emaciated, had suffered multiple injuries to her head, and also had multiple decubitus ulcers and bed sores that were not taken care of, that in fact she had been starving her mother and just essentially not taking care of her, but wanting the Social Security check, and was, pleaded guilty. So, I mean, there are circumstances where loved ones are being abused and we're not recognizing it. So I'd love for that to be detected everywhere. Unfortunately, we don't have a medical examiner in all 254 counties.
But you have somebody
There's a separate bill for that.
Well, you have somebody who serves that role in those other counties. Maybe it's not a medical examiner per se, but it's the local judge.
So there's a JP system,
Yes.
and I'm not going to stand up here and tell you I'm an expert on the JP system and how that works. I just know that in some counties, there were bypassing medical examiners who were standing by, ready to review these cases, and are, in fact, detecting circumstances where there's an attempt to destroy evidence and cover up a crime.
So would you agree to amendment that's saying the JP in those smaller counties would then have to do this as well, or the individual that's responsible for that in the smaller
I'm happy to talk with you about it. I
counties?
don't know if they have the ability to do that, the same level of training, or how that process works. I'm focused specifically on this issue, which is concerning bypassing a medical examiner when a medical examiner is present, and that's obviously somebody that has a high degree of specialized training in detecting cause of death.
But you want to detect wrongful death.
Yeah.
Grandma Jones in wherever, Abilene or whatever, she deserves the same protection if there is a murder happening to Grandma Jones over there where there's not a medical examiner. She deserves that same protection and oversight as Grandma Jones in Harris County. And so it seems if the intent of this bill is to prevent murder or to detect murder in cases of wrongful death, we would include those professionals in those rural counties so that our rural folk can be protected as well. And our grandmas out there in the rural communities probably even more likely to get targeted because there's not a lot of community around them. So
it's definitely something to think about. Again, the purpose of this bill is to prevent the medical examiner from being bypassed in a circumstance where suspicious circumstances may exist.
Thank you.
And there's a rush to destroy evidence.
Any other questions, members? Okay. Dr. Officer, thank you
Thank you,
for
Chairman.
being here.
Thank
If
you,
there's
committee members.
no objection, the committee substitute will be withdrawn, and House Bill 3357 will be left pending for now. Mr. Schatzline, you've been very patient. You've been here for several hours. The chair would lay out House Bill 1913 and recognize Representative Schatzline.
Thank you, Mr. Chairman and members, for the opportunity to lay out this bill. House Bill 1913 is also known as Brooke's Boundary, named after Brooke, who's a young woman whose story will be shared by her mother here today. This bill is about one thing, and that is protecting victims. It's about ensuring that survivors of sexual violence are never again forced to live in fear that their predator could move in just down the street. And when someone has already lived through a trauma that no one should endure, the very least we can do is ensure that they have a safe place to heal without the looming threat of re-encountering the person who hurt them. House Bill 1913 creates that protection. It establishes a legal boundary, a 2,500-foot buffer zone around a victim's residence. That space is more than just a number, it's peace of mind in just under half a mile. It's the difference between a survivor feeling safe in their own home or being haunted every day by the fear that their abuser might be around the corner. To make that protection enforceable, the bill amends Article 62.053A of the Texas Code of Criminal Procedure. It prohibits registered sex offenders from going within 2,500 feet of their victim's home, creating a safe zone where victims can begin to rebuild their lives. Furthermore, the prevalence of registered sex offenders in Texas is alarmingly high. According to safehome.org, Texas has the highest number of registered sex offenders in the United States, with over 75,000 individuals listed, accounting for nearly 10% of all registered sex offenders nationally. This significant number underscores the critical need for protective measures like those proposed in House Bill 1913 to safeguard victims from potential re-encounters with their offenders. This is incredibly important, and as I said before, this is about protecting victims once those that did the harm to those victims get out of jail. We have witnesses, and I'm happy to answer any questions. I would also like to reserve my right to close.
We will give you that opportunity to close. Any questions for Mr. Money?
Oh, excuse me. Great bill. Love what you're trying to do here. Question, how will the victim in this case, or how is the person that registers knows that the victim is nearby, or how does the victim know that the person registering is nearby?
Yeah, it's a great question. So one of the things, last session, this bill came to the full House and was voted out 146-0. And the reason that it was is because we were able to make some provisional changes within this bill to make sure that this is an opt-in program for victims. And so one of the things that we don't want to do with this bill is we don't want to require victims to have to tell TDCJ where they live. We just want them to have that option to be able to tell TDCJ so that they can ensure that sex offender is not moving in within 2,500 feet.
So how that works, I just want to make sure, if I'm a victim and I opt in, then I'm going to notify TDCJ, this is where I live. And then if my offender comes within that 2,500 feet and says, hey, I want to move to this place, they're going to say you can't live there.
That's correct. And we clarified this with TDCJ last session, that they would not ever disclose that location to the sex offender. They would just say you are not allowed to live in that zone. And that could be for other reasons as well. You know, there's laws on the books, even at the local level, that you can't live within 1,000 feet from an elementary school, you name it. So.
And that's not subject to an Open Records Act or something that people would be able to get that victim information?
That's correct.
Okay, so is that part of the bill right now, or do we need a committee sub to get there?
So I would accept a perfecting amendment on this. This is something that we probably need to add in. That's what we did last session with a perfecting amendment.
Okay, thanks.
Yeah.
Would you rather do it that way as opposed to a committee sub?
I'm open to either way.
Your choice, but yeah.
Okay.
Okay, and I know we do have both Mr. Larry Stevenson and Robin Stevenson. Do they both intend to testify?
Yes.
I mean, it's perfectly fine. Okay. So the first one I have on the list is, okay, any other questions for Mr. Schletzline? Okay.
Thank you,
We'll
Chair.
give you a right to close after we hear from the witnesses. And the chair calls Larry Stevenson. Mr. Stevenson, we have you registered as testifying on your own behalf and that you're obviously for House Bill 1913. Is that correct?
That's correct.
Okay, you may proceed.
All right. Well, good afternoon, and thank you so much for this committee to hear us today. So, and thank you again to Representative Schletzline for leading the way with this House Bill 1913. My name's Larry Stevenson. I live in Rowlett, Texas, and I am in support of House Bill 1913, and I would like to see the law for sex offenders modified to protect the victims of these awful crimes. Again, this bill is not designed to add further punishment. We're not trying to do that to these sex offenders, as I'm sure others will argue, but it is about protection for the innocent victims that were violated, and to just give them the opportunity to, kind of put their lives back together as best they can without having their healing or the rehabilitation just derailed with these encounters of folks that did this to them. So, again, the laws in place do a good job for the potential victims. They keep them away from schools, they keep them away from daycares, and that's fine. But there is a gap when it comes to the victims here, and And, you know, how else would you explain that the guy that sexually assaulted my 14-year-old daughter can move right back in next door after he completed his prison sentence and just plant his butt right there and come out in the front yard and just do whatever he wants to do. So that's why we're here. That's why I'm here on her behalf and for others that may find themselves in that same situation. So, you know, sexual offenders have a reoffense rate that's over 50% within a specific amount of time. And we know that percentage is low because so many of these go unreported because of the fear that's generated. And Brooks' attacker fell into that same category. He'd already violated several other young ladies that we didn't know about that just showed up at his sentencing trial to just offer support for us. So unfortunately, that was a little too late for us. But you know, I don't know about you, but I'm not really, you know, willing to risk the flip of a coin, you know, that someone who hurt my daughter or my family before, you know, won't do it again, especially if he's living within, you know, eye shot or near a place where I'm gonna, or my daughter's gonna encounter him could encounter him on a regular basis. So, you know, it's, you can just imagine how uncomfortable this was, you know, not only for me, but especially for Brooke. I mean, we had to, you know, I always had to go out and peek around the corner the minute, you know, we go outside. It's like, is he out there? Is he standing around? Is he loitering around? And so, you know, that's just, no adult or child should be a slave to their home. You know, they shouldn't have to stay in their home and hide because of this situation coming up. So, you know, it's that, again, that fear that just paralyzes them. And it just, it's this, you know, this not being protected like they should. And this House Bill 1913, I believe, does that. So, you know, and hopefully we'll give her and other folks in the same situation, you know, just some peace about moving around their homes and neighborhoods safely without this fear and anxiety. So, again, I'm sure you're going to hear arguments today from others about how these folks have been rehabilitated and have they reconciled with their families and victims and such, and they want to just move forward with their lives. And I understand that, you know, and they'll even worse, that we may force them to move. Well, guess what? That's exactly what we want too, as victims. We just want our lives back. We just want to move forward. And it's, you know, if this bill's not passed, you know, all that grief and that imposition, guess where it gets shifted? Right back into our lap, right? And that's exactly what happened with us. You know, we chose basically to move because we had to. I mean, we weren't going to put our daughter through that, right? So we had to go through that. We had to go find another house, you know, move out of the house that we've raised our kids in, that we've been for 30 years, and to get away from this situation. And that, you know, that should never have to happen. And, you know, quite frankly, I would think that any sexual offender that has been rehabilitated, truly rehabilitated, would have enough empathy and regret that they wouldn't want to move back in close to their victim anyway. So, again, Todd robbed Brooke of a lot of stuff when she was 14. And, you know, her self-esteem, her purity, and, you know, he's been holding it hostage now for a long time. And, you know, she's still working at it. She's been in a lot of places, a lot of homes, a lot of rehab to get better. And, you know, it's certainly not fair that she or anybody else in this situation should have to, you know, try to get their lives back together without the presence of their attacker just looming over them, or just the chance that they're going to run into them at the store, the 7-Eleven, or getting gas or whatever. You see them at the pump across the way. So, you know, I just believe that your support of this House Bill 1913 would be a huge step, not only for Brooke, but for other victims to move their recovery forward and, you know, to close this gap for other victims as well. And so thank you again on behalf of my daughter Brooke and for other victims.
Members, any questions for Mr. Stevenson? Thank you for your testimony. I can imagine it's not easy to get up here and do that, but we appreciate you coming and telling your story.
Thank you very much for listening.
Thank you. Next, I have Ms. Robin Stevenson. Ms. Stevenson, we have you registered as Robin Stevenson, testifying on your own behalf in support of HB 1913. Is that correct?
Yes, sir.
Okay, you may proceed.
All right. Good afternoon. I appreciate you guys being here and allowing me to speak. Sorry, I'm nervous. I'm about to cry.
You're good. You're good.
Okay. But first, I want to thank Representative Schatzline for hearing our cries and authoring this bill. Like you said, my name is Robin Stevenson, and I'm here as a parent, and I'm also here as a voice for those who have been victimized. I am in support of House Bill 1913, and I request that the law for sex offenders be changed. Like Larry said, our daughter was sexually assaulted by a 37-year-old neighbor who still lived at home with his family. And, you know, we have spent majority of our time trying our best to help our daughter heal, to help her feel safe again, and to rebuild trust and move forward as a family. All of that came to a halt. What happened next, we never imagined. Sorry. He was able to move right in next door to us, and our daughter freaked. Let me say that again. The man who violated our daughter, who stole her innocence, was illegally allowed to return and live feet away from us. I mean, imagine if this was your son or daughter, and how would you explain this to her, to tell her the person that hurt her is now living back next door to her? I mean, we followed every step to protect our child. He, you know, she reported it, he went to prison, and we trusted the system. And then we learned that there was no restrictions against him from moving back next door to us. It didn't protect the victim at all. It protected everybody else but the victim. House Bill, I believe, is a very common sense solution to a terrible loophole. And it protects those victims from being re-traumatized. It reinforces safety and dignity of the victims long after their court case has ended. I want to reiterate what Larry said. This is not a punishment. This is protection. You know, survivors like Brooke should not have to feel, you know, uncomfortable or scared to come to her own home. You have the power to make this right, to make this change, and to protect victims, you know, and help them to feel safe in their own environment. Please let our child's story mean something. Let it lead to change that protects others, so no other victim will have to go through what our daughter did. I respectfully and prayerfully ask for each of you to vote in favor of House Bill 1913. And I want to thank each of you for allowing me to speak today and have your attention. And if you have any questions, I'm available. Thank you again. May God bless you.
Members, do we have any questions? Mr. Burdell?
I just want to say thank you for coming and giving your testimony. Appreciate that, and that's very helpful to this bill.
Thank you.
Anyone else? All right. Thank you for being here. Appreciate your testimony.
Thank you.
Next, we have Brian Hawthorne, Sheriff Brian Hawthorne. Sheriff, we show you registered as Brian Hawthorne on behalf of the Sheriff's Association of Texas, and that you're testifying neutral in HB 1913. Is that correct?
That is correct.
You may proceed.
Thank you, Chairman, members. We support the concept. First of all, I'm Brian Hawthorne. I'm the Sheriff of Chambers County. I'm the Chairman of the Legislative Committee for the Sheriff's Association of Texas. It's very important to us that the laws that are passed that are expected us to enforce and applicable, that we have the ability to figure out how to do it. And after reading this bill, we met with the author, Representative Schatzline, on Friday. I believe our office, we did, we came to talk to your staff. Okay. Yeah. Our problem is trying to find the applicability, because currently right now, I can't even tell you where the victims in my county live. So we understand there's going to have to be some form of a registration list or something. Most victims aren't going to want to put themselves, most victims that we have found want to move on. They like their anonymity. They don't like for people to know they were a victim of crime. I'm sure there are some that probably don't feel that way. So what we're trying to do is just figure out, and we're more than willing to work with the author and his office on the bill, trying to make it to where we think it's applicable, where we could actually enforce it. It's real easy for us to enforce a school zone or certain things like that, but obviously victims of crime are a moving target because they do move, especially when you think of all the different type of crimes that require registration. Everything from the Romeo and Juliets to the violent offenses where they may come out of prison after they've been there for 10 years. They don't know where the victim is. I don't want them to know where the victim is. And now somehow we're going to have to identify where the victim is. So we're just trying to figure out how to apply that. Also, I think if you live in big cities, that 2,500 feet, that's a half a mile, might work. But I've got a number of little towns, and 90 other sheriffs have a lot of little towns where the town itself is barely a mile in size. And especially if it's I don't even want to get into the type of crimes, but you could have a scenario where somebody is coming back, and for them to not be set up for failure on their probation and their parole, it might be in their best interest that they are actually living with their mother or their grandmother or their father versus living on their own, working through whatever probation or parole and rehabilitation that they may have set up for them. Also, it could be very difficult for us to track victims because if they are a female victim and they're young, they may be getting married, they change their names. So we just see a lot of little issues that are going to need to be worked out with the with the representative here to work through this bill. We would love to find support. It's all about supporting victims and protecting victims. We're just not sure if the current bill, the way it's written, is capable of being addressed. I will tell you the police chiefs and the sheriffs handle registration in our counties. So, it's something that we're all about. Most chiefs and sheriffs routinely run sex offender registration roundups, making sure that our registered sex offenders are appropriately following the rules and the laws. So we're all about protecting those victims. We're just not sure if this bill, as currently written, makes it happen to where it's enforceable for us.
Thank you, Sheriff, for your testimony. I have questions from Mr. Verdell. Yep, as well.
Sheriff, thanks for coming. If this were, I know right now you're neutral based on the applicability of it. If the language were changed to say that perpetrator, is that the right word, or the criminal, basically cannot reside within 2,500 feet of the victim, would that be something y'all would be more inclined to move towards supporting then? If the victim was willing to come forward.
I was going to say the 2,500 feet or the residents for sure we could feel very comfortable with it. What we worry about is I've got some places where in certain town you couldn't even drive through the center of town that you would be in violation of that 2,500 feet.
I live in Brady, so I understand.
You fully understand exactly what I'm talking about.
Yeah.
So that's our concern. Small town Texas, it probably works great for Houston, Dallas, San Antonio, but rural Texas, that could be problematic. But we fully understand the 2,500. What we've got to figure out is how do we, from law enforcement, identify whether or not somebody is a victim unless there's some form of an official registration. So we see it, I know this sounds horrible because we want to support the victim, but if somebody goes and they don't have to register with us until they've changed their residence. So now they've already changed their residence, they come and register with us. Now if we even had the victim database, we'd look up that victim database, and then we would say, oh, you can't live there. Chances are he's already put his first and month's rent down. We just see all kinds of little issues that we're going to have to work through.
Yes, sir. I appreciate that.
But we support the concept. We're just the law itself as it's written now. Just going to, we feel the Sheriff's Association feel like it needs some work.
All right. Thanks, Sheriff. Appreciate it.
Representative Rodriguez Ramos.
Thank you, Sheriff. I think you answered my question. I don't know why I'm from Dallas, but I am often concerned of how these laws impact our rural communities, and so
Sure.
that was a big concern of mine. I know maybe there's a lot of family there, and an individual has nowhere else to go, but this town is so small that then what are we doing? And so I don't know. I just really am concerned, and I appreciate you speaking to that in terms of the impact.
Well, even our, what we call an EPO, Emergency Protective Order, is 200 yards,
Yeah.
right? 600 feet. So when you, and we even have a tough time in law enforcement trying to appropriately and properly enforce the emergency protective orders. So
What is roughly the 2,500 feet? What is that?
that's a
roughly?
half a mile.
Half a mile. Well, okay, thank you.
Yes, sir.
Representative Money?
Yes, and I appreciate your willingness to work with the author to try to come up with a solution that's workable. I'm from a district that has a lot of those towns, that if you put a 2,500 foot radius, you cover the whole town.
Yes, sir.
So I get where you're coming from. You, I'm sure, heard the testimony of the Stevens.
Absolutely,
here.
I did.
And so what we have there is a situation where the perpetrator moved back absolutely knowing that he was right next door. So I think it's right for us to think forward, okay, how does this work if the person just plops down and they don't know that the person has moved there or whatever. But this person moved back to within, next door. Either did he live there beforehand and just went back to his same home, but he knew he was right next door to the same place that he had committed those crimes, and that the victim still lived there. Is there a way to draft this? I'm not asking you to do it right now, but to address just that, just the knowingly moving there. I think that this is a bill that needs, we need to provide the protection for the victims that's here, and I appreciate your heart for that. Just want to encourage you to prioritize sitting down with Representative Schatzline and seeing if we can address this in some way that would give comfort to the Stevensons and to other families like that just say once that's happened and we've gone through the process and the person is in the process of paying their debt to society, they can't come move back in right there.
Representative Money, I totally agree with you. The issue, and this is what I always tell from a sheriff's perspective, is if we pass a law that we have a very difficult time applying actually out on the street, then next thing you know, the sheriff and the police chief are the bad guy.
Right.
So I just want to make sure, or the district attorney becomes the bad guy, because we make the case, try to move forward with it, and the DA says, well, the way the law is written, I can't prosecute it. So that's what we've got to do. Because believe me, I would feel the exact same way if somebody moved in next to my family that had violated my family. No question about it. And I think we just need to work on whatever that needs to look like. So
All right.
I just want, Sheriff Association is here to help.
Thank you.
All right.
Sheriff Louderbeck, Sheriff Hawthorne.
Sheriff, I think it's the application. We've walked this road before, have we not?
Yes, sir, we have.
So the actual applicability of here, I think we can reach a pretty quick agreement. If we can get the police chiefs and we can get the group together and roundtable this pretty quickly, I think we can come up with a very satisfactory answer.
We would love to move from neutral to support. Absolutely.
Thank you.
You bet.
I guess I would just point out that, aren't most crimes based on a complaint? They start with a complaint to the PD. If we just take the facts of this situation, I think one of the comments a while ago made me think about that the process normally commences with a complaint. So in this situation, you would have had a victim contacting probably the local police, the chief, like you talked about earlier.
Correct.
And then as far as noticed, I think the Texas Department of Criminal Justice, I think they provide notice to, under 62.052, as far as like when, on a pre-release. And so I just didn't know if that was,
So the issue that I see here, and Sheriff Louderback could even add to this, is probably that operation also needs to include DPS and the sheriff, the county of which they get transferred to, where they go. And the reason being is if it's in the big city, then the police department handles their sex offender registration. If it's in the rural area of the county, then the sheriff's office handles that sex offender registration. But at some point, we've got to identify how we're going to manage the victim. That's who I worry about, is the victim. The sex offender, I have no problem dealing and addressing that law to him. I want to make sure we don't violate the victim by creating a registration list that they must get on, because what happens if somebody doesn't get on it and then somebody moves in next to them, or say moves 2 blocks away from them, but they're clearly within that 2,500 feet, all right? And enough people know, well, you know, that's the guy that offended Susie, who lives 2 blocks over, right? Then the complaint comes into me, then there's this expectation for me to go arrest him for living within 2,500 feet, and he didn't even know she lived there. So that's the issue I think that we have to work through. In Brooks' case, there's no doubt. He knew what he was doing, and shame on him, and it's sad that the law didn't have that applicability to fix this problem. So it is something that does need to be addressed.
Good. Thank you for your testimony.
Absolutely.
All right.
Thank you.
Yeah, next we have Fran Rhodes.
Fran Rhodes. Don't see Fran, so we will put Fran Rhodes down as for the bill, but not testifying. J. Dan Gum. Welcome.
Thank you, Chair and committee members. My name is J. Dan Gum. I am representing myself and our organization, Forgiven Felons. And we are against the bill as it's written. I've been out of prison now 19 years and served 3 years. And ever since then, I've been working alongside every kind of felon. And the motto of our organization, Forgiven Felons, is helping people with the past realize their future. And we don't discriminate to what that past is. We try to help everybody be a better version of themselves than they were when they committed their crime. And with that said, our transitional house has helped a lot of people that have to register, the registrants, the sex offenders. And we have seen people that we've worked with. First of all, I do want to say that I am sorry that the Stevensons had to go through what they went through. The guy is an idiot, and that should never happen. And I apologize on behalf of him, because this actually doesn't ever happen. This is the only case we've ever heard that it happens, and he's an idiot for doing that, and he never should have done it. And I hope that we can get something written that will protect from the anomaly idiot every once in a while that does this. We have seen so many people in our organization come through with sexual offenses in the past, get better, rehabilitate, decades beyond their crime, start families, start their own business. A couple of the problems I have as it's written is the knowingly and intentionally. If we could get that added, because over the 19 years of working alongside people that committed sex crimes, no one wants to go back to their victim. I don't know what this dude's problem was, but none of the ones we've worked with, hundreds of them. And so I just want to say that I have a friend that's a DA, and she said there is a provision, a protective order, lifetime protective order, that is automatic for child victims. And from what I understand, eventually that was put in place.
So can you work with Mr. Schatzline, you think, to?
Absolutely. In
Okay.
fact, Mr. Schatzline and I go way back. We are personal friends. We did try to get our schedule together before the bill was
Okay.
written, and we're both so busy.
Okay.
But knowingly, intentionally, I think last year when I went to the Senate to testify, those were in the bill. So I think maybe it just accidentally got left out this time. But
So-
the other thing too is I'm sorry, go
Oh,
ahead.
go ahead, go ahead. I was just going to see if there's any questions.
Okay.
Okay, any questions, members? Okay. Well, we appreciate you being here.
All right, thank you.
What was the last thing you were going to say?
Okay.
Real quick.
That some of the people that we have helped have reconciled with, they were family members that were their victims, and they have reconciled. And this would create, when they get together and they're in the same household, this bill would create them, causing them to create a felony for them. So if there's a way we could get an opt-out for the victims, like they have an opt-in at trial or at the, on that end, if there's a way we can get an opt-out for the victims that do want to be around their family, that would be great.
Thank you for being here. We really appreciate it. We have Brandon Kopak.
Good afternoon. My name is Brandon Kopic.
Okay,
Mr.
sorry.
Chair, Mr. Committee members, I am representing myself and forgiven felons. I started getting sexually abused at age 3.
You're against the bill?
I am
in its
against the bill.
current
I
form?
apologize. Yes,
Okay,
sir.
okay, thank you.
I started getting sexually abused at age 3 by a male and female cousin, all the way to age 12. Whenever I finally said something, I wasn't believed by my own family. So whenever I started getting abused by a police officer while I was an explorer for that police department, over the course of 3.5 years, 60 to 100 times, sometimes at gunpoint, while he was on duty in a squad car in a uniform. And I didn't deal with it right. But the one thing that I noticed is that whenever I turned 18 and he was sentenced in a plea agreement, I didn't feel that he got what he deserved. I actually felt pity for him because I realized that him being on the registry for the rest of his life didn't undo what happened to me. I hate what happened to Brooke, and I am so sorry, and I'm so proud of the family to be able to stand up here and say what they did. But see, I didn't deal with my brokenness, and my brokenness led me to commit a sex offense, and now I have to register. And now I have more empathy than I had before. But see, the difference is that I did the work while I was in prison to really work on what was broken inside of me. I fully gave my life to Christ. I couldn't get counseling in prison because they don't offer it. So I went and got a bachelor's and master's in counseling so that I could really understand why I was thinking the way I was thinking and what was screwed up about me. And I dealt with a lot of my issues and ended up becoming one of the state's very first self-harm prevention counselors in prison, and then got out and now are part of a nonprofit organization. The sex offender registry, by and large, there's no empirical evidence that it works, that it actually stops recidivism. I say, if I would have gotten some type of counseling as a victim, I got 10 sessions that was paid for by the Boy Scouts because it was in conjunction with the police department. That's it.
Okay. So with the bill, what's your specific problem with the bill?
I believe that all sex offender registration doesn't directly stop recidivism.
Okay.
And I believe that since sexual assaults continue to rise on average and the sex offender registry continues to grow, that we're not dealing with the underlying problem.
All right. Any questions, members? Okay. Thank you very much for being here. Members, we have Richard Gladden.
Chairman, members of the committee, I appreciate you allowing us to come speak on this. I'm opposed to the bill, HB 1913.
And you're here on behalf of yourself?
On
right?
behalf of
Yes,
myself
sir.
only. I'll try to get through quickly. I know a whole lot of information, so if anybody has any questions, I'd be happy to answer it. There's some information that has not been disclosed either back in March of 2023 when Representative Slatsline, proposed the bill. He was under the impression then, as he is now, that there's not already a law that someone, a prosecutor, when someone's sentenced for a sex offense, not only under the Victims Bill of Rights, but under Article 7B, which I've made copies of and highlighted for you, a prosecutor and the judge is obligated to impose a protective order that in most cases would apply to a convicted person for life, okay? And so you don't wait till they get out of prison. You don't wait till after they get out of the courtroom. That law goes back to 2007. This case, the offender was convicted in 2013. The prosecutor did nothing to ask for a protective order. The family did nothing to ask for a protective order. The guy gets out 10 years later. The family still does nothing to get a protective order. Ms. Stevenson did testify before you last time that she had gone and talked to a lawyer who said there was no such provision. 7B's been there. In fact, Representative Cook authored a bill that amended it. We not only have these requirements where the thing has to be imposed for free by a prosecutor at the time of sentencing, but there's also the Court Office of Administration has a website where if you don't find a prosecutor to do it, they've got an interactive link. You click the link and it's right there. You fill in the information. Now this question, if I could just get another 10 seconds. The question about notice, this bill doesn't have anything about knowledge or anything, but in 7B, it has a provision where, just like any other protective order for violent offenders or anything else, the offender who's supposed to comply with it is entitled to know the address they can't go within the distance of. Otherwise, there's just no way it could work. Just no way. This 7B also has what's called the opt-out. Is if a victim tells the prosecutor, I don't want a protective order. This is my uncle. We go to Christmas together now. We go to Thanksgiving, Mother's Day. Please don't separate me. I've reconciled with my offender. This bill doesn't have it. We've complained since 2023 to the Representative Slatsline. He's done nothing. In fact, he took out the amendments that the Senate committee required to be put in there to address some of these things. And you asked the question at the hearing in March 2023 of the representative, wouldn't a protective order fix this problem? And he said, there's no way you can get a protective order to fix this problem. In this very case, the last testimony was in the Senate, May 18th. The family, or actually Brooke herself, the next month went and got a protective order in her county. It was filed. Within 6 days, the judge signed it, and in fact, the offender agreed to it. It was an agreed protective order for life, and he was the one that moved. It wasn't the family that moved. Does anybody have any questions?
Any questions? Okay, thank you for being here. We have Brady Gray. Yes, sir.
Good evening, Chairman and members. My name is Brady Gray. I'm the president of Texas Family Project. I'm here today to support House Bill 1913, Brooks Boundary. This bill isn't about punishment. You heard that
Hold on
earlier.
1 second. So you're here
Yes.
speaking on behalf of Texas Family Project and yourself,
And myself,
correct?
yes,
Okay,
sir,
yes, sir.
for the
Thanks.
bill. As you heard earlier, this bill isn't about punishment, it's about protection. And for survivors of sexual abuse, knowing their abuser could live down the street or even next door is much more than just disturbing, it's re-traumatizing. There are laws that bar sex offenders from living near schools and daycares and playgrounds, but we need a provision that ensures that they don't live next door to their victims. And this need is very real. Texas Department of Public Safety shows that there's more than 100,000 registered sex offenders in Texas. Nearly 25% of them were convicted of crimes involving a minor. These individuals are legally monitored, but Texas, as far as I understand, and we've heard some conflicting testimony today, currently offers no statewide protection preventing them from moving in near their victims. Victims' families in Texas today are being forced to move, change schools, alter their routines, and simply avoid unintentional encounters with their abusers. And that's not justice. That's a failure to uphold it. Brooks Boundary would shift that burden back where it belongs, onto the offender and not the victim. Our laws must reflect moral clarity and compassion. The rights and safety of victims must come before the convenience of offenders. And HB 1913 is a focused, enforceable solution to that real and documented threat. It sounds like we have some great stakeholders in the room to help clean up a few of the issues that have been identified in this bill, and I'm confident that can be done. And I'm very thankful to Representative Schatzline for his leadership on this, and I urge you to support this bill as it is amended.
Thank you, sir. Any questions for Mr. Gray? Thank you for being here. We have, the chair calls Mary Sue Molnar.
Hi, good afternoon. My name is Mary Sue Molnar. I'm testifying on behalf of Texas Voices for Reason and Justice in opposition to House Bill 1913.
Oh, let me clarify. You're testifying for Texas Voices for Reason and Justice and yourself, right?
Sure.
Okay, great.
So good afternoon, Chairman Smithy and committee members. I oppose House Bill 1913 for a few important reasons. First of all, TDCJ has no authority over people on the registry unless they are on parole. And they can opt into victim services, and then TDCJ can control where they can and cannot live. But if they're not on parole, TDCJ has no authority. So first of all, there is no opt-out for the victims who may not want to be included in this law. Because many offenses occur in the home and by someone related to the victim, it's not uncommon for some victims to choose a restorative justice type of healing. There are licensed sex offender treatment providers here in Texas who offer family reunification programs for victims who choose to heal through reconnecting and repairing their relationship with the person who abused them. Again, it is not uncommon, and it is the victim's right to choose their own path to healing. House Bill 1913 offers no exemptions for victims who choose that option. And as you've heard, most people on the registry, they don't know where their victims live. With over 100,000 people on the registry, we're talking about thousands of registered people who might feel the need to search for their victim's address in order to stay in compliance with this law, whether it be moving to a new location, going to dinner, going to church, or even the emergency room.
Okay.
So thank y'all for listening to my testimony.
Well,
Appreciate
thank you
it.
for being here. Any questions? Thank you very much.
You're welcome.
Appreciate it.
Thank you.
Is there anyone else here to testify for, against, or on House Bill 1913?
Yes, sir.
Okay. Have you filled out a form?
Yes,
That's
you called
Fran
my name
Rhodes.
earlier, but
Oh,
I
I'm
had
so-
stepped
I'm
away
sorry.
to do a Senate hearing.
Okay.
I apologize for that.
Okay, if you would, your Fran,
Fran Rhodes.
okay, Fran Rhodes, if you'll state your name and your.
Yes, I am
who-
Fran Rhodes. I'm president of True Texas Project, and I am here representing myself and True Texas Project in support of HB
Okay.
1913. We strongly support this bill because we believe the rule of law, and we believe in the rule of law, and we believe that victims of sexual abuse should have as many protections from their abusers as we can possibly give them. There's probably nothing more devastating to a child or an adult than being sexually abused. And unfortunately, it is not uncommon in our society. Recovery and rehabilitation are possible for victims, but that recovery can be hampered if the abuser has access to the victim. This bill would ensure that sex abusers cannot be within 2,500 feet of the victim of sexual abuse. This bill is about common sense, and I definitely love me some common sense. And it's based also on existing law. Registered sex offenders already have restrictions about where they can live, and this just adds one more layer to keep them from intimidating their victims in close proximity to their homes. Homes should always be a safe place, and victims of sexual abuse should be able to feel safe in that space. HB 1913 provides a barrier between offenders and their victims that will enhance that same sense of safety and help them heal. We strongly support the bill and urge the committee to pass it favorably out of committee and to the floor for a vote.
Okay.
Thank you.
Thank you, Ms. Rhodes. Any questions, members? Okay, thank you for being here as well. And so we have anyone else here to testify for, against, or on House Bill 1913? If not, Representative Schatzline, you ready to close?
Sir. All right, thank you so much, Mr. Chair, and as well as members. Want to just address a couple things that were said. So it was claimed up here that the sex offender in Brooks' case had to move rather than the family. That's patently false. His family was forced to move, and that's just not a true statement. Additionally, I really appreciate Sheriff's Association with their suggestions. I spoke to them as they left. They would recommend that we change some of the language. I told them we would absolutely change some of the language. The two main variables there with the committee sub we'll be submitting will be making it an opt-in option for victims. That way, if they don't want to disclose to TDCJ, where they live, that's okay too. We want to protect the rights and the privacy of those families. But we also want to give them the tools to be able to protect their family in the same way. I want to say I genuinely appreciate what Forgiven Felons does. I love Jay Dan. We are friends. We did ministry together in South Dallas. And what I will say to that is the knowingly language I'm very open to as well. I want to make sure that we are protecting victims, and we're doing so the way that we can actually enforce it from law enforcement, and so we'll add that into our committee sub as well. I'm very committed to working with any of you on language. My sole goal is to make sure that we protect these victims from offenders terrorizing them once they get out of prison or jail. So with that, I'll take any questions, and I ask that you would have favorable consideration and send this bill to the Calendars Committee so we can get it done and we can protect victims.
Okay. Any questions for Mr. Schetzline? Okay. Thank you.
And I close.
so if
Thank you.
there's no objection, the chair will leave House Bill 1913 pending for now. I've got a couple of authors here. Is it okay if Mr. Cunningham comes up because he's only got a couple of witnesses? Mr. Cunningham, you ready to go? Let me go ahead and call you up. The chair lays out House Bill 2180 and recognize Representative Cunningham. But you got to talk fast, okay?
Thank you, Mr. Chairman, committee members. Thank you for this opportunity to lay out HB 2180. Currently, law enforcement evidence rooms around the state are required to hold on to evidence during a court case in which the defendant has already pleaded guilty, relinquished all rights to an appeals process. This has led to an increase in evidence and property in these rooms, resulting in evidence rooms exceeding its capacity, and law enforcement agencies and science centers needing to build temporary pods and holding rooms, expanding unnecessary costs. Years will go by before destruction orders are received and requires research to be done in a case that would have been available at the time of a guilty plea. House Bill 2180 allows defendants who have entered into a plea of guilty or no contest, acting with counsel, to waive the right to the preservation of evidence in a case where all is applicable. The bill creates a format for a waiver, which is currently in use in Montgomery County, has been for several years. All parties in the case, the prosecution, the judge, the defendant, and his or her counsel are required to be present at the time of the plea. This allows for the destruction order to be done at that time. If the defendant pleads guilty and decides to waive their rights to the preservation of evidence, the bill allows for 4 possible options. 1, evidence of the property can be returned to the rightful owner. 2, the evidence of the property can be used by law enforcement. 3, the property can be sold by law enforcement. Or 4, it can be destroyed. The defendant and their counsel and the court have 120 days after signing the waiver to object to the plan of destruction of any evidence. The bill does not allow for the waiver to be used as part of a plea bargain agreement. Finally, this bill allows crime laboratories to preserve any evidence it deems necessary to comply with accreditation requirements. I know it wasn't that fast, Mr. Chairman, but thank you.
Fast, okay.
And I do have some witnesses
Okay.
if there's any questions that are needed.
Any
I
questions,
reserve the right to
members?
close.
Okay, thank you, Mr. Cunningham. Chair calls Dan Zintek.
Good afternoon, Chairman.
Welcome.
I'm Dan Zintek, Chief of Police, Humble Police Department. I'll be representing the Humble Police Department and myself in favor of the bill.
Okay, thank you.
Yes, sir. So to elaborate a little bit further, I also serve on the Legislative Committee for Texas Association of Property and Evidence. This has been an ongoing issue, and I've been in law enforcement 33 years now. 17 years of that was in Montgomery County, and now the rest of my term was in Harris County. Not every place has all the divisions, SWAT, crime lab, all those things. Every single law enforcement agency in this state has a property room, and they fill up. Right now, we looked at an expansion for ours. It was not a large expansion. It was probably about the size of where y'all are sitting, and it was $1.2 million. Now, here's the reality. In Montgomery County, at the end of a case, and I excuse my ignorance of y'all's expertise of law or otherwise, but that's the time that you fill out all the other paperwork, all the times they have to go do their fees, probation, otherwise, while everyone is present. Everyone knows the case at that point and can make a decision on property. And maybe that property is to return some of it to families, some of it to the lawyers for payment. Otherwise, it's all handled there. While the defense is present, the defendant is present, and the judge is present and knows the case. What has had to happen is we have cases that are 10 or 20 years old that we have to go back to the original court, that the judge is not the judge anymore, the defendant is not present, the defense is not present, and the court has to do research to determine whether or not destruction should happen, instead of everybody being present. Now, the cases that we're talking about, some of the arguments that we had in the past, is what about people that are later found innocent? And I think in the last time we brought this up, Michael Morton. I will say now, Michael Morton never claimed guilt. He always claimed his innocence, and we're not talking about those defendants. We're talking about people who have walked up, said, I am guilty, I give up my appeals, I am pleading guilty for no other reason than I am guilty. And we need to decide all the issues related to this case, including the disposition of property.
Okay.
It is handled the same in Chapter 18 with other disposition of property, and the language is very similar. So again, I'm open for any questions.
Okay,
Thanks,
any
sir.
questions? Yes, Mr. Lauterbach.
Yes, sir.
Appreciate what you do. Your testimony is spot on, but I want to make sure the committee understands what Representative Cunningham has brought before us is a true challenge for law enforcement. From agency to agency to agency all over this state, the property room issue is a major, major concern because we don't have an effective way of old evidence, of preserving it. We run out of room, evidence is stolen, evidence is eaten by rats, we have a number of issues that are going on here. So I appreciate Representative Cunningham bringing this, appreciate what you do, thank you.
Thanks, sir. I would challenge every representative here to visit their property rooms in their area, and they will see the issues that we have.
Okay, any other questions? Okay. Thank you very
Thank you
much
for
for
your
being
time.
here. Brady Mills.
Good afternoon, Mr. Chairman, committee members. My name is Brady Mills. I'm the chief of the Crime Laboratory Division with the Texas Department of Public Safety. I'm on the bill and as a resource to address any questions. I would just make two comments. There's two really good points. One point is that the individuals that need to be able to make that decision are all in one place during the plea agreement to make a decision about the evidence. And then we see this as a help for our toxicology evidence. Toxicology evidence is blood tubes. We have about 40 to 50,000 blood tubes that we're storing for driving cases in our Houston laboratory. We also have to maintain those in refrigeration, which is a challenge to have that many tubes in refrigeration for a long extended period of time. And toxicology evidence it degrades over time. And so just the value of having those tubes sit there for time is a challenge for this forensic science as well. But I'd be happy to address any questions.
Okay. Well, we appreciate you testifying on it. Any questions, members? Oh,
Yes, ma'am.
Ms. Rodriguez-Ramos.
You referenced in the previous witness to the storage of all of these items, and you said a toxicology having all of that refrigerated. Is there not a limit to how long you need to hold any evidence?
It's based on the sentence, and so it's based on each individual case and each individual sentence that the defendant would receive. The challenge for us is we don't have that information, and then we don't have a really good conduit into getting that information because we rely on our investigators to get that for us. And so just that process causes us an undue strain to get the information, and then based on the sentence, there's an extended amount of time that it's retained.
So it seems like that would be the answer, as opposed to getting rid of the evidence, period, is creating a process so that you guys do have that information automatically and then setting a time limit for that evidence to stay in your hands and then be destroyed, as opposed to the person is feeling overwhelmed, the world is falling apart, and then they're gonna sign this, and then they're gonna close the door on any prospective information that may exonerate them in the future. So it just seems like this is not the solution for the problem, but thank you, I appreciate it.
Thank you.
Anything else, members? Thank you very much for being here.
Thank you, Mr. Chairman.
Is there anyone else to testify for, against, or on House Bill 2180? If not, Representative Cunningham, you ready to close?
Yes, sir. Once again, Chairman Smitty and committee members, thank you for allowing me this opportunity. This bill, I will add, well, we had it last session here in this committee, and well, in the subcommittee. And so we're bringing it back because we had a number of defense attorneys and everybody that came up and offered suggestions. And these were some of the points that we pointed out. And so while there might be some that still might object, I think that this bill will do what needs to be done. It was mentioned earlier, visit your property room. I visited mines in my home city. I've also visited the city of Humble. No, I mean, the city of Houston. And it is overflowing, and they've got stuff that's outside. And then just trying to keep, I think, Representative Ramos mentioned about the timelines. They've had some stuff that's been there since 1983. And so it's just trying to be efficient in getting rid of evidence at a proper time with all parties involved. Thank you again, Mr. Chairman, I close.
Thank you. Any questions? Ms. Rodriguez-Ramos.
So did you ever consider writing a bill to limit that they don't have it since 1983? I mean, if that's the issue.
Well, and what we had to do, Representative Ramos, was to make sure that we didn't touch anything as kind of like sex-related and things of this nature, because there's a requirement that property has to be preserved for X amount of time. And forgive me, I don't know what the year is, but I know it's over 20-something years. And this piece that I'm talking about, it was been there since like 1983, so almost, over 40 years now. So this was brought to me by law enforcement to address an issue of the property, and so how to get rid of it at a proper time. As I stated earlier, Montgomery County has been doing it for several years, and so we bring it before this body. I hope to have a favorable vote.
And are you familiar with the Innocence Project?
Somewhat, yes, ma'am.
So this is like the Anti-Innocence Project?
Some would probably say that, but I don't think it is.
Why wouldn't it be? If they're using evidence from previous years that helps prove that their DNA was not theirs or they're exonerated. This is saying we're gonna get rid of it right now.
Well,
So and people plead guilty. We know statistically they plead guilty even though they're not.
Well, once
for many
again,
reasons.
it's taken into account that we're going to have not only the judge, but the prosecutor, we're going to have the defendant, his or her attorney, all there at the same time. And this is not about a question of innocence or guilt, but I've already pleaded guilty.
Yes, and we know people do that under pressure.
And that was the group, the last session that brought it in, and I says, okay, help me to find balance. And this is what I'm bringing to the committee. And this was the balance.
Thank you.
Thank you, Ms. Ramos.
Go ahead, Mr. Munn.
Just to be clear, the defendant still has to sign this affidavit that waives their right. So if they are concerned that they really are, innocent and they want an opportunity to prove that later, they would just not sign this, correct?
That's correct, Representative Money. And then also, by signing this, you still have 120 days to say, you know what, I changed my mind.
And if we had to, we could make an exception for DNA evidence too.
I think, as I said,
Absolutely. Is it?
Yes.
Okay. Well, and it may be elsewhere in the law, but DNA is not as cumbersome to store.
Well, and I think if I don't know if the chief said it or the other guy, the toxicology part is not even included in this bill. So that is the exception.
Yeah. If I'm the defendant, I may want my DNA evidence destroyed.
Yeah.
So, Mr. Moody.
Yes, sir. Rep.
Mr. Moody has a question.
No, thank you, and I apologize for coming in midway. I think if we limited this to drug cases, that's going to do a lot in clearing up space, and maybe doesn't touch some of the other matters that have been raised as concerns. I know you've been working on this, and so I'm just throwing that out there as something that I think would alleviate some of the problems, and then it also would address some of the concerns on these other cases. The innocence cases are a mix of things. Some of them are pleas, some of them are jury convictions. I think limiting the scope is something that would be something worthwhile to talk about, and maybe we can talk with some of the folks that came and testified to say, does that give a certain amount of relief in those cases? Anyway, just something for just food for thought.
Yeah, and thank you, Rep. Moody. And as I said, we had this bill last session, and took up some of your advice, along with some of the people that voted, that voiced opposition, and that's what we came up with. And so, the toxicological evidence, it's not included in this bill, which addresses what we're talking about now.
No, and I think that's the conversations that you had on this last session. I think were very productive, and I appreciate you working with everybody to bring it back.
Thank you, sir.
Thank you.
Thank you. So if there's no objection, the chair will leave House Bill 2180 pending for now. Thank you, Mr.
Thank you, Committee.
Ms. Lopez, you've been there forever. Let me get you up here, and you've been hiding back there. The chair lays out House Bill 2282 and recognizes Representative Lopez. Thank you.
Thank you, Chairman Smithy, members. Appreciate you all. Thanks for this opportunity to lay out House Bill 2282. This is a bill that addresses a simple but long overdue update to our criminal justice cost structure. We all know that law enforcement is an essential aspect of maintaining a safe and just society. However, currently, Texas pays fees when a person is arrested. This places a heavy financial burden on taxpayers. That is why reimbursement for fees is an excellent way to help reduce the cost and shift some of the burden to those who have been found or convicted of a felony or a misdemeanor. This bill seeks to adjust the fees imposed for executing or processing arrest warrants by a modest $25. That means that currently the defendant pays $50, and it will move that up to $75. So just a $25 difference. The actual cost of serving a warrant is between $75 to $104. If we enter this calculation in common terms, that means that since 1999, taxpayers have paid $13.7 million because of this. So reimbursement fees cover the expenses incurred by law enforcement agencies in investigating, prosecuting, and detaining individuals accused of a crime. This approach ensures that taxpayers are not left solely responsible for the cost of criminal proceedings. Rather, the defendants who have been found guilty of the crime will bear some of the costs incurred during the investigation, prosecution, and detention. So in conclusion, reimbursement fees must be a crucial aspect of our justice system that helps to reduce the financial burden on taxpayers. So by charging defendants that are found guilty of a crime, we can ensure that they bear some of the costs incurred during the investigation, prosecution, and detention. Thank you, Chairman, for letting me lay out this bill, and I believe there are witnesses.
Yes, we do have several registered. Didn't you have this bill last session as well?
We did, yes.
You're
We
good.
carried it last session, and the constables and the justices of the peace asked us to carry it again.
Okay, and where did it happen last session? Did it make it to the,
So I believe it died before.
in the committee? Okay, I couldn't remember. I do remember the bill, so.
Mhm.
Members, any questions for Representative Lopez? All righty, thank you.
Thank you.
And- Is Constable Michael Orozco here? But we need you to register if you're going to testify. We have you down as testifying, but if so, you don't have to, but if you want to testify, you'll need to get registered. All right. So the first witness I'm going to call is Rylan Maxud. Rylan, we have you registered as Rylan, is it Maxud?
Yes,
Okay.
correct.
With the Texas Fair Defense Project, and you're testifying on behalf of the project and yourself, and you're testifying in opposition to HB 2282. Is that correct?
That's correct, yes.
You may proceed.
Thank you. First, I want to acknowledge why this bill may seem like an attractive idea. It raises from $50 to $75 a court cost in any criminal case where a warrant was executed or processed. That sounds a lot like shifting the cost of police time arresting bail jumpers from taxpayers onto the fugitive. I would not be here today if that's what that bill is. Of the millions of arrest warrants issued in our state annually, around 90% come from finally offenses in justice and municipal courts. There are two common types of warrants. The first are bench warrants for folks who do not appear on citations because they cannot pay them and often fear being placed in jail. The second are capias pro fines, warrants to place someone in jail despite their appearance solely because they fell behind on payments. The vast majority of these warrants are never executed. They're simply placed in the computer to have the court send out scary letters, then are eventually removed once the defendant has enough money to pay. No police time is used in these cases despite being processed by the computer and accruing the fee. Warrant fees make tickets much more expensive, only for folks who do not have the money up front, and they prevent case disposal. I don't think $75 per charge, adding up to hundreds per person, is the right number to reimburse for computer processing. Court costs are supposed to be reimbursements, not punitive, unlike fines. I also don't think the intended targets of this bill are Texans with tickets they cannot afford to pay, despite making up 90% of all arrest warrants. To better reflect the intent to reimburse the taxpayer for police time arresting potential fugitives, I think an amendment to exclude finally misdemeanor cases from the entire statute is appropriate. Thank you, and I'm available for any questions.
Members, are there any questions for Mr. Maxud? All righty, thank you for your testimony. Next, we have Constable Chad Jordan. Constable Jordan, we have you registered as Chad Jordan, Constable Precinct 4 in Hood County.
That is correct.
And you're testifying on behalf of the Justice of the Peace and Constables of Texas Association and yourself. Is that correct?
I am, sir.
All right. And you're testifying in support of HB 2282?
I am.
All right. Please proceed.
Chairman, members of the committee, my name is Constable Chad Jordan, and I'm here in support of House Bill 2282, representing the Justice of the Peace Constables Association of Texas, the largest association of elected officials in the state. Thank you for the opportunity to speak to you today on this bill. This bill proposes a long overdue increase in the fee for executing and processing arrest warrants from $50 to $75. As a working constable, I can tell you firsthand, we've been doing more with less for decades. The current $50 fee was set over 30 years ago and no longer reflects the actual cost of serving a warrant in today's world. Fuel, vehicle maintenance, technology, training, insurance, and all these things have gone up significantly. But the fee has stayed the same. Most people don't realize this, but millions of taxpayer dollars are currently subsidizing warrant enforcement across the state. When the state doesn't reimburse the true cost of warrant service, the burden falls directly on the local taxpayers. House Bill 2282 helps shift the cost of taxpayers off taxpayers and back on the convicted defendants where it rightly belongs. Our data shows that the real cost of serving a warrant ranges from $75 to $104, depending upon distance, time, resources involved. That includes wear and tear on our vehicles, and again, fuel prices, cost of computers, technology needed to track and process warrants safely and accurately. This bill also strikes the right balance by acknowledging the need of indigent defendants. Courts already have this discretion under Article 4309 of the Code of Criminal Procedure to waive and or defer fees for those who truly cannot pay. So we're not locking people out of justice. We're just making sure that those who can't pay or those who can pay do pay their fair share. House Bill 2282 is about fairness, fiscal responsibility, and public safety. It ensures that local governments are not forced to dip into property tax revenues to fund services that should be reimbursed directly through the justice system. I urge you to support this bill and bring this fee into the modern era. Thank you for your time and consideration. I'm happy to answer any questions.
Members, are there any questions for Constable Jordan? All right. Thank you, sir. Appreciate your testimony.
Thank you.
Next, we have Judge Ron Cunningham. All right, we'll show Judge Cunningham of Texas County Judges and Commissioners Association as not testifying but he is for the bill. Next, we have Stacy Suits. Constables, we have you registered as Stacy Suits, Travis County Constable, and you're testifying on behalf of Travis County Constable Precinct 3 and yourself. Is that correct?
That's correct. And
All right.
I appreciate the opportunity to speak to y'all, and I'll be very, very brief. In 1951,
Hold on one second. You're testifying in support of the bill, correct?
Yes, sir.
Okay, go ahead.
In 1951, the legislature set the warrant fee as for $3. In the 85 or 87 session, when I was working with JPCA on the legislative board, we raised it up to $35. That was pretty much the market rate of what we were serving civil process for at the time. In the mid-90s, we came back and raised it up to $50. That's what we were serving civil process for in the mid-90s. Now, in the urban areas in part of Texas, I've checked, we're averaging $70 to $85 to serve a citation, just a regular old citation. We need to do some cost recovery on that and then adjust for inflation. I don't think this is erroneous, and like Chad said, the judge can make adjustments in the fines and fees, and that's it, and I appreciate y'all's time.
All right, we appreciate your testimony. Members, any questions for Constable Suits? All righty, thank you. Is there anyone else that wants to testify on, for, or against House Bill 2282? Are you registered, sir?
I'm registered but not to testify. I want to sub in for Judge Cunningham.
What's your name?
Rick Thompson.
Good. Okay. All right, we show you registered as Rick Thompson, Legislative Director for County Judges and Commissioners Association of Texas, and you're testifying in support of House Bill 2282.
Yes, sir.
All right, please proceed.
Thank you, Mr. Chairman, members, and thank you for letting me step in at the last moment. This is real quick. Judge Cunningham had to go home, but I wanted to point out, from the Commissioners Court side, from the state of Texas, we really support this bill because the taxpayers shouldn't be footing a bill for those folks who are not showing up for court. And we have indigency process if they cannot afford it. So we support increasing the fee from $50 to $75. Llano County has 2,300 active outstanding warrants. It's a population of 22,000. That's a lot of backlog in the court, a lot of cost to the county. So we're looking for some relief, and we appreciate your consideration on this bill. Thank you.
Thank you. Members, any questions for Mr. Thompson? Hearing none, Chair recognizes Representative Lopez to close on the bill.
Thank you, Chairman.
Can you give me 1 second? Okay, yeah, go ahead.
So just to close, Article 43.091 does talk about the waiver of payment for fines and costs, which is a waiver of payment of all or part of the fine imposed of a defendant if the court determines that the defendant is indigent or does not have sufficient resources or income to pay. So that's one. And this is costing Texas $13.7 million. There's been 3 million arrests that this affects for arrest warrants, KPS pro fines, and some of these funds are used not only for technology, like was mentioned, but also to give pay raises to deputies, sheriffs, and clerks, and so forth. So, members, I ask for a favorable consideration. This bill had passed through the committee last session and placed on general calendar, and it died before it could go to the House floor. Thank you all so much.
That's consistent with my memory. I thought it got out of committee. So, yeah, thank you for bringing this again this session. Members, any questions for Representative Lopez? All right, members, are there any objection to leaving House Bill 2282 pending? Hearing none, House Bill 2282 will be left pending. Thank you. All right, you two both been here for a long time. You have two bills. Do you mind if we take spillers? Y'all both have the same number of witnesses. If not, you guys can arm wrestle it out. Sorry. All right, Chair recognizes Chairman Spiller on House Bill 3553.
Thank you, Chairman Cook.
And Chair lays out House Bill 3553.
All right, thank you. Thank you, Chairman, and thank you, members. Thank you for your time. Thank you for Chairman Harless. House Bill 3553 amends Section 9.42 of the Texas Penal Code to modify the justification for the use of deadly force in the defense of property. Currently, the law permits deadly force to protect property only under specific circumstances, but specifically including a provision that applies to two of those offenses only at nighttime. This bill removes the nighttime restriction and clarifies when deadly force is legally justified. Specifically, House Bill 3553 seeks to improve and clarify the law by removing the nighttime limitation for using deadly force in defense of property for the charges of theft and criminal mischief. It clarifies that deadly force may be used to prevent crimes such as arson, burglary, robbery, aggravated robbery, theft, and criminal mischief at any time of the day, rather than being limited to nighttime incidents. It maintains existing safeguards requiring that the use of deadly force must be reasonable and necessary to prevent the loss of property or to stop a suspect fleeing immediately after committing one of these offenses. So by enacting these changes, House Bill 3553 ensures that Texans are consistent, have consistent protections under the law regardless of the time or day. And Mr. Chairman, subject to any questions that the committee may have of me, I would respectfully request the opportunity to close.
We will do that. Members, any questions for Chairman Spiller at this time? Hearing none, we'll move to witnesses. And Chair calls Rylan Maxsood. Mr. Maxsood, we have you testifying on your own behalf and that you are registered as Rylan Maxsood and you're testifying against House Bill 3553. Is that correct?
That's correct.
Please proceed.
Thank you. This bill would eliminate the nighttime requirement for someone to use deadly force to stop only a simple theft or vandalism or to prevent someone from fleeing with property after a non-violent theft. This statute, a national outlier, has been routinely used many times before. For example, in 2010, a Houstonian swiped a taco truck's tip jar with $20 in it after the sun set. He was shot and killed with a gun and ammunition worth 20 times that. In 2023, another Houstonian was legally shot in the back in front of a gas station while fleeing with soda cans he shoplifted at night. Both men legally killed with no due process over Class C thefts they could have just paid a fine for. If I swipe your pen right now and run out the back, why should I get killed? And there's no age limit in this statute. If a 12-year-old boy swipes a convenience store tip jar or candy bar or graffitis the side of the store in the daytime, why should we allow shooting the boy in the back and killing him as he runs away? Ultimately, the answer is deadly force should only be used to defend life. And stopping a robbery or forcible entry are already included in that separate self-defense statute. I support the Castle Doctrine and Stand Your Ground because they're about preserving your life and your loved one's life, not gratuitously shooting someone in the back over $20. I've unbuttoned my jacket for this testimony to unconceal, to emphasize that bills like these are the current threats in Texas to our cause of gun rights and self-defense rights. Responsible, sober, level-headed gun owners, the average Texan, would never pull the trigger ever, except as a last resort to protect life. Respectfully, this bill is out of touch with us and doesn't represent us.
Any questions for Mr. Maxsood? Thank you for your testimony.
Thank you.
Next, Chair calls Kathy Mitchell. Kathy Mitchell, we'll show Kathy Mitchell as not testifying. She's registered on behalf of Equity Action and herself, and she's in opposition to House Bill 3553. Next, we'll move to Chris Harris. Chris Harris. Mr. Harris is not present either. He was registered to testify on behalf of Texas Civil Rights Project, and we'll show him not testifying, but against House Bill 3553. And that concludes all the witnesses we have. Does anyone else want to testify on, for, or against House Bill 3553? Hearing none, Chair recognizes Representative Spiller so we can get to Representative.
Thank you, Mr. Chairman, and I'm going to be brief, but I think I need to address this. Number one of the charges that this applies to is not vandalism. Vandalism is not included in these offenses. And if you look at Section 9.42 of the Texas Penal Code, there are several steps that you have to go through to be able to legally claim this. First of all, you have to be justified in using deadly force under Section 9.41. That's a completely different statute. And then you have to meet the requirements that it has to be one of these offenses, and you meet the specific requirements under Section 2 of 9.42. Then you have to additionally reasonably believe that the land or property can't be protected or recovered by any other means, or that the use of deadly force to protect or recover the land or property would expose the actor or another to a substantial risk of death or serious bodily injury. So that law has been in place for over 50 years. And I would submit to you respectfully that criminals are not as brazen 50 years ago as what they are now. And this came to me as a result of a meeting I had with a bunch of border folks down in Brackettville in Kinney County when they told me that their children, a huge group of 200 people, tell me that their children couldn't even go in their front yards and play. And this was not at nighttime, this is during the daytime. And my thought was, this is the United States of America. This is the state of Texas. The idea that children can't go out and play in fear of their lives is wrong. Even if it's not in my district, the idea that that is going on is wrong. And so this bill was brought primarily because of that, because I looked into the statute and thought how silly that we restrict only 2 of these provisions where it only applies at nighttime. So I think it brings consistency. And again, thank you for your time. I respectfully close and ask for favorable consideration.
Yeah, one question. Representative Ramos.
Sure.
So a 12-year-old who is painting graffiti or breaking windows or doors on a car what this bill is saying is go ahead and shoot that kid because he's committing criminal mischief. Whether it's day or night, he deserves to die for damage to a property. That's criminal mischief.
Well, intentionally or knowingly causing damage or destruction of property is criminal mischief, yes. But you still have to meet all the other requirements in Section 9.42 and 9.41 to be able to justify in doing this. Now, I would submit to you that probably most folks don't have a laminated checklist of all the things of 9.41 and 9.42 to decide if they're going to
No, they're just going to get the gun and say, it's daytime, he's messing with my property, I'm going to shoot the kid. I don't even have to wait until nighttime anymore. The kid is jumping my fence. Now I feel like he's affecting my property. Ask questions later, shoot the kid now. Yeah. This is, and in Texas, yeah, you're right, they're not going to have the paperwork to say it. They're going to have the gun to just do it, and they're not going to think about it. And I think this is a very irresponsible law because we're saying, we don't have enough killings at nighttime. Let's start shooting in daytime for something that's my property, and we've learned in law school, a person's life. This even allows that if the person is fleeing, you can still shoot them. We've been taught that a person is more valuable than a piece of property, and this is saying, no. We're in Texas. Shoot anybody on command if you feel threatened, and then you'll ask questions later. And the truth is, these kinds of laws affect not people like you as much as they do some of the other people on this panel. And the burden of proof then shifts very much so in these bills, in this type of situation. I think it's very, very harmful, and it doesn't, as the previous witness said, it doesn't even talk about an age limit. So, I'm not African American, and I don't know what it's like to be in that skin. But I had a friend who told me, my kid, an African American friend, who said, I had to drop off my kid to go get his car fixed, and I was terrified that he waited by the bus stop in a nice neighborhood in the front of the house. He waited under the tree because it was so hot. It just takes one person to say, that's criminal mischief. It's on my property, so shoot this kid. And the kid is just waiting for his mom to pick him up because his car's in the shop. Like, this is what you're doing in this type of legislation. Do you understand that?
Okay, let me try to answer that question. What I'm doing is, it's exactly the same law that's been in place for over 50 years. It only clarifies the nighttime restriction on two of the charges. And if you will look at 9.41 and read what it says, that someone has to do that. I'm not saying that someone can't be reckless and someone can't shoot a 12-year-old child in the back or something, but what I'm saying is they can't legally do that. And if you look at 9.41 and you look at the other requirements in 9.42, they prohibit that under the circumstances that you just described.
I'm reading 9.41. If the actor reasonably believes the force is immediately necessary to prevent or terminate the other person's trespass on the land. That's what 9.41 says. So that is part of what you're saying here. You
That's-
can do that. Shoot that person if they're trespassing on your land. The kid who just gets a shortcut through your land.
That's, but.
And
you-
don't
you
worry
have-
about it being nighttime. You can shoot them in broad daylight. You're all good.
Okay, but you have to look at, that's on defense.
9.41, what you just
Right,
said.
and that's one of the elements under 9.42. So you first have to look about using force, that you have to comply with 9.41. Then you look at 9.42, and you have all the other, under section 1, under section 2A, under section 2B, all of those, and there's an and after that, you have to comply with subsection
Yes,
3. And so you've got to do
9.42
all of those things. And
just-
so the situation that you describe, in my view, would be completely illegal and doesn't exclude anyone from being prosecuted for any criminal act resulting therefrom.
In your view, yes, you're right. It says this is allowing, and there is, I guess, somewhat you're talking about this as law, and I'm looking at the bill in 9.42, and I guess the common understanding is during nighttime. It's scary. It's night. There's a cloak of darkness where people may or may not know. And so there's more a presumption or a reasonable doubt that the individual may have, why are they walking across my field at night in my backyard? But so that makes sense. I'm scared somebody's running through my field and I shoot, I guess, whatever. But now you're saying this can happen during the daytime as well. And you're using deadly force to protect a piece of property. That doesn't make sense.
All right, but this is not changing the law. You can't use deadly force for criminal trespass, for walking across someone's lawn.
Criminal mischief.
Okay.
9.41, what you're talking about. That's exactly what it's referencing,
And that would be-
trespassing.
All right, and that would be
And that would fall
intentionally-
under this.
Right, and that would be
So you could
intentionally
kill
or
somebody.
knowingly.
You can kill somebody for that.
Well, you can under the law right now.
We're limiting it to nighttime because it's understandable that people are scared in the evening because whatever. Now you're saying shoot to kill in the daytime as well. Let's have a shooting spree 24/7 if you feel somebody is scratching your car.
Okay,
I
and
mean,
I-
this is ridiculous.
I don't think that's what my bill says, and I don't think that's what it provides at all. But I understand your concern.
Well, Ms. Jones? Yeah. Okay. Oh, I'm sorry. I just walked in. Mr. Latterback, you.
Let's discuss this from a more rational point. Notwithstanding that we have 9.42, the land or property cannot be protected or recovered by any other means. But do we not have today a very real possibility during the daytime where parents can't even let their children drop off at the bus? They've got to have someone there. They had to make arrangements the last 4 years even to pick their children up because of the intense fear and the problems they're running into with illegal aliens. Is that a fair statement?
I think so, absolutely.
Okay, so,
That's a
so
concern.
we also have 931, we also have 932. We have a build-out. Chapter 9 of the Penal Code covers deadly force use in our state. And you are absolutely correct in saying that 41 and 42 has been in place, and there are many safeguards in place under 42.
Right.
Thank you.
Mr. Verdell, I'm sorry.
Representative Spiller, thank you very much for bringing this bill. Looks like a very simple bill. It looks like it just makes this a gender-neutral bill and takes away nighttime versus daytime where you can defend your property at any time during the day. So I appreciate you bringing this bill forward.
Sure. And I'm happy to address any concerns anyone has with the bill to make it better. If you think there's something we can do to address, to put in some safeguards or something I'm happy to work with anybody. I haven't heard anything from anyone, any opposition to the bill, but if anyone wants to visit with me about it, even the folks that either testified or were scheduled to testify, I'm happy to talk to them.
Sure.
Just for those who can't see the bill, it just takes out the word he and puts in the person, which makes a lot of sense, so appreciate that.
In addition to it removes the nighttime exemption just on the limitation on theft and criminal mischief. It's already there for arson, burglary, robbery, aggravated robbery.
Yeah, and it's safe to say you should be able to protect your property whether the sun's shining or not. Is that correct?
I would think so.
I would
but
think
now,
so too.
You know,
Thank you.
yeah.
Ms. Jones, did you?
Hey, Mr. Chair, so here's my
concern. I can think of a number of places in my district and some other historically disadvantaged areas where there aren't sidewalks, right, in front of people's houses.
Most of
So-
my district does not have sidewalks.
Okay, so I could see somebody prefer, I remember when I was on city council, people didn't think it was a big deal, but walking in grass, you know, because it's safer to walk on the, like not in the street, right? So I can see that being a problem, where there's a non-criminal reason that somebody's on your property. And I mean, people walk across my property all the time. I presume it's because outside of my house I have a street light, right? And people park on like right in front of my house and walk on my property. Again, they don't do it to my neighbors, but they do it to me. I presume because of the street light, the other people don't have street lights. So that's one thing that concerns me. I also have a concern, just sort of like in my experience living. And I've shared, I have a nephew who's getting ready to go to college. Thank God, got a scholarship. So my sister and my brother-in-law don't have to pay. Honor roll kid. And the police literally presumed he was doing nefarious activity and hemmed him up. Of course, now he's traumatized by the police. He wasn't doing anything. He's a good kid. So there are some people, I can remember being in Fredericksburg, which I had never been in Fredericksburg before. One of my friends turned 60, and her birthday party was at this really nice Airbnb there. Just so happened, I was the only black person there. And the funny thing is, I ain't seen no black people there, even when I went to Walmart. But that's another story for another day. And when I got out of the car to go into the very nice Airbnb where all of my, no disrespect intended, all my white friends were, the lady across the street was looking at me like, what's she doing here? Right? And I remember looking at the lady thinking, I probably got a better job than you. This is what I'm thinking. I might be more educated than you, but you are looking at me like I'm a suspect in something. So the funny thing is, I like called my friend and I was like, hey, can you come out here? Because I don't want no problems with these people in Fredericksburg. You know, so I just think that there are some people just have a nefarious, well, they have beliefs that you're there for a reason that you're not. Ended up having a great time in Fredericksburg, let me be clear. Had a pool in the Airbnb and everything. Nice food. I can't remember the name of the restaurant. But I think that at least at nighttime, and this was daytime when I got there, right? But I was still looked at funny. So I just think that there's room. I guess my problem is, and I get at night why it's more scary probably, and I'll agree with Rep. Ramos that in law school they teach us life is way more important than property, and that's why you have to do things very specifically with self-defense. But I am just concerned that if you shoot first and ask questions later, somebody's dead. There's like no way to fix it because they're dead. So that's my concern, but I'm happy to speak with you. Sure. To see if there's a way, and for the record, somebody broke in my house at least a couple of times. My car's been broken into. I've been shot at. Thank God they didn't hit me twice on 2 separate occasions. So we can talk. I won't belabor the point.
And as been mentioned, there are other limitations in the bill that they have to use other means and so forth. You don't just come out and start shooting at people and using deadly force and with no other means. And it has to be for one of these offenses. You have to meet all the other requirements. So I think I've covered that already. But I understand your concerns.
But I guess my major concern is it allows an encounter to start off, and if somebody's afraid or somebody thinks you're doing something, there's not gonna be a lot of discussing, there's not gonna be a lot of talking, there's gonna be action. And then, so I just think that there's, like I said, I'm happy to speak with you about it. It doesn't, any situation where an unarmed person who's taking property or breaking into a car can just get shot is just concerning to me, because I just think about my son. I think about my nephews. Anyway, so that, we can talk.
And like I say, this bill doesn't change the law in any respect to that, other than the instance of the others that are limited by nighttime versus daytime. That's the only thing this bill does.
Right, but to me, that's big. Like, so I'm 59, I'm about to be 60, right? I don't see as good at night as I used to could. So I just can't see because my eyes don't allow in light. I found that out from the ophthalmologist. Didn't know that. So I understand why I'm afraid at nighttime, because I just can't see. But in daytime, I can see. And so I may be able to assess things more accurately in the daytime than I can at night. So taking away the cloak of darkness is big. So to me, it's just not that simple. But we can meet offline.
Happy to talk.
Okay, thanks.
Okay. Anything else? Oh, yes. Ms. Bowers.
Thank you, Mr. Chairman, and thank you, Representative Spiller, for bringing this bill. But I think it is as simple as what my colleagues and our colleagues are up here are saying. It's as simple as placing, property over people, and a lot of things are changing, not only in the state of Texas but in this country right now. And we're only 5 to 6 generations away from slavery. And I know that's a part of history that we don't like to talk about, but I'm just coming from the Smithsonian's National African American Museum in D.C. about a month ago, and when you're looking at, I got to the cotton gin era and the transatlantic slave trade, and that's when, value was placed on our lives as African Americans. And when you're talking about people could just shoot, day or night, and deadly force is what we're talking about here. And, I got Sheriff Louderback right here next to me, but I looked it up just now, and deadly force is also known as lethal force. It refers to the use of force that is likely to cause serious bodily injury or death. So what are you saying? That's what you're saying. They can use deadly force, right?
Yeah. As you can in the state of Texas for the last 50 years, yes. I'm not changing any of that. And I'm not changing anything about deadly force in the defense of a person. I'm not talking about deadly force in the defense of another person. I'm talking about deadly force as it relates to property. And the only thing it changes is these 2 exceptions that only apply at nighttime. And to me,
so, but that's putting a person's life over. Not to cut you off, and I would like to talk to you about it offline, and I don't want us to be here any longer than we have to, but respectfully, I do believe that you are saying that property is it outweighs a person's life, and it is more valuable.
I wouldn't say that. What I would say is this. When people, and I know they classify crimes, and I don't want to keep us here, but in answer to your question, you have crimes against people and crimes against property. And crimes against property are crimes against property, but those are also crimes against people. Those are crimes against people's liberty, their ability to live their lives in the way that they should have the right to in this country. And I think we can't ignore that. We can't separate it. We can't say, well, they came to steal this so I can shoot them in the back if they're 12 years old. That's not what this bill does. Okay. So I haven't changed the law. I haven't eliminated the restrictions. I haven't broadened anything. I've only taken away the nighttime exception because 50 years ago, as I said, I think criminals were not as brazen as they are now.
Okay.
And so to me, it's a common sense approach. But
And your district is where?
my district is everywhere. I go about 300 miles. I'm up on the Oklahoma border, and I go to about an hour north of here. So I cover a lot of territory.
Outside of Houston, maybe?
No, well, thankfully, I'm way outside of Houston, but yeah.
Well, I didn't
yeah,
think
I'm-
you were
yeah.
down by
No,
Houston,
no,
but
no.
I'm just trying to figure out, well, I do agree criminals are more brazen, but we can definitely talk
Sure.
about it, and we should, because it does sound like that's what this bill is saying, that property is more important.
Yeah.
And
I'm not saying that. I would never say that.
I appreciate that. Thank you.
Sure.
Okay, anything else, members? Yes. Mr. Verdell?
Thank you, Chairman. Representative Spiller, would it be safe to say that by this also enabling you to defend your property during the daytime, as Representative Jones mentioned, nighttime it might be a little harder to tell, but daytime it's a lot clearer that somebody that's trying to take your property is easy to identify?
I think the argument to be made that in the daytime, you might be under stricter scrutiny because you have to, it's a test to determine what's the most reasonable means, and you have to use reasonable means, and in the daytime, if you can see what's going on, you may be held to a higher standard. But I'm not a prosecutor. I've done defense work for 38 years, but I'm not a prosecutor, so I can't really answer that question. But I think certainly the argument could be made that someone should be more aware at daytime than what they are at nighttime.
Yeah, and where I'm from is, you know, I have a lot of oil field in my district, and there's a huge amount of theft going on right now in the oil field, daytime or nighttime.
Exactly.
And people are out there on private property, and they're having their stuff stolen from. They should be able to defend themselves, regardless of the time of day of that. All right, thank you, appreciate it.
Sure.
Okay. Anything else for Mr. Spiller?
Thank you,
Okay,
Mr. Chairman.
thank you.
I would respectfully close and request favorable consideration, and certainly willing to talk to anyone that wants to visit about it. Thank
Okay,
you.
now that was your closing, wasn't it?
What's that?
That was your closing.
It
wasn't
is it. I'm done.
Okay, great. Okay. Well, we're not going to give you another chance.
Good, good.
Okay. So, thank you very much. So if there's no objection, the chair will leave House Bill 3553 pending. Oh, hey, Lindsay, could you see if Mr. Money's in there? Okay, well, we had everybody here a minute ago, but we've lost one, so let's go ahead and hear another bill. And if y'all can hang tight, we'll hopefully vote. We've got two more bills to vote on. Mr. Harless, if you want to come forward, the chair would lay out House Bill 2177 and recognize Representative Harless. So, sorry to all the members and the witnesses. Sorry that y'all had to wait. We
That's okay.
try to get it moving.
Thank you, Mr. Chairman and members, and I do have a committee substitute. U.S. Government Code contains a provision that allows a service provider to voluntarily disclose certain information, including communication and location information, to a government entity if the provider believes in good faith that an emergency involving danger of death or serious physical injury to any person requires the disclosure of this information without delay. This includes non-criminal situations such as runaway children, critically missing persons, or locating the infirm. However, Texas law has no such provision to voluntarily provide this information. House Bill 2177 seeks to conform Texas law to federal law and provide law enforcement with these tools to help recover these individuals and ensure their well-being. The committee substitute just includes language that gives providers...
Hey, Sam, hold on just a second. So Representative Cook is going to lay out the committee substitute to House Bill 2177.
Perfect. So you want me to stop right there?
Nope. Go ahead and
All
start
right.
talking about the substitute.
The committee
now.
substitute just includes language that gives providers liability protection for sharing this information with law enforcement in an emergency. I do have a resource witness who's able to answer any additional questions, and I respectfully ask for the opportunity to close.
Okay. Thank you. Any question for Mr. Harless? Mr. Moody has a question.
So there's a general bar on disclosing that type of information, and your bill says, except as provided here, they can do this, and it has a series of factors. good faith belief that immediate life-threatening situation exists or requires immediate disclosure of the electronic customer data. So this is the exception to the general rule that they can't disclose this type of information. And I just don't know because I haven't looked
Yeah,
into
so
it.
currently,
Who's the ultimate arbiter of whether they acted in compliance with this? Like
That's
who's
a great
who's
question,
the
and if you don't mind, I'll let my expert witness
That's
answer
just-
that. But currently, what happens is if somebody is missing or they're looking for somebody, and I just had a perfect scenario in December about that. A good friend of mine was coming to see me, and he got lost. He had early stages of dementia. We couldn't find him. So they had to go through the FBI, the federal. So this just allows the state, and it cuts out the time frame right there.
Okay, great. No, I mean I definitely see the need to have conformity in the two federal and state side. I just want to understand who is the arbiter of whether they acted in good
I'm
faith.
sure they can answer that better.
Okay, anything else from Mr. Harless? Yes, Ms. Jones?
I want to make sure, so this is a situation where the police can put a tracking device on my car without a search warrant?
That's not this bill at all. This is 2177, ma'am.
We got 77 and 78.
Oh, I'm looking at the wrong one.
No problem.
Okay, phew. Okay, you're gonna get to that one too, huh?
Yeah,
I'm
we'll
gonna
get-
get
eventually
that.
we'll
We're
get
not
to
about
that.
Talk about that now. Okay, all right. Then I'll hold.
Thank you.
Okay, anything else? Okay, Mr. Riddell?
Representative Harless, I just have a quick question.
You bet.
If I understand this correctly, this would be bypassing a warrant process to get information, is that correct?
On 2177?
Yes, sir. Yeah, that should be the one I have up right now.
So currently, like I said, you have to, if they're looking for somebody who's missing or somebody with dementia or something.
Yeah.
Currently, there's a federal statute in place to help us with that. This just lets Texas conform to that law without a
Okay.
warrant.
All right, thank you.
You
Appreciate it.
bet.
Okay, anything else? Oh, yes, Ms. Jones?
So this lets the government without a search warrant track my phone.
I'm gonna let the experts answer that question, Ms. Jones.
Okay, thank you.
Thank you.
Okay, all right, thank you,
Thank you.
Mr. Harless. And we'll certainly reserve for you the right to close. And so we have Janet Nichols here with the Department of Public Safety. Captain Nichols, excuse me, I'm sorry, we appreciate you being here.
Yes, sir.
If
Good
you'll-
evening, Chair
oh,
Smith. Go ahead.
Well, just identify yourself and who you're with and that you're neutral on the bill.
Okay. Committee members, yes, I'm Janet Nichols. I'm a captain with the Criminal Investigation Division with the Texas Department of Public Safety.
And you're neutral on the bill.
Neutral here as a
Okay.
resource, yes.
Okay. Anything do you think you need to tell us, or are you just here for questions?
Just here for
Okay.
questions.
Questions? Yes. Mr. Wu has a question.
Thank you very much. As part of your normal job, you help find missing people, help figure out dangerous situations. Like somebody says, my elderly relative is missing, and they've driven off. We don't know where. This is something that law enforcement would take part in, right?
Correct.
Okay. And if they say like, I know my grandpa's got his cell phone on him. What this would allow y'all to do is without going through the process of going to a court, filing a search warrant, having a hearing on a search warrant, and coming back days or at minimum a long time later, if not weeks later, that you would be able to request request from a service provider. You tell them this is a non-criminal request. We're not looking for evidence. We're not looking for anything. We're trying to find this person that's missing. And if this law is in place, this would allow them to respond as we found the last location, the last ping is here.
Correct.
Okay. Thank you very much.
Ms. Jones, did you have a question?
No.
Okay. Let me ask you, so if DPS is investigating a fatal car collision, and all you've got is the license plate and the ID of some of the victims, how do you go about identifying next of kin to know? Do you know the answer to that?
So as far as like anything with this bill, or you're just asking generally?
Well, is there a procedure on that now, or would this bill help in that situation?
So no, this bill would not necessarily
Okay.
help in that situation. I
Okay.
mean, typically, if all we've got is the vehicle, you're just gonna go with registered owner and try to backtrack and find
Okay.
a next of kin.
All right. Any other, Ms. Jones?
So is it your understanding of this bill that there's gotta be, you don't have to go to anybody, law enforcement, just if they believe they have a reasonable good faith belief that somebody's missing or in danger, they can just do it?
I don't know what you mean by anyone, because it says a government entity, so it would be
Right,
like a
so-
law enforcement
right.
entity.
Police, constable, fire. Government. I mean, what's the definition of government entity? Let me see. Service. And then it says that a person does not have a cause of action against a provider. So like, let's say that somebody thinks somebody's in danger, right?
Okay.
They're like missing on purpose. They don't want nobody to know where they are. But, I don't know, somebody else thinks they're missing. That person can go, that government entity, whatever that means, can just go to the phone companies or cell phone companies and get their location data, and then they find out where that person is. And then the person who's found, let's say they find the person. The person who's found doesn't get to go after the cell phone company, even though they didn't want to be found. And their cell phone provider literally, I guess technically, picked the government entity over them. They wanted privacy. But there literally is an exclusion for a cause of action where I can't sue my cell phone provider for telling people information I don't want for them to tell. I guess is my concern.
So I understand your concern, I mean, a valid point, and I hear what you're saying. So what this is limited to really is like, if you look at the federal statute already, is there's gotta be certain things that we're, at least, you know, when, from my perspective, when we have done this under the federal statute, is there's gotta be certain things that are in a synopsis written up, proven to a degree. So it's a suicidal subject, like someone else said. Maybe somebody who's elderly with like early dementia, Alzheimer's, something like that, where there's a health risk. So it's certain.
But what if, I'm gonna
Okay.
use your example. What
Okay.
if I'm old, right? And I have heart problems and I still don't want nobody to know where I am. I just wanna leave. And I don't want nobody to know where I am. I don't want my child calling me. I don't want nobody bothering me. I would be bothered that my cell phone provider that I pay money to every month, probably a lot, to allow me to call stuff, to give out my private information. And then if they do, then I literally can't sue them for doing it.
So this would maybe be something, getting super in-depth on that, the expert that I don't believe is available today might better answer, but, I mean, I understand where you're coming from, absolutely. I think a lot of it, it's not just any health concern with somebody that's elderly. I know that they've talked more specifically usually about like, I think at times a diabetic's got in there when they know they're without their medication.
But I get-
Alzheimer's.
But when I'm looking at the words, it says, in good faith believes an immediate life-threatening situation exists. Like, I'd like so first of all, I think there's a reason there's a difference between feds and the state.
Correct.
Right? So I don't necessarily believe that what the feds cover, the state should cover, because they're separate. Let me start off by saying that. But the next thing I'll say is, what's the definition of an immediate life-threatening situation? I mean, I can see a situation where somebody could abuse this to find out where somebody is by saying they believed a life-threatening situation existed and they really didn't, but there's no arbiter, right? It's literally the exclusive decision of the governmental entity to basically invade my privacy without like a judge. Like with a search warrant, I get it. You think something bad is happening, we need intervention. We don't want to violate the Constitution. So we go to a judge and we say, hey, judge, there's all this really bad stuff or something's bad's happening. We believe there's probable cause. Please give us a search warrant. At least then there's somebody who can try to weigh the equities to see, as opposed to giving government, whatever that means, the exclusive decision-making to determine whether they want to go into my privacy. And then if they're wrong, I don't have a cause of action to sue them, sue the phone company. So that therein lies my concern.
Understandable. So again, I'm just a neutral, just a resource. But part of where you're comparing, where it's not a true comparative, is it's a non-criminal incident. Being a non-criminal incident, there's no way I can get a search warrant for your cell phone geolocation then, because there's no criminal offense.
But so, which actually scares me even more, because there's not a crime. So I still think it's an invasion of privacy. But I'm not trying to. I'm just trying to think out.
Yeah, no, absolutely.
I'm just trying to think it out. So at least if it's criminal, there's some urgency.
So some examples I can give you where this has been used before is, let's say you have a young family member and on Facebook or something you see where they've posted suicidal ideations and now they're missing. And you know they've got their phone with them. And now we have no way, this is trying to open that up where we can take action to try to help locate them.
I understand that concern, but I'm just worried about the Constitution.
Okay, I think Mr. Wu has a question.
Just real quick, could you please help allay some of my fears? If a person just says, could law enforcement go get, find out where this person I'm looking for is? Right?
Just generally.
Just
you
generally.
called me right now and asked to go find somebody. No, I couldn't do that.
Absolutely not, right?
Correct.
But what did they say? Like, well, I think they might be in danger and all this stuff, and you guys go out and locate the person using this service, right? When you find that person, do you just automatically take that person to whoever requested it?
No.
Or the officers would go there and talk to the person and say, hey, people are looking for you.
Certainly there's vetting on both ends, both before there's vetting. You're not just telling me somebody, oh, they are sick and we need to find them right now. There's got to be some proof of that when we're vetting that on the front end. And then certainly on the backside of that, there would be vetting as well.
I mean, this is a lot of work. You're not just going to do this for every person who just like runs up to the office.
No.
Okay. Thank you.
Yeah, that's good. So you got, Mr. Money?
One of my biggest concerns, I don't think we've touched on it yet, is that this seems to leave the decision-making to the provider of electronic communication service. So it says a provider of electronic communication service or a provider of remote computing service may disclose to a governmental entity if the provider in good faith believes an immediate life-threatening situation exists that requires the immediate disclosure of the customer data. And I'm concerned about this in two ways. Number one, I'm concerned because that leaves a communication service provider in a situation where they're trying to determine whether to violate someone's liberty rights that we've just talked about and their privacy rights of where they are. On the flip side, if they decide not to, and then that person commits suicide or is harmed in some other way, now they're open to liability because they did not provide that. It just seems to be that of whether or not this is a good idea generally to allow a mechanism to get that information is one question that we've talked about and then I have concerns about. But my second one is leaving the arbiter of that decision to be the service provider themselves, not the police, not a court of law, but a telecommunications company. That's very concerning to me.
Understood. I would believe that his expert witness would probably be the better person to answer that.
Okay.
Okay. And we may have to just investigate that after the hearing sometime. And I'm sure Mr. Harless will cooperate with that. Mr. Little?
Thank you, Chairman. What's electronic customer data?
What exactly is electronic customer data?
Yeah.
So like that can be your subscriber information, it's also your geolocations, anything that they're holding as data for your account.
Text messages?
No, most service providers don't hold text messages.
You're shaking your head. Signal chats?
Oh, Signal, no.
Facebook Messenger?
No, that's end-to-end encryption.
That's. This is not how I read the statute. So I'm looking at the definitions 18 Bravo.001. So it's electronic customer data means data or records that are in the possession, care, custody, or control of a provider of an electronic communication service, one, and contain information revealing the identity of the customer, information about a customer's use of the service, information that identifies the recipient or destination of a wire or electronic communication, the content of a wire or electronic communication sent to or by a customer, and finally, any data stored with the applicable service provider by or on behalf of a customer, or, location information. That's a ton of data, don't you think?
If the provider maintains that data, correct.
We can get text messages from a provider, right?
Each provider is different on how long they maintain those data records.
Yeah, but 2 years at least.
Again, an expert could probably explain that better, but I know certain providers know if we don't serve them with a preservation letter pretty quickly, they'll only hold them sometimes 30 days, 10 days. It just depends on the provider.
So I'm just imagining what is proposed as an immediate life-threatening situation. Let's say it's a terrorist suicide bomber, something that extreme. We think there's a terrorist suicide bomber, and we think this is who this person is. You can pretty much wring out that person's digital footprint from every electronic communications provider you can get your hands on without a warrant, right?
So technically right now I could do that with an exigent. I can do an exigent regular, I'm doing an exigent, this is a life-threatening situation, this is a criminal act, and within 48 hours, I have to have submitted the legal paperwork to continue that.
Now we're getting somewhere. So you already have the ability under exigent circumstances to seek a warrantless search of that data?
For a criminal offense,
So
yes.
what do we need this for?
This is for non-criminal offenses.
Doesn't say that. It's in the Code of Criminal Procedure, but it doesn't say that, unless I'm missing it. Do you see it in there?
I did not see that in there specifically, no, sir.
Okay. All right, thank you.
Okay. Anything else? Okay. Thank you for being here. We
Welcome. Thank
appreciate
y'all.
it. Okay, Kathy Mitchell. Ms. Mitchell, we'll show Ms. Mitchell against the bill but not testifying. Chris Harris. Okay. And so we'll show Chris Harris against the bill but not testifying. Is there anyone else here to testify for, against, or on House Bill 2177? If not, Chair recognizes Representative Harless to close.
I appreciate the conversation. Representative, if you want that in there about criminal, I would be happy to put it in there. This is just to help locate people that are missing or in distress, that we're concerned about life-saving situations. I believe already if it was criminal, they could get a warrant without it.
Yeah, may I respond?
Sure,
Chairman?
sure.
Yeah, I'm just worried about the government's ability to do that under non-criminal circumstances. And the reason being, this only calls for the government to have a good faith belief of certain allegations here in immediate life-threatening situation. And I'll just say that that's an exceedingly low bar, and I have some concerns about it.
I appreciate your concerns, and I just believe that we're going to act in good faith and try to help find these people a little bit quicker that are missing or have health issues. And with that, go ahead,
Mr. Wood? Okay. All right. Well, if there's nothing else right now, y'all can work on these.
Absolutely, happy to.
Try to work these out. So if there's no objection, the chair will withdraw the substitute that's been offered on House Bill 2177, and if there's no objection, we'll leave House Bill 2177 pending for now. Mr. Harless, if you can give us 1 minute, we've got everybody here, and I need to do a couple of votes. We got 2 votes left, actually. So at this time, the chair has recalled House Bill 1443 by Representative Schatzline from the Subcommittee on New Offenses and Change Penalties, and recognizes Chairman Louderback to explain the bill.
Thank you, Chairman Committee. Committee Sub HB 1443. The Subcommittee on New Offenses and Change Penalties voted 3-0 and 2 absent to recommend the bill be heard by the full committee. CSHB 1443 involves...
Well, let me first say that Chairman Louderback is going to offer the committee substitute on that bill.
Yes, will do. It involves current and new criminalization of the possession and intent to promote the possession of childlike sex dolls. Name of the bill creates a state jail felony for the possession of a childlike sex doll. It increases the penalty categories for the promotion and possession with intent to promote childlike sex doll. Lowers the threshold for automatically finding intent to promote the possession of childlike sex dolls, possession of 6 dolls to 2, and revises the definition of childlike sex dolls to be those that are anatomically correct and designed to resemble children for the purpose of sexual gratification. I now move that HB 1443 as substituted be reported favorably to the full House with a recommendation that it do pass and be printed.
Okay. So Chairman Louderback has made the motion, and so the clerk will call the roll. The substitute is there any objection to the adoption of the substitute? There being none, the substitute's adopted, and the clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money?
Aye.
Representative Moody?
Aye.
Representative Rodriguez Ramos? Representative Verdell?
By a vote of 11-0, the bill will be reported favorably. Is there a substitute on the next one?
No, sir.
Okay, so the chair recalls House Bill 2666 by Representative Verdell from the Subcommittee on New Offenses and Change Penalties, and recognizes Chairman Louderback to explain the bill and the subcommittee's action.
Thank you, Chairman, for the opportunity to explain HB 2666 before the committee. The Subcommittee on New Offenses and Change Penalties voted 3-0 and 2 absent to recommend the bill be heard by the full committee. House Bill 2666 increased the penalty for arson to a government building from a second-degree felony to a first-degree felony in the event of death or serious bodily injury. I move that House Bill 2666 without amendments be reported favorably to the full House with the recommendation that it do pass and be printed.
Okay, so Chairman Louderback has made the motion. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little?
Aye.
Representative Louderback?
Aye.
Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos?
Is this 2666?
Yes, ma'am.
No.
And then Representative Verdell? 10.
Okay, so by a 10-1 vote, the bill will, House Bill 2666 will be reported favorably, referred to the regular calendar. I think that's all the bills we have to vote on, members. So, Mr. Carlos, if you want to come backup, thank you for your patience. And so the chair would lay out House Bill 2177, and once again recognize Representative Harless. I'm sorry, 2178. Chair lays out House Bill 2178 and recognizes Representative Harless.
Thank you, Mr. Chairman and members. House Bill 2178 seeks to provide a mechanism for an authorized peace officer to install a physical mobile tracking device during an exigent circumstances, such as a high-speed chase where it's impossible to receive an immediate warrant. It will allow for the installation of those tracking devices from car to car through a projectile without a warrant when it's necessary to prevent an impairment of a criminal investigation, damage or destruction of property, death or serious bodily injury, or escape of a fugitive for a felony offense. Installation of such devices could only be done by an authorized peace officer and would require probable cause. The bill would also require law enforcement to obtain a warrant, a court order for a tracking device no later than 72 hours after the installation of the device. If a court order is either denied or not obtained within 72-hour time frame, the officer shall terminate the use of the device, and any information obtained through the use of it may not be used as evidence in a criminal proceeding. I believe we have some resource witnesses, and I respectfully ask for my right to close.
Okay, thank you. We'll do that. And so we have Jason Guillen. Thank you, sir, for being here.
Thank you. Thank y'all for having me. Good afternoon, Mr. Chairman. My name is Jason Guillen. I'm employed as a sergeant with the Harris County Sheriff's Office Violent Offenders Unit out of the Texas Anti-Gang Center. I've been at the county now 24 years, and I'm a TCOL instructor and a master peace officer. I am testifying in support of this bill and believe this bill would greatly enhance the ability of law enforcement to quickly and safely resolve cases involving violent crimes. I am humbly requesting your support in this bill, and I would like to thank you for this time.
Okay, thank you. Are any questions? We really appreciate your attendance
you.
here today.
All of you, thank you.
We have, we do have a question. We got a question? It's not going to be that easy. You're
I
going
apologize.
Thank you. So you want to be able to track a car and within 72 hours, which is that 3 days?
Yes, ma'am.
Then go and get a court order?
Yes, ma'am. Under exigent circumstances. That's the caveat. It's not just,
So is the exigent circumstance they got to be driving away real fast or something?
It would be either a felony. It's the way I read it, and in the verbiage that I read, it would be a felony. So it wouldn't.
Like possession of a controlled substance less than a gram is a felony. So you could do it on that?
The way it's written, yes, ma'am. When put like that, I guess there could be some different verbiage.
I'm just, thank you.
Yes, ma'am.
Okay, any other questions? Yes, Mr. Verdell. Hold on.
Hey, sorry about that. That's my
One
fault.
more,
I'm kind of
Mr.
slow.
Verdell.
No, you're good. You're good. That's me. I apologize.
What would happen during that 72 hours before you request the warrant?
We would probably send a team member down there to go get a search warrant from a judge.
So you would interdict before the 72 hours in, or
Yes, sir.
if it waited that long?
Yes, sir.
Okay, thank you, appreciate it.
I got it.
Mr. Little has a question.
Thank you, Chairman. So, Mr. Gain, I have a question about the use of the information. My understanding is that if you don't get the warrant, then the evidence becomes inadmissible at court, right?
Yes, sir.
All right. One of my concerns is the potential other uses of the data besides admission in an actual tribunal, in a court proceeding. I mean, that data would still have investigative value, wouldn't it?
I'm not real clear on what data you're referring
Well,
to.
so you put a tracking device on a car, you're getting a data set, 3 days on, you don't get your warrant, you still have a data set. And my understanding is nothing in this proposed statute would prevent you from reviewing, considering, researching that data. You just wouldn't be able to use it in court if you don't get the warrant, right?
Yes, sir.
Okay. That's one of the things I've got some concern about is that the use, the capture and then investigative use of the data, that as long as you don't introduce it in a court, you're still fine. And like what, can you imagine some potential investigative uses of that data that you might, where you might not try to introduce it in a court proceeding?
I cannot. No,
I mean, if
no.
it's, if, let's just say it's a robbery crew, an armed robbery crew, you're developing, you can use that to develop a pattern of life, whatever. You can figure out where these people are going, who they're associating with.
So yeah, in a situation like that, if we were to stick a car, manually on a robbery crew suspect, yeah.
Yeah.
Yeah, you could.
But if you don't get the warrant, then you still have the data, you just can't introduce it in a court.
Yeah, it'd
right?
be no good to you.
All right, thanks.
Good. Yeah, Mr. Wu has a question.
That being, I want to be clear, but that being said, if you discovered evidence based on that data, like you started looking around that area because of that data, that would be considered fruit of the poisonous tree, right? That
Yeah,
you,
it would
you
be-
got information that was not legally through a search warrant.
Yes, sir.
Or the search warrant was denied.
Mhm.
And then later on, using that data or information that you got from that, and you found other stuff, that's all tainted now.
Yeah, that's
Okay.
that's done. That's cooked.
So it's, the protection carries through even if you use it to find other stuff.
Yes, sir. Yeah, no matter. Yeah, if it's denied, then all of that's cooked.
Yeah. Thank you.
Anything else, members? I'm sorry. Mr. Riddell?
Couple questions. First one is, how would this be deployed onto a vehicle to track it?
Oh, well, there's several ways. So in the pursuit aspect, it would be in a car chase. In a manual aspect, it would be through covert surveillance, and we would manually stick a vehicle, under exigent circumstances. I've only seen that done on extremely violent crimes in extremely rare situations.
Okay, would it be if you're in a car chase, you could deploy it? I mean, but the person's already breaking the law then, right? So you wouldn't need a warrant to
Yes,
do
sir.
that, or? Okay, all right, thank you.
All right, thank you very much. Oh, I'm sorry. Okay, Ms. Jones.
I just want to play this discussion out for purposes of this conversation.
Yes, ma'am.
This dialogue
Absolutely.
only.
Yes, ma'am.
I can see exigency if somebody's running from the police.
Mhm.
But when asked about the deployment of this device, good word, by the way, I felt like I was talking about military stuff. You said it would be done covertly.
Yes, ma'am.
How is that exigent?
In a
Explain to me I'm just curious.
In let's say we get a kidnapping call and my unit responds to that call, and we don't have time immediately to get a search warrant. We have to, time is of an essence to either recover our victim or prevent the kidnapping. Then we would stick the car and go get the search warrant.
But you can get a search warrant under that situation.
Yes, ma'am, absolutely.
Like you could
But
pick up the phone
we'd have to
and
run.
get a search warrant.
We'd have
So-
to run. Yes, we'd have to run down there and get it, and we risk losing the vehicle.
You guys can surveil the vehicle. You can be following the vehicle while somebody's going to get a search warrant.
Following the vehicle is very difficult. It's very difficult
I mean,
without being burnt.
if you're surreptitiously surveilling the vehicle, so they don't know that you're following them, right? You're just
Right,
sort of
correct.
following them just to keep them like this.
Right.
Meanwhile, back at the ranch, you're getting the search warrant.
Yes, ma'am.
And then, because here's what I know. If you don't get a search warrant and there is no probable cause and there are no exigent circumstances, whatever you seize is kept out. That's well-established law, right?
Yes, ma'am.
But with this, there is no guarantee that you can't do exactly what Rep. Wu said. I mean, we just have to sort of take your word for it, that you're not using the information that you couldn't get a search warrant for later to get other stuff. So the fruit of the, you familiar with the fruit of the poisonous tree?
Yes, ma'am, I am.
Okay, that's well established in this country where the Constitution was formed and matters to me. So I
Me
just,
as well.
so that whole 72 hours, I'm struggling with that. But thank you.
Fair. Yes, ma'am.
All right. I think, is that all? I think we're
just-
done.
Oh, sorry.
Thank you for being here. So we have Janet Nichols, DPS. Welcome back.
Hi, yes, good evening. Janet Nichols again with the Captain with the Texas Department of Public Safety Criminal Investigations Division, here as a resource neutral.
Anybody have any questions? May get off easy this time.
Well, there's a couple things that
Okay.
maybe I could clear up.
All right.
Some questions, at least in my reading of this, is when we were talking about, is this any felony offense? It is not any felony offense. It's the 3G offenses and then escape or evading in a motor vehicle. The way this is deployed, there's, technology is ever-changing landscape. I don't know every vendor that has it, but there is one vendor that I'm familiar with out there, Star Chase, and it basically kind of shoots out kind of like a dart thing that places a GPS on a vehicle. To Mr. Little's point, no, absolutely, even if there's a pattern of life or something established in the 72 hours that we have to get the warrant, there's absolutely no way that we could use any of that. Even if we've got that data, we can't use that. That would be fruit from the poisonous tree if it was declined. If upon the serving of the paperwork, a judge felt we did not have the probable cause at the time that we used the device.
Any questions, Ms. Jones?
Is it your understanding of this bill that the warrant within 72 hours has, because what if you have deployed the device, you find out stuff that you can now use to show the judge 72 hours later?
No. My understanding of this is the warrant's written based on the information that you had when you deployed it, not information that you got in between. So I can't say Friday afternoon when I used it and then I found out it was involved in these other 2 robberies on Saturday. Or at those locations, we would not be allowed to use that.
So would you do a probable cause affidavit?
Correct.
Is that what you would do? Okay, thank you.
Yes, ma'am.
Okay, any other questions? Mr. Verdell?
Would it be correct to say it takes about 5 to 10 minutes to request and be granted a warrant?
5 to 10 minutes to
Yeah,
get one?
Yeah. Could an officer have one in about 5 or 10 minutes if they requested one?
Like a warrant to get a tracking device placed on a vehicle?
Just any warrant?
I've never gotten a warrant in 5 to 10 minutes, no, sir.
Okay, how long does a warrant take to get?
Yeah, so it just depends on what I'm writing the warrant for, so it just depends on what my probable cause is, how long it takes me to type it.
Okay. What's the
type pretty
quickest you've gotten a
quickly.
warrant, or could get a warrant?
Understand I came from West Texas, so sometimes finding a judge maybe added some time to that. So probably the fastest I ever got a warrant, start to finish, probably just a little over 2 hours.
Okay, copy that. My brother's currently law enforcement. He says 5 to 10 minutes they can have a warrant if they need it. And so I guess I'm just publicly stating the 72-hour thing kind of bothers me. Like 1 hour might make sense or something like that. I just have a hard time with giving a person, what is that, 3 days? Is that what that comes out to, 3 days? Yeah, to do that. So, okay, thank you for your answers. Appreciate it.
Yes, sir.
Okay. Thank you for being here. We appreciate it.
Thank you.
Nick Hudson?
Chair, members, thanks for the opportunity to testify. My name is Nick Hudson. I'm here with the ACLU of Texas, testifying against HB 2178 as drafted. But Representative Harless, your staff has spoken with us about this, and we would love to work with you all on it to make some changes, and I think could cure some of our concerns. The U.S. Supreme Court has held that vehicle-mounted GPS tracking devices are an intrusive form of surveillance that can amount to a search under the Fourth Amendment. And our concern is that the bill appears to be drafted in a way that likely violates the Fourth Amendment. I'd like to just offer a brief idea of what some acceptable use cases are and how to maybe make some changes that might address those concerns. I'd also like to say, I'd like to offer attorneys who specialize in this area. I'm going to do my best to convey their thoughts on this sort of thing. So we've heard in the hearing about a new GPS tracking technology that allows police to shoot at a car, a GPS tracking device while they're pursuing it. It shoots out of the front-mounted device on the front of their grille, and it sticks to the car being pursued and allows the police to track the vehicle while they are in pursuit. We don't necessarily see a problem with that if it is happening in the course of a pursuit, provided there are certain protections. So, for example, Representative Lowell, you brought up any data collected from the GPS tracking device that's not immediately related to the pursuit, we think should be deleted and not used in any sort of prosecution. It should be in the heat of the chase, and the officer should, and I think this is in the bill, but should not have time to have sought the warrant. We also would like to see that tracking ends as soon as the officer catches up to the person being pursued, and that officers need to pursue continuously so that you don't have this 72 hours of just a GPS tracking device. We think that that may run afoul of the Fourth Amendment. 2178 doesn't have a limit to those sorts of circumstances, and we think that use of GPS tracking and movement outside of the heat of a chase requires a warrant. I see my time is up, but I'm
Okay.
happy to.
Any questions, members? Okay. Thank you for being here.
Thanks.
Oh, could you, let me ask you one thing. I don't know if you may have said it, but you're against the bill, correct?
Yes, sir.
Okay.
Thank you.
And on behalf of ACLU Texas, right?
Yes, sir.
Okay, thanks.
Thanks,
And Chris Harris, Chris is still not here, so we will show Chris Harris against the bill but not testifying. Is there anyone else here to testify for or against or on House Bill 2178? If not, Mr. Harless, give you the right to close.
Thank you, Mr. Chairman. I appreciate the thoughtful discussion, and I respectfully close and ask for favorable consideration.
Okay. So if there's no objection, the chair will leave House Bill 2178 pending.
Thank you.
Thank you, Mr. Harless. Ms. Hernandez, do you want to come up? The chair lays out House Bill 2229, recognizes Representative Hernandez.
Making me nervous.
Slowly but surely. Get here. Good evening, Mr. Chairman and members. House Bill 2229 streamlines the expunction process for individuals acquitted in statutory county courts, eliminating unnecessary delays and financial burdens for those seeking to clear their records. Currently, individuals whose cases have been heard in statutory county courts must petition district courts for expunction, adding legal hurdles that prolong the process and increase costs. This bill addresses this inefficiency by allowing statutory county courts to grant expunctions for cases within their jurisdiction. This bill aligns statutory county courts with district, justice, and municipal courts, which already have the authority to process expunction petitions. Expanding this ensures a consistent and fair approach across the judicial system. Criminal records can have long-term consequences affecting employment, housing, and personal opportunities. This bill ensures that those who have been acquitted can move forward with their lives without unnecessary legal obstacles. This simple change would create a more efficient criminal justice system by allowing individuals who have proven their innocence to clear their records in a timely manner and without undue hardship. Be happy to answer any questions and respectfully
Any questions for
reserve
Ms.
the right to
Hernandez?
close.
Ms. Jones?
I just got one quick question, Rep. Hernandez. So you're saying that the statutory county courts are the only courts that can't, for the most part, process their own expunctions?
That is correct.
Okay, thank you.
Okay, anything else? Not, we'll go ahead and, we got a witness, so we'll call the witness. Chair calls Natasha Malik.
Hello, thank you Chairman Smithy and members of the committee. My name is Natasha Malik and I am a staff attorney with the Criminal Justice Project at Texas Appleseed. I am testifying for HB 2229. Over the interim, Texas Appleseed partnered with January Advisors to analyze the state's computerized history database. And what we found is that there are over 4 million Texans who are currently eligible for an expunction. 96% of those are for dismissals. Amongst all individuals eligible for record relief, The average length of time since one's arrest is over 15 years. The average length of time since they have been eligible is over 12 years, highlighting not only that many people don't know they're eligible for record relief, but also the process itself is not easy. Increasing expunction access through statutory county courts will have far-reaching positive effects on the individual and on the state. For one, employment plays a key role in the desistance of people with records. Work can assist reintegration efforts by promoting opportunities to practice pro-social behavior and create positive social connections, which in turn discourages criminal behavior. Additionally, the discretion to deny renting to people with any type of criminal record, even a simple misdemeanor or an arrest that led to no charge, leads to difficulty in finding a place to live. It can cause familial instability and even homelessness, which again is a predictive factor for criminal activity. Expanding access to expunctions will allow Texans to meet their basic needs and successfully reintegrate back into society, thus increasing public safety and boosting Texas's economy. Therefore, we ask you to please support HB 2229. Thank you for your time and consideration. I'm happy to take any questions.
Any questions, members? Okay, thank you
you.
for being here. Anyone else here to testify for, against, or on House Bill 2229? If not, Representative Hernandez, you want to close?
Close.
Okay. And so Representative Hernandez closes, and so if there's no objection, the chair will leave House Bill 2229 pending for now. Let's see, Representative Manuel, you want to come up? You ready? Okay, the chair lays out House Bill 1194 and recognizes Representative Manuel.
Thank you, Chairman Smithy and Vice Chair Wu. Thank you for the opportunity to present this bill today. HB 1194 seeks to extend the duration of magistrate orders for emergency protections, commonly known as MOEPs, by increasing each time frame by 30 days. Currently, MOEPs can be issued for 31, 61, or 91 days. But for many victims to violent crime, especially those experiencing family or domestic violence, 31 days is simply not enough time to recover resources and establish safety. This bill is about giving victims time to breathe and rebuild. Victims often flee with nothing, without any money, documents, housing, any longer. The reason we're asking for this additional 30 days is to give people time to secure their basic needs. Legal help takes time. Victims need more than a month to find representation, file for custody of divorce, and understand their rights, especially if they're starting from scratch. This bill doesn't change how MOEPs are issued, only how long they last. Judges still make the call, but now they'll be able to offer protection that actually matches the reality victims face. HB 1194 proposes a practical and consistent change. This bill would increase the minimum duration of all MOEPs from 31 days to 61 days. It would also adjust the remaining time frame for consistency. 31 days would now start at 61 days, 61 days would start at 91 days, and 91 days would go to 121 days. The first few weeks after leaving a violent situation are critical. This is when victims are at the greatest risk of retaliation. Many do not have a safety plan or legal guidance in place. Extending MOEPs gives law enforcement, legal aid groups, and community organizers more time to help protect victims and stabilize their lives. Very short, a small story of me growing up, and I have my mother's permission. When my stepfather and my mother were going through some not great times, my stepfather would follow us to our grandmother's house, wait for my mother to go to work, and then go in the house and tell my grandmother, oh no, they're just coming back home. So he would unpack everything we packed. This was also in between times where one time she was at work, it was 3 a.m, and we were 7 or 8, and we thought, oh great, we get to see our mom. And we're out like we're adults. And what had happened was he had gone to the jail phone and said, let me talk to my wife. And he said, come outside. If you don't, I'm gonna kill Christian, I'm gonna kill Farron. This is just a small example of what men, women, children go through in these kind of domestic violence situations. Yes, we want to save families, but sometimes people are not right and are not meant for each other. And there are people who are seriously harmed every day while we've been in committee people who have been stalked, people who cannot hide from their abusers. I'm also going to give a story. I have permission. My chief of staff for 10 years, she did this kind of work. She had one person who had been looking for a place to stay because her husband had been looking at child pornography and beating the living crap out of her. And when she finally was able to get away, she threw out all of her devices, and they kept hearing this truck, and they didn't know what that was, and they found out he had been tracking her through her Apple Watch. When an abuser wants to find someone, he does it, or she does it. And more importantly, because we don't have enough shelters, sometimes they do have to turn people away because there isn't a place for them there. And those people end up back on the streets, and it takes an average of 7 times currently for someone in domestic violence to leave. 7 times for them to permanently leave, and that's if they don't have any physical damage. And lastly, I'm going to say to everyone here, imagine yourself being in an abusive relationship, you have children, you get put out of the home because you flee without anything, and in 30 days, someone tells you, you have to find a new place to work, you have to make sure that the kids are going to school, you have to make sure that the father or the mother, whoever's not going to try to kidnap those kids, you have to secure a safe place for them to live because that could be used against you in a divorce proceedings. And you're not even thinking about the mental health impact of it. And you're not thinking about if this person has a job or if they do not have a job. And if there are any questions for me, I would love to answer them. I know we have some witnesses, but if not, I would reserve the right to close.
Certainly. Any Ms. Jones has a question, I think.
So, Rep. Manuel, are you familiar with the cycle of abuse?
Unfortunately, yes.
Okay, so let me just say this, as a survivor of domestic violence, what the statistics show is it takes 7 times for the average.
But it's more.
What, if it's gone up since, anyway, it takes at least 7 times to try to leave, right? And I can remember one time my mother actually called 911 when my ex-husband was, at the time he wasn't my ex-husband, was strangling me, and had my son not been on the phone with my mother, I may very well be dead. But thank God I'm not. But anyway, when he got locked up, he called me.
To come get him out.
He called me from jail with a collect call. It's funny now, but it really isn't funny. Maybe I'm laughing because I'm nervous, but here's the deal. The cycle of abuse, you actually love your abuser.
Mm-hmm.
And I don't always think you're in the best state of mind immediately after it because they do the honeymoon phase. They tell you whatever it is they think they need to say to get you to back off. And so to give the person who's abused time to process what happened, where the person can't contact her and where the person can't, or him, where the person can't get somebody to contact you to do the very things that you talk about, I think might be a good deal because there's a cycle that this might be helpful in helping you get situated like you said. But I just wanted to bring up the cycle of abuse. And I would ask everybody here, and I don't know if your resource witnesses are going to talk about the cycle of abuse, nor do I know if they're going to talk about the power and control wheel, which will help you understand why forced distance is important in these situations. So thank you.
Thank you. Thank you, and also we'll call the witnesses. We have Jennifer Mudge.
Hi, everyone. My name's Jen Mudge. I'm a public policy manager with the Texas Council on Family Violence. We're the statewide coalition of family violence programs here in Texas and in all of your districts.
And so you're testifying in favor of the bill?
And I am
Okay.
testifying in strong support of HB 1194. Thank you all for the opportunity to speak, and thank you, Rep. Manuel, for this bill. I won't belabor some of the points that Rep. Manuel already talked about, but we do believe this bill has a really powerful but simple safety change And by extending the period of MOEPs, the criminal justice system really does begin to better reflect the ongoing needs and reality of survivors. Like Rep. Manuel mentioned, oftentimes after an arrest and a MOEP is put in place, survivors do need time. They need time to safety plan. They need time to get connected with that local family violence center if that's what they choose to do. They need time to secure housing. That takes quite a while, or to work with their landlord to utilize lease termination statutes. Maybe they need medical care. And maybe they need counseling to kind of process what's happening before they can even think about next steps. So there's a lot of other things that survivors might need time for as well. Giving this extra time really provides that support and takes the pressure off of the survivor to make these really important but really emotionally difficult decisions. And it gives them time to seek out what they need without the fear of the order expiring and that hanging over their head before they could even get their bearings. I think the bill also really acknowledges the impact of trauma, and that survivors needed a little time, and that can take many years, of course, but need that as much time initially to process what's happened. So ultimately, giving this additional protection could be the difference between a survivor staying safe and them having to return to an abusive partner and potentially be re-victimized.
Good. So let me see if there's any questions. Any questions, members? Okay. Appreciate you being here.
And I'm happy if y'all have questions about power control or cycle of abuse, I'm happy to answer that. But I know we've also been here quite a while. So.
Okay, thank you.
Thank you.
We have Terry Saunders. Terry Saunders still here? Okay, thank you.
Good evening. My name's Terry Saunders, and I am in favor of HB 1194.
And you're testifying on behalf of yourself,
And I
correct?
am.
Okay.
Yes. I am a resident of Lockhart, Texas, currently, and I stand before you today to address an urgent issue that not only affects me, but countless other women in Texas in need of extending the amount of time for these emergency protection orders. I myself am a survivor of domestic violence. I was married for 10 years and still am trying to get a divorce. And my life has been turned upside down, still trying to get a protective order. So I'm standing here today and trying to be proactive, and hopefully when I do get that protective order, it will be extended for me. Just give me a little bit of time, sorry. During this time, my life has been turned upside down. I have had to change jobs. I've also had to move 3 times in the last year. I have also had about 5 different phones, including the paid by month burner type phones. I just used these type of phones during extenuating circumstances like today. I have been tracked through my iCloud by my husband, and I finally got him off this past November. I had to see him for our daughter's birthday party, and even though it was at the skating rink, he was able to put an AirPod in my bag, and the police say it takes over 6 months just to be able to figure out who it belongs to. Excuse me. Just this past month, I found out that he's now in my Google account, and he can see everything again, just like he did with my iCloud. He can see my locations, private photos, videos, my calendar, so he knows exactly where I'm going to be.
So this bill, you think, would, by getting an order, a protective order, would be able to protect you from the intrusion?
If I finally get this protective order,
Okay.
I believe that this will help by providing necessary protections for victims in need during critical periods when offenders, including my husband, may retaliate or escalate their behavior.
Okay, let's see if there's any questions, members. Anybody have any questions? Okay. Yes, Ms. Okay. Ms. Jones?
I'll speak with you offline. I can refer you somewhere that actually does divorces for people in your situation and get protective orders.
Yeah, you need to get help, you know, on that. So, Ms. Bowers?
Thank you, Chairman Smithy, and thank you, Ms. Saunders, for your testimony and for your strength and courage in standing here, sharing your story and your experiences. You know, our hearts go out to you. I speak for my female colleagues. We're all victims of domestic violence, and so I just, you know, how long did you say you've been trying to get a divorce?
A year and a half, and when I moved to Caldwell County, they don't believe that they have enough evidence, even though I have him even recorded saying that he's doing it, because we're still married. That's their belief, and I don't think that's right.
And thank you for that. That was one of the other questions that I had. How much of your story were they believing? That's because you are still married, and I won't belabor the point, but I did want to know, you know, you said about a year, so how long has it taken you to get a protective order? You still don't have it, correct? Okay.
Well, we're
Thank
incredibly sorry what you've been through and what you're still going through, and if there's anything we can do, you know, as a committee to try to help you, and there's a lot of other people in your same situation, so.
Thank you.
Thanks, so. Anything else? Okay, thank you for being here, ma'am. We have J.R. Wally. Woolley?
Woolley,
Okay, sorry.
like the booger or the mammoth.
Okay, so appreciate you being here.
Good evening, Chairman and members. I'm Judge Woolley. I'm the Justice of Peace in Waller County. I'm also the second Vice President of the Justice of Peace and Constables Association. I want to be clear, like Ms. Saunders was just saying, this bill affects the time period for a magistrate's emergency order protection.
Let me get you to say your position on the bill.
For the bill.
For the bill, okay, yes, sir.
This is at magistration after an arrest. Okay, so you're looking at charges right then. The regular protective order that Ms. Saunders is seeking happens in the higher court. This covers that period until that can get taken care of in a higher court. We all know the backlog from COVID's a real thing still. That time period is growing to get those other protective order hearings heard. So this time frame, extending these time frames on these emergency orders helps make sure that there's protection all the way through, from the time of the arrest until the next protective order, more permanent protective order can be taken care of.
Okay.
And as probably the only person in this room that actually issues those, I'm sorry, Judge Powell's in here too, but the two of us are probably the only people in this room that issue these orders. So if you have any questions, I'd be more than happy to answer them.
Okay, any questions, members? Well, I think we appreciate you taking the time to be here, Judge. And
absolutely.
Thank you for your efforts on this. Is there anyone else here to testify for, against, or on House Bill 1194? If not, Representative Manuel, you want to close? I understand you hurt your foot.
Sprained it, and I can barely walk.
Okay, well, I'm sorry.
But I think most importantly, we cannot have healthy families if people are being abused and children are seeing abuse or experience abuse in any forms. I thank you all, and unless you have any questions for me. Last time also, by the way, this did pass this committee without any problems. Of course, it's just time constraints, and it got pretty much stuck in between the Senate and the House stuff. I would greatly appreciate that, and I know so many people would appreciate
Well,
that.
Ms. Saunders, right? The story that she told is really compelling, I think.
We are going to make sure that all of the groups that we work with before we leave tonight,
Okay.
that she's
I
in
mean,
contact with
sure,
them.
the
And we've also
testimony,
been,
I
with
think
the
your
probation
testimony really
officers.
made a difference with the committee members, and we just appreciate the fact that you came up here to do this. Thank you. Mr. Verdell has.
Thank you, Chairman. I just want to say thanks for bringing a good bill forward. Appreciate it.
Thank you so much. Thank you all very much for your time and for your consideration.
Okay, thank you very much. Okay, if there's no objection, we'll leave House Bill 1194 pending, and we'll work on getting that done. So, let's see, Ms. Bowers, are you ready? Okay. Ms. Bowers has some witnesses that need to get back, so the chair would lay out House Bill 2492 and recognize Representative Bowers.
Thank you, Mr. Chairman and members. I do think this is a simple bill. It won't take us that long, and I feel like it's probably a good segue from Representative Manuel's bill. Thank you again for allowing me to lay out House Bill 2492. This legislation was developed in response to the countless stories we've heard from survivors, law enforcement, and advocates. It addresses a real and immediate vulnerability in our current approach to family violence, establishing a cooling off period for repeat domestic abuse offenders. House Bill 2492 makes critical revisions to Article 17.291 of the Code of Criminal Procedure by changing language from may to shall in high-risk family violence cases where a person has previously been arrested for family violence. A magistrate can direct them to be held up to 48 hours for a cooling-off period. Currently, if a magistrate decides a person needs to be held, the authority holding them can decide to release them contrary to the order from the magistrate. This often does not give victims enough time to make additional plans, as we were just discussing, or the person arrested for domestic violence the time to cool off. Often when they are released without this period, they return home and commit additional violence. House Bill 2492 is a needed change so that the orders of magistrates are carried out and victims of domestic violence can be protected. Members, I have a committee sub. Currently, the wrong may to shall is changed.
So do you have has it been distributed yet, or are you working on it?
The committee sub will change. I do believe that you all have it.
Hold on, let me make sure. It hadn't been distributed, so if you talk mainly about the bill, but you can tell us the subs coming. I just don't want to endanger your
So
bill.
the committee sub will be forthcoming, and I don't talk about it. It does say the sub is in drafting.
Okay.
The sub is in drafting, and I will get it to the committee as soon as possible.
I assume the sub is to deal with some issues that you've identified.
It's because the wrong made a shall.
Okay.
But domestic violence is rarely an isolated incident. Studies show that it tends to escalate over time, and the most dangerous period for a survivor is immediately following an arrest. According to the Texas Council on Family Violence, over 70% of domestic violence homicides occur shortly after a separation, arrest, or protective order. In 2022 alone, more than 200 women in Texas were killed by intimate partners, and behind each of those numbers is a story that didn't need to end in tragedy. House Bill 2492 is designed to prevent the next one. I do have some witnesses here, and if they will come up at your calling, sir.
Well, is there anyone
I
you
will
want to
go
call
ahead and-
first? Or, okay.
Yes, Judge Powell.
Okay.
And so I will respectfully reserve the right to close.
Okay, thank you very much.
Thank you.
Any questions, though, before we go? Okay, we'll move on to the witnesses. Chair calls Judge Jim Powell.
Yes, I'm Jim Powell. I'm here representing myself, and I support this bill 2492. I am a justice of the peace, a magistrate, and a coroner in Matagorda County, Texas. And I've sat through 8 or 10 hours of testimony on all these bills, and just every discussion affects something I do on a daily manner. So I'm intrigued. I admire the committee's stamina to put in these hours. In the 6 years that I've been at JP, I don't know how many people I've magistrated, probably 300 or 400, but I've issued over 40 magistrates' emergency protective orders to protect the victim of family violence. And I'd like to try to explain the anatomy of family violence offense. Typically, there is an incident in the home that is observed by a family member, a neighbor, or a friend that triggers a call to 911 dispatch to request law enforcement assistance. The law enforcement officer arrives at the scene, usually after dark, and observes the front door is closed. He or she does not know what to expect when knocking on the door. After interviewing the victim and observing him or her for any signs of injury, he interviews the offender and any witnesses present. Based on his or her experience in family violence cases, the officer makes a warrantless or on-view arrest, and the accused is taken to jail. Following the booking intake at the jail, the accused is presented to a magistrate. The magistrate is to review the officer's complaint to determine probable cause existed for the arrest. Following that, he'll conduct the 1517 admonishment hearing where you read the defendant his rights. You commit the arrestee to jail. You set a bond amount. You also set an order for conditions of release on bond. And in cases of family violence, the statute requires in 90% of them that we issue an order for emergency protection. And on rare occasions, issue a written order for further detention of the defendant. Now, personally, during magistration of these 40-plus emergency protective orders, only 4 times has the accused said or done something that has led me to believe that the violence will continue if the accused is released from jail immediately after posting bond. On these 4 occasions, to further protect the victim and to allow a cooling off period, I have issued a written order for further detention of the defendant to the jailer of Matagorda County under Article 17291 of the Code of Criminal Procedure. On each of these 4 occasions, the jail captain, who has no law enforcement experience dealing with family violence, has not read the officer's complaint, is not the magistrate who observed and interacted with the inmate, but he makes the decision to ignore the written order of further detention because it will cost the jail budget $45 for every 24 hours that this defendant is held. The current language in 17291B gives the jail this option because of the word may instead of the word shall.
And so you think this bill would fix that?
I think it will,
Okay,
yes, sir.
okay.
And to kind of dovetail into the previous bill, which was the EPO, because they're related, I respectfully request that you make this word change in the appropriate places to remove the option from the jailer to make that decision when the magistrate is the one and the law enforcement officer who has the most experience. And then I want to emphasize that an emergency protective order is only good for 60 days, 91 days currently, and it's just a piece of paper. The 4 guys that I wanted to hold for a while longer, I knew they were angry enough that they were going to go home, whether they had a protective order or not, going to beat the girl again.
Okay.
So,
Okay, we appreciate it. Let me see if there's any questions. Anybody have anything? So I think we get it. I think, that you've got to, you can't just release in those situations.
the cycle of violence that she brings up, I'm well aware of it.
We've got
and
people
it
in
is.
real danger, yeah.
And you watch these victims be brutalized, and each time is worse than the prior time.
Well, thank you, Judge, for being
Thank you.
here. We have Judge J.R. Woolley again. Now, I've got a question for you. How do you spell your last name?
WOOLLEY.
Okay, I think on the
WOOLL.
I think on the previous bill, it was just one O, WOLLEY. And so can the clerk have permission to correct
Please.
to the correct spelling
Absolutely.
on both bills? Okay. I'm sorry.
I might not have had my glasses on when I filled that one out.
Well, that's not unusual to have a doing that to type in the misspelling. So go ahead. I'm sorry. I didn't mean to interrupt you.
You're fine.
But if you would state your name again.
Judge J.R. Woolley, I'm the Justice of Peace, Precinct 2 in Waller County, the Second Vice President of Justice of Peace and Constable Association. I'm testifying in support of this bill. A couple things I want to point out in addition to Judge Powell's testimony. There are several states already that have these cooling off periods in statute. North Carolina has a 48-hour mandatory that is actually done prior to probable cause finding even taking place. So the arrest, a 48-hour period, and then they find probable cause. That's not what we're doing in Texas. We're going to find probable cause and then enact this period. California has it the way it's basically the way it's written here, and Tennessee has a 12-hour cooling off period. So this is not an unheard of thing across the United States. As everyone said, it protects the victims. It is, as Judge Powell alluded to, right now that the may allows the person that's detaining the individual, and I want to be clear, there is some very specific findings. In order to put this in place, they have to have had a prior arrest for family violence in the last 10 years, or they have to have had, if they've had a deadly weapon finding on an offense, then it can be 48 currently. Up to 48 hours. This changes, I believe what's going to happen with it is that it's going to change that may to a shall. So as Judge Powell said, if we have the information as the magistrate, we've looked at their criminal history, we see this is not a first-time offense that's maybe not that bad. This is somebody who is repeatedly doing family violence. Let's give them that. Let's give us that option to make that happen, and not give the person detaining them the option to ignore a court order.
Okay. Thank you, Judge. Any questions, members? Okay. Oh, I need to confirm though that you're testifying on behalf of the Justice of the Peace and Constables Association and yourself.
Correct.
Correct. Okay. Thank you, sir. Okay. We have Michael Orozco. Orozco. Thank you for waiting.
Oh, no problem. Thank you. Thank you for having me. Well, good evening, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Constable Michael Orozco, and I'm one of the 5 elected constables serving in Dallas County. Also, I'm here on behalf of the Justice of the Peace and Constables Association and myself in favor of HB 2492. I began my career as a deputy constable in 1997, and over the years I've delivered countless protective orders. In Dallas County, constables are the designated agency responsible for serving all protective orders issued by the courts. This is a responsibility I take very seriously, and one I'm deeply passionate about. Why is that? Because we don't just serve the protective order, we read every protective order in full. We need to understand who we're dealing with, the context, the allegations, and the level of risk involved before we ever knock on the door. I've read thousands of affidavits detailing heartbreaking allegations, and each one fuels my commitment to protecting victims of domestic violence. This moment feels like deja vu. I stood before another committee 2 years ago to testify before the House and Senate committees in support of a bill introduced by Representative Vicki Goodwin and Senator Carol Alvarado. That legislation aimed to ensure that remedies already available in law would actually be known and used. This legislature ultimately passed the Senate version of the bill, which took effect immediately upon the governor's signature. And that's exactly why I'm here today. We know we now have another critical opportunity to help close the gap in protection for victims of domestic violence. Texas must give survivors that time they need to escape dangerous situations. The proposed bill would give magistrates the authority to detain family violence offenders for a period of up to 48 hours after bond has been posted
for repeat offenders. This creates a vital window of safety, time victims can use to relocate, to plan, and to begin healing. Thanks to the continued leadership of Representative Bowers, Texas is once again in a position to champion meaningful life-saving reform. And I'm open to any questions you may have. Thank you so much.
Thank you again for being here and for waiting. Any questions, members? Okay, thank you very much.
Thank you.
Do we have anyone else here to testify for, against, or on House Bill 2492? If not, Ms. Bowers, are you ready to close? And I will point out, we had no one even register in opposition to the bill.
Thank you. Thank you, Mr. Chairman, and thank you again for the opportunity. I know it's getting late, but as a reminder to our fellow committee members, I just want to say that this holding period is not automatic. You know, it must be based on a magistrate's written determination that continued violence is likely and that the offender has a qualifying history, including prior arrests for family violence or violent offenses involving a deadly weapon. So you have heard from magistrates, county officials, and law enforcement today, and I want to be clear that House Bill 2492 gives more than a consistent and enforceable framework for responding to family violence cases. These holds are critical. They give survivors time to relocate, secure emergency shelter, file a protective order, as we've heard before, or work with victim services. Without this time, many are left completely vulnerable to retaliation. And with that, I close.
Okay, any questions for Ms. Bowers? Okay, thank you very much. And you said a substitute will be
That is in
forthcoming.
draft. Yes,
Okay,
sir.
we'll get that to us and we'll.
As soon as possible.
Okay.
Yes. Thank
If
you.
there's no objection, members, the chair will leave House Bill 2492 pending. Mr. Louderback, are you ready on yours? Okay, you're going to lay, okay. So the chair would the chair would recognize Representative Louderback to lay out and explain House Bill 3602.
Thank you, Chairman Smithy, Chairman Wu, members of the committee. I'm going to bring you a bill that's has previously outlined today. Rep. Curry brought 2984 before the committee, and this bill kind of builds on that, and it has to do with blood specimen. So, Article 18, the Code of Criminal Procedure, allows judges to issue warrants for a blood specimen of persons accused of intoxication offenses such as intoxication assault and intoxication manslaughter. The current code allows these search warrants to be executed in any county adjacent to the county in which the warrant was issued, only by the officer with arresting jurisdiction. Several law enforcement agencies in our state enter into contracts with adjacent counties for jail services. This scenario creates logistical issues for blood specimen collections. This bill was brought to me by the Addison Police Department, of which I have T.J. Smelter back here, who stayed with us all day today, in Dallas County, but they contract for jail services in Tarrant County. So currently, officers in cities like Addison must first, upon arrest, transport the suspect to the jail in Tarrant County. If a suspect refuses to provide a sample, the arresting officer must drive back to Dallas County to draft the arrest warrant, then drive to a Dallas magistrate to obtain the warrant. Once the warrant is obtained, the officer must then retrieve the suspect from the jail and transport them back to the officer's home county to collect the specimen. Finally, they must transport the suspect back to the adjacent county's jail. This procedural mess takes an incredible amount of time. House Bill 3602 seeks to keep these officers on the street and clean up this process by allowing any peace officer to execute a warrant for a blood specimen regardless of arresting jurisdiction. That's in Article 18067, Code of Criminal Procedure. That, ladies and gentlemen, lays out the bill, House Bill 3602. I do have one witness here that can, from Addison in Dallas County, who can answer the questions about it.
Okay.
So the right to close.
Any questions for Mr. Louderback? Okay, we'll call T.J. Smetzer. And Chief, we appreciate you being here, and more than that, we appreciate you waiting around. I'm
Yes, sir.
sorry that you had to wait as long as you did.
No, it's okay, sir. This is important to us, so happy to be here for this. Thank you, Representative Louderback, for filing this bill, Chairman Smithy for holding this hearing. My name is TJ Smetzer. I'm an Assistant Chief with the Addison Police Department, and I'm for this bill. The Addison Police Department does not currently have our own city jail. Instead, we contract with a city in northern Tarrant County to provide jail services, while Addison is completely within Dallas County. Whenever we arrest someone for DWI, if they don't consent to providing a blood specimen, we first have to transport them to the jail in northern Tarrant County, book them in, type up the blood warrant, and then drive the arrested person back to Dallas County to actually execute the warrant. As you know, in a DWI, time is of the essence, and obtaining the blood evidence as quickly as possible is crucial. We spend at least an extra 30 minutes driving because we currently cannot execute blood warrants outside of Dallas County. This very small change in the law will allow us to execute blood warrants in neighboring counties, and I'm happy to answer any questions.
Any questions for Ms. Smith? Yes, Ms. Jones?
Quick question, how many, when Rep. Louderback laid it out, I think he said that you can't do a blood warrant unless you're in an adjacent county, is what I think I heard him say.
So
how many counties are you guys over?
there's at least 5-6 counties that are next to Dallas County. So what it says is you can execute the blood warrant in any of those neighboring counties, but only if you have arrest authority currently.
So you're wanting to, the second you know that they're not gonna give you a sample to be able to, for lack of a better, whatever, like stop where you are, do the warrant. Is that what you're asking to do?
No, ma'am. What we would do, if we arrest someone for DWI, we're going to ask them if they'll consent to providing a specimen. If they do, drive straight to the hospital, obtain that evidence. If they say no, we would drive to the jail in Tarrant County, book them in, type up that warrant, take them out of the jail, and then go to a hospital that's right across the street, instead of having to drive them all the way back to Dallas County.
Which was the home, was it that was Dallas County was the home, because you're in Dallas County?
Yes, ma'am.
The name of, I can't remember the name of your town.
Addison, yes, ma'am. Dallas
Okay,
County.
so you want to be able to draft it right there and take them somewhere, to hospital, wherever you are, to get it expeditiously?
Correct, yes, ma'am.
Okay, thank you.
Okay, anything else, members? Okay, we appreciate you being here.
Yes, sir. Thank you.
Thank you. We have, Chair calls Faith Bussey.
Good evening.
And we apologize to you for having.
That's okay. My name is Faith Bussey. I am testifying on behalf of myself against the bill. I'm going to start by saying something unpopular, but it is principled. I believe that forced blood draws are a complete violation of my God-given right to not self-incriminate, and they are a complete violation of the protections under the Fifth Amendment, which states a person shall not be compelled in any criminal case to be a witness against himself, which is where we get the right to remain silent. I believe that if government really wanted to solve the issue of DUIs and DWIs, they would remove every barrier that exists for ride shares and automated vehicles. That is the future, and it will be more effective than any conviction or punishment y'all can come up with. But I fully understand that that ship has sailed in the legislature, and that is not the conversation we're having. So, regarding this particular bill, it is removing the limitations on who can execute this very sensitive warrant. It opens up this authority to any peace officer. And week before last, I had to explain to 2 different committees in both chambers who all was included in the term licensed peace officer. So I want to make sure that this committee understands that any peace officer just does include licensed peace officers under TCOL, but it also includes school resource officers, a law enforcement agent of the Texas Alcoholic Beverage Commission, an officer commissioned by the Texas Facilities Commission, airport police, a security officer, or investigator commissioned as a peace officer by the comptroller, an investigator commissioned by the Texas Medical Board, an investigator employed by the Texas Racing Commission, pharmacy and pharmacist officers, an officer commissioned by the Board of Managers for multiple hospital districts, a security officer or investigator commissioned as a peace officer by the Texas Lottery Commission, an officer commissioned by the State Board of Dental Examiners. So these officers who will be given power under this bill are not all licensed by TCOL, do not have the same training on chain of custody, and do not answer to the public via a city council or county commissioner court. If a person has any issues, they can simply take it up with whatever random agencies or historically super transparent and pro-accountability hospital boards. That was sarcasm for the record. So I'll be opposed to this bill no matter what. But if the committee feels there's a problem that has to be solved, then this bill needs to be amended to narrowly tailor who can have this power. Thank
Okay.
you.
Well, thanks again for being here, and Ms. Jones has a question.
So I think that before there's a blood draw, they've got to get a warrant, right? So they've got to go to somebody, so it's not, and the officer has to give articulable facts of probable cause to get a warrant for that blood draw. So I don't think that this will stop that. I do have a question for the bill's author when it says by any peace officer, because I would hope that the officer who's trying to get the search warrant, wherever the officer gets the search warrant, is the officer that arrested the person and that saw whatever it is they thought was probable cause to get a search warrant, and can't call another officer and say, hey, say this to get a search warrant. So, but in order for a search warrant, law enforcement's got to give articulable facts.
Sure.
Right.
I would hope so.
All right. Okay. Thank you.
Mr. Cook has a question.
And I haven't had a chance to look it up, but I could tell you were very prepared on the difference between any peace officer and, are you just making a distinction between any peace officer and law enforcement officer?
Yes.
Literally those, that
Literally
phrase.
just that phrase.
Thank you.
Thanks.
Thank you. Is there anyone else here to testify for, against, or on House Bill 3602? If not, Representative Louderback, you may close.
Committee, this is a question of logistics. Representative Jones is absolutely correct that it takes a warrant, and this is a certified peace officer here in Texas, licensed by TCO, that is eligible to make arrests for a traffic offense such as DWI, for a blood draw to take effect. So this is part of law right now. We've been doing it for a very long time, but this is a logistical nightmare. Which is just not conducive to so much time spent on a DWI arrest when you're in that particular situation of contracting jail duty. In other words, your county says, I'm not going to go to Dallas County Jail. They don't have room for our prisoners, so Addison PD is going to Tarrant County Jail. So that's in essence all it is, just a time-saving move to try to get our officers back on the street and back to protecting the public. Go ahead.
Ms. Jones?
So I've got a question. You said jail duty. I guess the officer driving the person from wherever they're arrested to the jail they've contracted to. Is that the same person that arrested the person, or could that be somebody else?
No, more than likely, it's going to be the actual arresting officer. He's going to be transporting to the holding facility.
Right, as opposed to somebody else. They say, hey, go take them to jail, and then the officer who did the arresting, is the officer who does the arresting always the officer that's going to get the search warrant?
Very, very normal. It'd have to be an abnormal set of circumstances for that not to take place, but the arresting officer will take that person into custody and drive them to the facility.
So give me the abnormal, give me a situation where where a non-arresting officer is trying to get a search warrant.
Well, another emergency that happened, maybe call another unit, maybe have a specialized operations person there that was almost run over by a DWI driver, suspected of DWI, made the traffic stop, called someplace else. These would be very abnormal situations. They're very rare situations. The typical situation that you're running into for a law enforcement agency on patrol that comes across a DWI suspect and goes through the field sobriety and makes the arrest is going to be transporting.
And the part in your bill where it says, any peace officer, what is that? You heard the lady who came before you came to close, who tried to, I guess, differentiate between the different kinds of peace officers. This underlined part on page 1, line 12, by any peace officer. Again, my concern is substituting an officer in who didn't do the arrest to try to get the search warrant. This by any peace officer is not saying that. You're just saying wherever it is you find out that the person's not going to give you consent, then you can get the search warrant then and there.
That officer is that officer is going to be tasked with that. And that's his arrest. We catch, we clean. So that's going to be his. He's going to be tasked with that point. At that point to complete the process fully on that.
Okay. Just want to say what. So yes or no? The officer who's doing the arresting is the one, regardless of where they are within the counties, is going to be the one that's going to get the search warrant?
Yes.
Okay, thank you.
Okay. Anything else, members? Okay. If not, the chair will leave, if there's no objection, the chair will leave House Bill 3602 pending. Okay, thank you.
I close. Thank you. Respectfully.
The chair at this time would recognize Mr. Cook, who is going to lay out House Bill 2448 on behalf of Representative Moody.
Chairman, do you mind if I do it from here?
I think that's fine.
Perfect. Thank you, Chairman.
We have an
You got an
objection.
objection? She just wants me to move over there. So. Mr. Chairman, members, thanks for hearing House Bill 2448, which is Speaker Moody's bill. He doesn't really want to jinx this, but he says it's a simple bill. Once a criminal case gets to court, the very first thing that happens is an arraignment. It's basically a formality for two purposes. The first is to fix the defendant's identity. That's not a, quote, mistaken identity, close quote, defense kind of issue. It's basically, is the defendant's name correct on the charging instrument? The second part is entering a plea, which is always, quote, not guilty. Otherwise, it would be a plea hearing, not an arraignment. Once upon a time, that was all that was done live in court. Since it's entirely a formality, that was a tremendous waste of everyone's time. So in 2001, the law changed so that it could be done in writing, which is known as a waiver of arraignment. A waiver is written form that says the defendant is the person charged and they want to plead, quote, not guilty. When that's turned in, the case moves on to the first court setting. The issue is that some courts require a defendant to personally sign a waiver of arraignment even when they have an attorney. That can become a problem when a defendant is incarcerated, with the attorney often having to travel a great distance to get a signature, or the court having to get a defendant physically transported to the court in order to conduct the arraignment. In El Paso, for example, we have a jail annex far out in the county. So attorneys have to set aside several hours in a workday for a round trip just to hand a client a piece of paper to sign. House Bill 2448 ends that by simply saying that a defendant's attorney may sign a waiver of arraignment on their client's behalf. By signing, the attorney is simply saying, quote, my client is the person charged and they plead not guilty, close quote. Again, it's a formality, and this makes that process faster, easier, and more efficient for everyone involved. As I said, a simple bill, but I'm happy to answer any questions. He is. I'd like to also reserve the right to close when appropriate, and reserve right to close, and appreciate the opportunity to lay out this bill for Speaker Moody, House Bill 2448. Thank you, Mr. Chairman.
Okay. Any questions for Mr. Cook in place of Mr. Moody? Okay. And we have no witnesses who have registered, but let me ask, is there anyone here to testify for, against, or on House Bill 2448? If not, then you've got the right to close.
I close.
Okay.
Thank you,
Okay.
Mr. Chairman.
Mr. Cook closes. And so if there's no objection, the chair will leave House Bill 2448 pending for now. Members, we've come to the end of our bills. Is there any other business that we need to take up? Anybody aware of anything? If not, the Committee on Criminal Jurisprudence stands adjourned pending call of the chair. Thank you.